Can I just say something about Andrea?
Good morning, everybody. Good to see y'all bright and early. Hey, it's been a minute since we've done one of these 6 a.m. on the West Coast live streams. You know, every time I get into watching a trial live, it just really reminds me, you know, I need to move to Chile. I really need to move to Chile. The timing is so much better for the live stream schedule. It's 11 in the morning there right now. Like you can have a nice breakfast, go on a little walk, come back and watch the trial. Not so on the East Coast. Things are quiet at the moment, but the cats are about. So it is going to be possible that we might have to pause, deal with the insanity of the teenage cats should they decide they want to be all over me at any given moment. But so far we're safe. It's like I feel like I'm on eggshells all the time now with the cats at this age. Welcome. So just waiting for trial to get started so we can get the jury charge and the closing arguments. Case of Adrian Gonzales. Feel free to hit the poll on your way in. Let's take a look. So far it's been pretty overwhelmingly on the side of not guilty. Pretty overwhelmingly. I gotta say, you're not gonna get any disagreement from me. I've only just started to get my recaps out because frankly, I was expecting this trial to go a little bit longer. I had crossed my mind the state was maybe going to rest when the state rested. But we just had two very quick witnesses from the defense, get them done in an afternoon, and then that's that. And here we are. So I am a little bit behind in getting my recap out, but I did release my first review, kind of looking at things a little bit differently in this case than you might be used to with, you know, all the notes and the details and the things like that. Not doing it this way for this one. And a big part of the reason why is because the jury isn't going to do it that way. Caught my attention. First thing the judge says after the opening statements, jurors, you're not going to get to take your notes in the deliberation room. So feel free to keep taking them if it helps you focus. But don't count on them. They're not going to be a substitute for your memory. So I'm like, wow, they're not going to have the details, then they're just going to be relying on what lands, what impressions do they get, all of the ins and outs of 11:32:59 versus 11:29:30, like all of these things, don't really know if those are going to stick. I'm the kind of person that, you know, it's like the process of writing it down helps me remember. So I would be taking notes anyway in that courtroom, just in the hope that it's going to kind of help some of those important things. We have our first visitor. Help some of those important things kind of, you know, stick with me, but not going to be able to rely on it in the jury room. So it's a case based on impressions, and I mean, I can't argue with your guys' impressions. My impression is really the same. And there's a couple reasons for that. You know, there's always a fact side and a law side when you're looking at a trial and what the right outcome is going to be. On the fact side, for me, I think the biggest thing I have the hardest time getting past is the three officers at the corner. We keep hearing about that. That stuck with me. Mendoza, Saucedo, Coronado. I can hear Nico LaHood's voice in my head saying those names over and over again. They had the line of sight on the shooter. They had the rifle shot on the shooter. They saw the shooter go in the door. And they didn't do what the prosecution is saying that Adrian Gonzales should be criminally convicted for not doing. Just going straight into the building, going to the gunfire, engage, delay, and distract the shooter. They didn't do any of that. So why on earth is he at this kind of higher obligation when nobody seems to dispute that he's not in a position to have seen what was going on, to have the knowledge of what the situation really was that these other folks saw. So I mean, just that alone for me is kind of is just it's a problem. It's an impediment. When I looked at this case, like straight off, we looked at some of the case law in the first video that I did after the openings, to just kind of look at what are they going to have to prove here. I got a little bit more that we can look at while we're waiting for court to get started. But the bottom line was, kind of looks like they got to show what he knew. Okay, that he knew that there was a serious risk, okay, of imminent harm to these children, and that this wasn't just a bailout. This wasn't just somebody trying to get away from the police. This was somebody who is, literally going to threaten the children. But then also, what was he supposed to do differently that could have prevented this? And that really seems to be what the burden is. And there were a lot of problems. We never got a specific, here's how he should have, responded to this information that he's getting from Melody Flores, who seems, frantic and, I mean, understandably, but probably not really, calm and clear and concise and communicating real consistent information. How is he supposed to deal with her, keep himself safe, keep her safe, figure out where the shooting is coming from, approach the school, intercept the shooter, and stop the shooter, not die in the course of all of this? He's got that terrible corner to navigate. There's no cover over on this whole side of the building. The building itself is the only cover. And when he can't see the shooter, he doesn't know how close the shooter is to that corner that he's trying to walk towards. So you come out from the cover of your car, you take 10 steps, that shooter's right there at the corner. He comes around the corner. You're sitting duck now. You're just a target. And then same thing with going in that school door. Walk into the hallway, you don't know where the shooter is. He sees the door swing open, pow, pow. He's got a rifle, you got a handgun. Just really didn't get a clear picture of exactly what he's supposed to do and how it would have actually stopped the situation and not just gotten him killed. So I was real surprised, honestly, watching this trial, going through this trial, because the very first thing I said when we came in for the openings was like, oh, I'm not real optimistic after Parkland. And the reality is, I don't even really know a lot about Parkland either. I didn't watch that trial. I just kind of got details coming through, but I just have this very, negative feeling about it. And I understand and appreciate it's not fact-based. It's just there. And so, like, Peter Tragos had the lawyer from Parkland on, and the police officer who'd been charged, had them on his show for an interview. And it was a great show. I really enjoyed watching it, but I can't help, I still have this negative feeling about this police officer. Like, I feel kind of bad, because I know it's not like based on fact. It's just based on, that's my gut reaction. You feel like they should have been able to do something, and you feel like, well, these are police officers. That's their job, to put themselves in harm's way to keep the rest of us safe. If they're not going to do that, if they're not going to do that for kids, then what do we even have them for? Why do we give them this power? There's just all these like feeling-based reactions that I have. And watching this trial, I didn't start off particularly sympathetic to this guy. But they got me there. They really did. They really did. I'm not, it's a terrible, terrible thing that happened. It's a terrible situation. And I think there were so many failures on so many levels, but I'm just not really sure what he was supposed to do differently. So I got a couple of things to share with you while we wait. The first off, I do have the indictment that is going to be, it's going to be read. This is the charge. All of these 29 counts are basically the same thing. So we don't have to look at all of them. But there's a couple things in this that caught my attention that made me wonder if this is going to maybe be a little bit of a hang up for the jury. So all of these charges, they're going to have to find the grand jury for the County of Uvalde, State of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2024 of the 38th Judicial District for said county, and said state upon their oaths present in and to said court at said term. This is like such formalistic language. That Adrian Gonzales, hereafter styled the defendant, on or about the 24th day of May 2022, and before the presentment of this indictment, in the county and state aforesaid, as a peace officer for the Uvalde Consolidated Independent School District, by act and omission, intentionally, knowingly, recklessly, and with criminal negligence. There's an and there that might be important. It might not, but it might be. Placed Jose Manuel Flores Jr., a child younger than 15 years of age, in imminent danger of bodily injury, death, physical impairment, and mental impairment by engaging in one and more than one of the following acts and omissions. So these ands I'm already getting a little bit hung up on because I don't know that it's required to be an and. They don't have to prove all of these mental states under the statute. They just have to prove one of them. But when you put it as an and, that suggests everything. That is an inclusive term. It's not an alternative term like or is. You just say intentionally, knowingly, recklessly, or with criminal negligence. That's a different thing. And same thing with, it's usually one or more of the following acts, but one and more than one of the following acts. So they have to find this and something else, the indictment seems to say. If I'm a jury and I'm really hung up on doing my duty, fulfilling my responsibility to faithfully apply the law to the evidence that I've received and that I'm judging, I might struggle with figuring out what exactly this means and what it's going to require me to conclude, because it's really seeming to suggest I got to find one of these, or maybe both, or maybe one of these and something else. It's not real clear. After hearing gunshots and after being advised of the general location of the shooter and having time to respond to the shooter, the said Adrian Gonzales failed to engage, distract, or delay the shooter, and failed to attempt to engage, distract, and delay the shooter, and failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and room 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. So this first one seems to really be getting to that the first minute that he was on the scene, because that's the time that it took for the shooter to get into those rooms, to get into the school and start shooting. So during that first minute, what we heard from the evidence, he gets there, he drives up, he drives straight to Melody Flores, he's talking to Melody Flores, he's communicating that information on the radio, and the point when he is communicating that the guy is over there by the teacher's parking lot is literally the same moment that the guy is already going in the school. So Not entirely clear what he knew in that first minute. They described the OODA loop. We heard a lot about the OODA loop, how he would be getting oriented, observing, trying to make sense, trying to track the echo of the gunshots, trying to get clarity from Melody Flores, and also trying to communicate that to the fellow officers that are responding, because you also need to orient yourself to who else is going to be there and where are they and what are they doing, and how are we coordinating our approach here. So already this first action seems to be focusing on that first minute, and that seems like that is kind of a tough call. To me, it seems a lot easier once the shooter is in the school and, there's a lot of gunfire at that point. There's a lot of gunfire. Kind of a lot harder for me to kind of wrap my head around, well, you didn't know. I mean, you're going to know something real bad is happening. But there's a very serious danger. It doesn't necessarily mean you can do anything still at this point. But this whole first minute, I think they have a real problem, which is establishing what did he even know? What did he even know? B, after hearing gunshots and after being advised of the general location of the shooter and having time to respond to the shooter, the said Adrian Gonzales failed to follow, I didn't mean to say that, failed to follow and attempt to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. This one seems broader, just didn't follow his training until after the shooter shot at one or more of these children. Didn't get a real picture of what the training was, did we? And I remember when the guy who did the training testified, he's like, yeah, there's lots of ways to do it. My way is just kind of one way, the thing that I teach. And we had all the officers that testified, some of whom it was a little intolerable how willing they were to be like, oh, well, if I was there, I would have, like, you don't know, dude. You don't know. How many of these situations have you been to and had to deal with? It's one of the reasons I liked Adrian Gonzales's last witness, his expert, retired SWAT guy. I liked him so well because he had the humility to be like, I don't want to, it wouldn't be fair for me to try to, sit here and say what I would do. I've got different training. I've got a different base of experience. It's not fair to judge somebody in that situation if you haven't gone through it. And I think, from a cop, that's, it's so easy to sit and play a little film in your head where you're the hero of the story. But then there's real life and real danger. And what do you actually do? A lot of people think you're going to act differently in a situation until you end up in that situation. And then you learn. Then you learn who you really are and what you're really made of. And a whole lot of the officers, they were all over the place with what the training was. Some were like, yeah, you just got to run straight for the gunfire. But then others were like, you need to tactically approach, which makes sense. Yeah, you need to tactically approach. You don't just willy-nilly charge the machine gun nest. That's ridiculous. And the defense, I thought, did a very good job of simplifying this down to a dead cop is not helping anybody. If he just does something foolish and gets himself killed, that's not going to help anybody either. You got to be smart about how you encounter the situation. So failed to follow and attempt to follow his active shooter training. Not real clear to me that they made a good record that his training required him to do anything other than what he did. He focused on cover and concealment. He tried to orient, tried to coordinate, tried to pass the information along. And, had these tactical challenges that he was going to need to overcome in order to be able to intercept the shooter. And literally seconds to kind of try to figure out how to do that. And the said defendant did not voluntarily deliver the child named above to a designated emergency infant care provider under this section of the Family Code. Really didn't hear kind of anything about that. This seems like a bit of a throwaway. Remember the first crime scene guy who got on the scene? Testify, he got there an hour later. They hadn't even breached the classroom when this crime scene guy first gets there. And the first thing he runs into is the ambulance is blocked on its way in. There's cop cars blocking the streets and stuff, and the ambulance can't get in. Like, this whole situation, it just sounds so chaotic. They're blocking off the ambulance. There's 373, 376, I don't even remember the exact number, 370 some police officers on the scene. The SWAT team shows up. They didn't even bring their gear. The SWAT team shows up without their ballistic shield. You are the special weapons and tactics team. You literally are what you are because of your special weapons, and you just leave your special weapons behind when you're called out to respond to a school shooting, an active shooting? This is mind-blowing. They didn't have their ballistic shield. So now they got to twiddle their thumbs some more. They didn't have the keys. They had to figure out, how are we going to get in through this outward opening door? It just sounds like chaos. It really does. And they've got the, charges against the other cop as well, the commanding officer from the Uvalde Consolidated Independent School District Police. He seems to be maybe a little bit more responsible for that chaos than Adrian is. So, we'll see what happens here and what happens with that case as well. But it just really seems like they got some serious factual problems. Was it his fault that SWAT showed up without their shield? Was it his fault that they didn't have the proper kind of, tactical vests and things like that so that they could approach this shooter and not just be on a suicide mission? They had the vests that would protect them from the low velocity handgun fire, but not the high velocity rifle fire. And that's what they were facing. So they supposed to just all die, charge the guy? I mean, come out and say it, prosecutor. What were they supposed to do? And lay it out for me real clear, this movie that you're playing in your head about how this could have gone differently. I think part of the really hard things about this case is that at the end of the day, one of the biggest problems here was the locks. It was how soft this school was that it didn't need to be. It's designed to make it hard for the shooter to get in. But if you don't lock the doors that are supposed to be locked, then all of that's for naught. There's no resistance. There's no friction. He can just walk right in. And that's what he did. And I think the reason why that makes it so hard is because everybody in that building, everybody probably on the school property, suffered a lot that day. I mean, just had the most terrifying, horrible experience of their entire lives. It's hard to imagine what that would have been like. Just having to wait and hear what's going on, and you're not getting saved, and it feels like it's happening forever, and you have no idea if you're next. And everybody in the world is going to have empathy for that. So the idea that there's some responsibility for what happened on some of those people as well, it's hard to swallow. Sounds like victim blaming, doesn't it? Sounds like victim blaming. But I can understand why, for the folks who survived, it might be kind of important to find another source of blame, another source of responsibility, to deal with your own guilt and remorse over your choices that potentially put those children in danger. Because these people are already going to be dealing with so much guilt, so much remorse. This is the survivor's guilt is such a real thing. Why me? Why did I survive? Why did these other, these children didn't? Why did I? It's the most normal thing in the world to have that kind of experience. But to have that compounded with thoughts about what I should have done differently, I mean, it's an awful thing to have to contemplate. But it seems kind of hard to deny that had those rooms been locked the way they were supposed to, this situation, yeah, might have been different. Might have been real different. When we were listening to the charge conference yesterday, one of the things that Jason Goss raised, he said they're still contesting the duty issue. Just right off the bat, they're contesting duty, and there was litigation that they had in the trial court. And I went looking to see if I could find their litigation, and I can't. They don't seem to have a good like portal for public access for legal documents. So I don't know what that litigation was about, but he did mention this case. So I'm like, okay, I want to go look at this case, this Luther versus Texas Parks and Wildlife Department, because he's saying under this case, Adrian doesn't have a duty. He didn't have a duty to act. Okay, I looked at this case. So this is a civil case, and I think that is the main difference. That's what the prosecution argued. It doesn't apply. This is just a civil standard for civil liability. It doesn't preclude criminal liability from being imposed. This is a case where two young kids are like floating out in a lake on a mattress, an air mattress. They're warned by some game wardens, hey, you might want to get closer to shore. A little unclear about exactly what they said. You could drown, you could get hit by a boat or whatever. Boys say, okay, the wardens take off. Eventually they start making their way back to the shore. They get hit by a boat. Some of the boys get seriously injured. So they sue the wildlife district, claiming the game wardens should have escorted or guided them to shore, and that by not doing so, the wardens abandoned the boys to the very peril about which they were concerned. So arguing they abandoned them, basically left them here, failed to act, right? Failed to get them to a safe position. Didn't like put them in their boat. They had a motorboat. They had a prop boat. So maybe get them in the boat, take them to shore, something like that. Something they should have done differently. And so the warden argued, we don't have any duty here. There can't be any liability as a matter, excuse me, sweetie, as a matter of law. And ultimately, the court agreed with the wardens. There's all these statutes that provide different kinds of responsibilities, but ultimately they say they can't construe from the general language of these sections a specific duty on the part of law enforcement officers to provide life preservers to boaters who don't have them, or in the alternative to escort them safely to shore. The officer's duty is to promote water safety by enforcing the laws rather than by assuming the much greater burden of ensuring the safety of each individual boater with whom they come into contact. The police are not insurers of the safety of law violators. He doesn't have a whole lot of sympathy for these defendants, does he? So a couple things from this, they're looking at the duty very specifically. It isn't just a general duty. Do you have a duty to respond? Do you have a duty to keep something safe, to keep somebody safe? They're looking at specifically what were they supposed to do, which is the framework I've been looking at this with Adrian Gonzales. What specific duty did he have in this situation? What specifically was he supposed to do? Now, the other thing that came up was when I looked at the statute that they're charging him with, the child endangerment, it doesn't on its face say really anything about any duty. It just says, by act or omission, you allow a child to be endangered. It appears to be a general application that would apply to just about anybody. And so it's not based on, at least as I kind of understood it, any kind of specific duty that he had as a law enforcement officer. It's just as a person, as any person who obtains the knowledge in that situation that the children were in imminent risk had some kind of responsibility to prevent it. Which is a little unusual, but state laws can do that. State laws can impose whatever kind of responsibilities they want. Some encourage people to be good Samaritans. Some discourage people from being good Samaritans. So I'm just checking to see if they're in court yet. Not quite yet. So I did keep looking, though, and I found this other case. This case is Suarez versus State out of Texas. This is a child endangerment case. This woman, kid falls out of her car, and I guess she doesn't notice that the kid fell out of the car. Kid gets hit by another car, and the kid dies. So she's prosecuted for child endangerment, and they have this standard of review, this legal standard here that is, I thought, extremely helpful. A person commits the offense of endangering a child if she intentionally, knowingly, recklessly, or with criminal negligence. See, the statute says or, it doesn't say and. You gave yourself a higher burden by making that an and, but whatever. By act or omission engages in conduct that places a child younger than 15 years in imminent danger of death, bodily injury, or physical or mental impairment. This is the statute that we're dealing with against Adrian Gonzales. An offense under this section is a state jail felony. Look at this, though. 2022, Section 22.041 applies only to those who have custody, care, or control of the child victim, and it imposes a duty upon those responsible for children to refrain from unreasonably subjecting the child to danger. So the statute doesn't say anything about a duty, but the case law does. The case law seems to say it isn't just anybody in this situation. It's somebody who has custody, care, or control of the child victim. So a parent does, because parents have, legal responsibilities, duties to care for their children, and children will be taken away, and you can be found responsible if you don't satisfy that. A person who omits to perform an act does not commit an offense unless a law as defined by Section 1.07 provides that the omission is an offense or otherwise provides that he has a duty to perform an act. So there's got to be something in the statute that says he's got a duty to act. There's nothing alleged in the indictment. This came up in the instructions yesterday because the defense is saying, defense says first off, they didn't present any evidence of a duty. And the prosecution says it's fine because that's for the court to decide. And so the court can instruct them accordingly. So I have no idea what this basis is for the duty that the law enforcement officer has some control, care, custody of the children. He doesn't have custody of them. They haven't been left in his care. Control is an argument. He has control in that situation because he's the officer and he's got authority. I really don't know. So I'm going to be paying very close attention to the instructions to see if we get any more information about that. Because this appears to be just another hurdle that they have to clear. That watching the whole trial, yeah, there was no evidence about it, which I understand. If it's a duty as a matter of law, then it's really not for the jury to decide. But so it sounds like they litigated it pretrial, and ruling went against the defense. I'm very curious about it. Very curious about this motion, this litigation. It must have been something along the lines of a motion to dismiss, because if the judge gets to decide as a matter of law whether there's a duty, then he can decide as a matter of law there's no duty. And if there's no duty under this case, apparently there's no prosecution. So I have to imagine the state proffered some kind of legal basis to argue Adrian Gonzales, the responding police officer, had a duty, but I don't know what that arises from. I don't have any way to check that because I don't know. I don't know what the argument is that he had a duty here. So looks like they're a couple minutes behind. They always are getting court started in the morning. I do kind of keep wanting to go check. So the poll, we have over 500 votes now, and pretty much strongly on the side of not guilty here. I'm not expecting a fast verdict. I mean, everybody, I think, has a tendency to think when you feel pretty strongly about how a case is going to end up as far as the outcome, you have a kind of tendency to think, well, most people are going to agree. I mean, we have over 80% consensus in this poll that it's going to be a not guilty. And so there's just often kind of tendency to think, well, it's going to be easy for them to decide. But it rarely is. It rarely is. Well, sometimes. I finally just got finished with the Buried podcast that Bob LaMotta over at Defense Diaries did. And so the last episode is the state's closing argument and the jury verdict and so forth. And they deliberated for an hour, just over an hour. It was, the trial was weeks long. There was 30 plus victims, 30 plus people that were found in the crawl space. No real dispute about did he do it? Just a question of, is he legally insane or not? Didn't take him long to figure that one out. Bob made the comment in the show that when it takes an hour to deliberate, it's because they didn't deliberate. They didn't deliberate about anything. They didn't have to. They were already in consensus about what the outcome was, and didn't have to discuss anything. I don't expect that in this case. This is not a case where somebody found, 30 corpses in your crawl space. This is nowhere near as cut and dry. 80% on the jury means one or two, maybe three people that are thinking he might be guilty. You have a little bit of psychological, I don't want to say pressure, but because it's not like an external pressure thing, but just jurors want to be respectful. And if you come back with a super fast verdict in a case like this, say everybody is kind of like we are by and large in the chat, in the poll, general consensus, strong consensus, they didn't prove it. He's not guilty. It doesn't necessarily mean you want to just go take your vote and then come back like instantly. It tends to make it look like you didn't have to work very hard. You didn't have to think too hard about it. You maybe didn't give it all of the attention. You didn't really focus on the details. They spent a lot of time focused on the details of this case, right? That timeline was very important to both sides. State had their version of the timeline. Defense had their version of the timeline. This all still has to be evaluated from the standard of what Adrian Gonzales knew at the time. And so in a way that the timeline was, it was almost a little bit of a distraction because this is with the luxury of the hindsight, being able to go back and look after the fact. What do we know now? We kind of know now how to put all of the pieces together and what was coming over the radio and who was where when, at least generally. But at the time, it's just a fog. It's a lot of noise and a lot of chatter and the tunnel vision and the stress and the, focusing your attention on this and maybe not necessarily picking up some of the other information that's going around. So in many ways, the timeline is like, it's kind of cheating. It's important though. I mean, it is important to the case. But it's not like Adrian Gonzales knew what the timeline was. Oh, kitty. Hang on a sec. It's not like Adrian Gonzales knew what the timeline was while this is happening. But it is, it is important. Those details are important. And so the jury is going to want to show that it took this seriously. That it did pay attention. It did care about the details. It did deliberate about the details. Not expecting a fast verdict on this one, even if the jury, initial poll is essentially the same thing as ours here on the channel. Guys, give me half a second here. Gotta deal with some chaos. Come here, sweetie. Get up. All right. Cats get everywhere. They get all over the desk. They start walking all over the keyboard, mashing on the keyboard, and then strange things happen to tabs and live streams and so forth. So gotta try to stay on top of them at all times. Well, Joni has come to say hi this morning. She is such a pretty girl. She's my little woodland spirit. She reminds me of my my little Artemis, my little Diana. She's a little hunter, very sweet, kind of like pops in and out, very, very affectionate, but not in a lingering kind of way. She will be off. And she's off. Then there's Miss Corona. Miss Corona is kind of bossy and kind of a troublemaker. She has her own mind. She wants to do what she wants to do. I will take her off of this desk over and over and over again, and she will just hop right back up. She will try to out-stubborn me. It is it is a little bit of a challenge sometimes between the two of us. Who's going to be more stubborn? Who's your money on? This cat is quite an adversary, but she's also extremely sweet. She's very loving. She just likes to express it in ways like attacking my hair and my clothes and things like that. Oh, they got some movement going on in the courtroom, but nothing really happening yet. Just still waiting for things to get started. I don't know how many of you saw that Ian might be having issues. If you are inclined to send out a tweet or something to the Team YouTube over there to try to get their attention. His live stream last night, his day 10 recap, it got taken down ostensibly for a community standards violation. Didn't happen. It's y'all know Ian. It's Ian talking about a case, and he has been the man on this case. Okay. I am not the only one who has been, very attached to and dependent on Ian's recaps and Ian's take. He's been extremely in-depth and detailed. He's got a lot of knowledge about these types of tactical situations that I don't have. So extremely valuable. And because his video got taken down, it's looking like he might be stream restricted. So I don't know if he's going to be able to live stream tonight. So if any of y'all want to wave your hands at Team YouTube and try to get their attention to see if they might be inclined to fix that, I'm sure he would appreciate it. I know I would, because I was very much looking forward to hearing what Ian was going to have to say at the conclusion of all of this. I don't know if YouTube would pay attention to our tweets, but it's what we have, right? Maybe we're shouting into the void, but it's a chance we have to try to get attention. I don't know of any way to contact them through YouTube other than Ian himself being able to report. And according to Ian, he filed the appeal that's supposed to go to a human, and less than a second later, he gets the denial. Appeal is denied, which is kind of some bullshit, right? Nobody looked at it in that time frame. So I don't know. I mean, we've made a stink before. Sometimes they respond on Twitter. So it's the hope. It's the hope that I have. Something just went flying. I don't know if you guys could hear that. I've had to do so much to try to cat-proof my office, but there's only so much you can do when you've got notes and you've got your notebooks and things like that you've got to be able to reach for. And they end up being interesting cat towers to be able to climb. Still waiting. The judge, put the time limit on the closings. I mean, it wasn't a hard limit, but he asked the defense, how much time do you want? They say 2 hours. He's like, well, I'll give you 90 minutes. Not necessarily going to freak out if you go over. It's like, why do you even ask if you're not going to give them what they're asking for? It's like a negotiation or something. I don't know, but anyway, he did put a little bit of a time limit on the closings. So I don't know how long the charging of the jury is going to take. Really don't know what that process looks like in Texas. You know how extensive it is. So we'll see. But then if the defense is getting 90, I have to think the state is going to take their full allocation of the time as well. So we're looking at 3 to 4 hours of just arguments today. The defense is going to split their argument, they said, between Nico LaHood and Jason Goss. I got to tell you, I don't love it. I really don't. I didn't love it in the opening. I don't love it in the closing either. I just didn't find it effective. And in the opening, I didn't get the point because they both basically said the same thing. It's just that Nico, from my perspective, said it a lot better. Nico's a great lawyer. He's been really fun to watch. He's got so many talents as a litigator. He's got some of it I'm sure is just natural. It's just charisma. It's just a way of being able to interact with people where, like, even when he's being an asshole, you don't really feel like it. You know, you don't. I don't hold it against him. It's like maybe it was just because he really didn't do that until that last prosecution witness, the expert, who came up with that detailed timeline and the animation, kind of put all the radio traffic and things like that together with the map to show the movements and who was where and put it all together in one place to kind of get a visual of everything going down. He was really the first one that kind of called for Nico to take the gloves off, because up to that point you're dealing with a lot of teachers and family members and things like that. And even if they are contradictory, you cannot be an asshole to those people. The jury is going to hate you. The jury is going to absolutely hate you. And they did such a good job of kind of laying that groundwork, dealing with it up front in their jury selection. We're going to have to ask hard questions of some people who have suffered horrible things and they're victims, and we're not impugning their character. But we have to do it. That's what this process is about, is about getting to the truth. And so if we have to ask those hard questions, are you going to hold it against us? And then they pick jurors who say no. You have our permission to ask the hard questions, even of witnesses that we feel really, really bad for. And then bringing that out when they're questioning those witnesses. The jury gave us permission to do this, and we're not impugning you at all. And so even then, when most people, you get called out on a contradiction, you said something completely different in your first interview with the police compared to what you're testifying now to at trial. Most people are going to be a little defensive about that. But they were just able to kid glove it in such a way that didn't really see that happen. Didn't really see the witnesses taking it personally. Just kind of acknowledged, oh yeah, I guess that is what happened. But then they get to that last witness where that guy is he got annoyed. He got so annoyed. He was like offended at being challenged and started to really let it show, like his disdain, like he can't be bothered. And he was very argumentative. And so, Nico took the gloves off with him, and it was kind of fun to watch. But in some ways, it's also kind of aggravating, just because the witness was so difficult. It was so difficult. At some point, even the judge has to be like, if you just answer it yes or no, then we'd be able to wrap this up and move on. But he wouldn't answer the question. And so Nico would, keep putting the same question to him. You're not answering the question. Even when he's being kind of an asshole to this guy. I mean, I didn't hold it against him. I'm like, yeah, the guy kind of deserves it. He kind of deserves it. Like Nico had just earned the credibility to be able to treat the witness in that way and not look like the bad guy. So I really enjoyed watching him throughout this trial. Very, very talented lawyer, very quick, very sharp, knew this case and the details front, back, and sideways. No question, this guy did his homework. Jason Goss, I wasn't so impressed with. They had some similar stylistic approaches. One of the things they got to do in this trial that was a little bit unusual is that they did get to be very conversational in their approach, primarily to cross-examination. That's what most of their role was on in the trial, was cross-examination. And so they got a lot of leeway to say things, talk themselves, either because we are orienting the witness to what it is that we're going to talk about. So we're going to tell you, here's what previous witnesses have said, and we've already heard this stuff, and here's some information that we already have by way of background. Or just because, you get to lead on cross, you get to ask leading questions, and so they get to kind of tell their version of the story and then be like, isn't that right? Do you agree with that? Yes or no? Try to put the words in their mouth. When I took trial practice in law school, my professor, he was really awesome. He was a great lawyer, and so much good information, good tips and things like that. But one of the things that he told us, it's a little bit trite, but it's very true, is that cross-examination is your turn to testify. It's your turn to testify because that's what you're doing. You are using the leading questions. You are pointing to the information that you want the jury to get, that this witness can deliver, and that's it. That's your job. So you're testifying about facts you want them to know, and you're asking the witness to confirm that or deny it. And you're asking this witness because you can nail them down one way or the other, because they have it in their report, or they said it in a prior interview, or something like that. You have some basis to be able to hold their feet to the fire. So your turn to testify is kind of it's a little bit of a defense lawyer, like, guiding light for how to conduct your cross-examination. And they definitely did that. This defense team took full advantage of that, their opportunity to testify. I just found, personally, I thought Nico did it way better than Jason Goss did. He would talk and 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 talk, and then be like, right? The witness is going, yes, no, maybe. I mean, could this question be any more compound? You've said it now 500 different ways, because you've said it, and then you've said, I mean, like, and then you've said it again a slightly different way. And I'm not sure that is always going to be super effective, because, again, one of the things the jury is going to have to bear in mind is they've been told over and over again what the lawyers say is an evidence. The questions aren't evidence, just the witness testimony is. And so you're already kind of mentally disregarding a little bit what the attorneys are saying. But then you got to follow him through like this long, convoluted kind of question to understand what it is the witness is saying at all. And it's not necessarily, even though it's simply yes or no, but your question was so complicated that it's really not clear, what they're agreeing with or whatever. So I didn't love Jason Goss nearly as much as I like Nico. But the splitting up the argument there needs to be a reason for it. And that was the big beef I had with the opening. I was like, what was the point of that? They just told us the same thing in slightly different ways. And from my perspective, Nico told the better story because he had all of that detail. He had the timeline that he gave to the jury, and that was kind of important. Certainly helped orient him to here's what's at stake. I mean, it oriented me to here's what's at stake in this trial. We're talking about 1 to 3 minutes before the shooter has done everything, all the damage that the shooter was going to do. And that's it. No more opportunity to be able to intervene and fix it or prevent it or anything like that. It's done. It happened so fast. That was important. Very important detail in the case. So then when I'm watching the evidence, that's what I can focus on. What do we know about this critical time period? So I might be critical of the closing, the splitting it up, because I'm going to want to see there's a reason for doing that. The reason should not just be sort of self-serving. I want the experience of doing it. I want the opportunity to speak to the jury. I want us to look like a team. Like, you got to put your client first. What's in your client's interest? Generally, what's going to be in your client's interest is going to be put your best lawyer up there to do the closing. And that to me is just without question. If I'm the coach, like I'm the coach for this defense team, and we're planning the closing here, I'm putting Nico on the field, like no question. He has been able to build the rapport. He's been able to communicate very clearly and concisely what his point is. And he's been able to adjust on the fly rapidly, deal with situations like, oh, so you didn't have this information in your critical timeline. Is there another version of your critical timeline? When did you give that to the prosecutor? Learning stuff for the first time in his cross-examination and instantly able to figure out on the fly, how do we attack this? How do we make our record that this is an issue and so forth? Not saying that Jason Goss can't do that. It's just that we saw Nico do it in real time. And part of what you're doing in the defense, the prosecution just gave their closing before you go. And so you can plan it all out ahead of time. You can try to script it as much as you want, but the best closing arguments are going to respond to what the prosecutor had to say. And so you got to be able to figure out on the fly real quick, how am I going to address that? How am I going to incorporate that? How can I tie that in? And we know that Nico can do that. So if I'm the coach, just me, maybe that's just me, but if I'm the coach, I'm giving Nico this closing argument, no question. So I'm going to want to see, why do we need them both? And what are we getting from Mr. Goss that we could not have gotten from Mr. LaHood? Oh, we're still waiting. He was very insistent, guys. Be here at 8:30. So here we were, 6 a.m. And of course, we're waiting. That's okay. That's just the nature of things. There's always last minute stuff. Always last minute stuff. Oh, they've got to make the copies of the jury instructions and they discovered that there's a typo. They have to go fix everything. Jurors late coming in. I mean, whatever. Things happen all the time. What else can we talk about? Oh, one other thing I forgot to mention when I was thinking about, how long is it going to take for them to decide? Another thing I didn't realize until fairly recently, not shocking to me, I just didn't know. I didn't know for sure. I hadn't confirmed that this trial is not taking place in Uvalde. They moved it. It's in Corpus Christi. I can't imagine, a world where this case could be tried in Uvalde. I did educate myself a little bit more on kind of just some of the background of this shooting and the investigation of the shooting and the response and so forth, just to kind of get a sense of, how did we get here? Why are we here? Why Adrian Gonzales and all of that? And so I learned a lot of stuff that I didn't know. I didn't know that because it took so long for them to breach that classroom door, that there were parents like already at the school trying to get into the school to save their kids, seeing that the police aren't doing anything and wanting as parents to go in and protect their children, and police preventing them from being able to do that. That's going to cause some hard feelings. I didn't know that happened. And that's definitely going to cause some hard feelings. Then I saw it was just a real shit show with providing information about the police response. The governor is giving information. The police is, the different heads and everything are giving information, and they're conflicting, and they're having to change, and they're having to give new information. And of course, they're trying to paint themselves in the best possible light, because right off the bat, it doesn't look good. 73 minutes it took you to get into that classroom. And they're giving public statements, trying to sound like, our response was prompt and efficient, and we got there with the equipment we needed and took care of the shooter. So not a whole lot of insight right off the bat into the kinds of questions and objections that certainly the family members of the children that were killed, but just the community as a whole, is looking real side eyes at the 73 minutes it took to get in that room. And so just kind of casually, oh, we got there quickly. Our response was, not real smart. Then I saw there was some PR document, like talking points or something, that somebody had put together for the Uvalde Consolidated School Police, like their talking points. And then this document gets released under the Public Records Act. So now people are seeing, here's how they're planning, here's how they're scripting to make themselves look good in this situation. I had no idea there was all this context. The teacher who testified the very beginning of week 2, can't remember his name now. Ephraim Gonzales, was that his name? He was the one that survived in room 112. He apparently has made a lot of statements, very unhappy with the police and the police response. And I can't say I blame him. I can't say I blame him for being unhappy. Stuck in there with the shooter for over an hour, been shot yourself, and nobody's coming. And the people that are supposed to be, like, that's their job, is to engage with a threat, they seem to have just kind of abandoned you, left you to deal with it. I don't blame him for being upset. So I didn't realize quite how much backlash there had been, really right off the bat, against the law enforcement and the response, and how much law enforcement mishandled that initial step of being honest. That looks like they're killing. Jury's coming in.
You can be seated in the courtroom. Thank you. All right, good morning, members of the jury. We have finalized the charge of the court. I'm going to read it to you. You don't need to memorize anything. You will have a copy of it, and it'll be in the jury room during your deliberations to consult. After I complete my reading of the charge, both sides will argue the case, and then we will ask you to deliberate. This is cause number 25 FC 0001U. State of Texas versus Adrian Gonzales. Charge of the court, members of the jury. The defendant, Adrian Gonzales, is accused of 29 counts of endangering a child. The defendant has pleaded not guilty. You have heard all of the evidence that will be admitted as to whether the defendant has been proven to be guilty of these offenses in violation of the Texas Penal Code. Both sides will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether the defendant has been proven to be guilty or not. You will have a written copy of these instructions to take with you and to use during your deliberations. First, and I will note, ladies and gentlemen, the notes you've taken throughout the trial, the bailiff will hold those for you until after the deliberations are complete. As I told you, if we have a dispute as to anything regarding the evidence, we're going to rely on the official court record, so the notes will be retained during your deliberations.
There it is.
First, I will inform you of the general principles of law that must govern your decision in the case. Then I will inform you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant may have been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After a careful and impartial consideration of all of the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish the guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt as to whether the defendant is guilty, you must find the defendant not guilty. Jury as the fact finder. As the jurors, you must review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law as provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, nor mention anything that is not in evidence in the trial. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by lawyers are not evidence. Evidence consists of the testimony of the witnesses, materials, and physical items that were admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are to be given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and the evidence that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based upon the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice or sympathy. You are admitted exhibits. You will be provided all of the admitted exhibits for your examination in the jury room. Testimony, the court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson or presiding juror, number one, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and number two, identify the verdict. The law requires that you must render a verdict of either guilty or not guilty. The verdict of not guilty simply means the state's evidence did not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreman or presiding juror should notify the court. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf if he elects to do so. The defendant may also choose not to testify. The defendant's decision not to testify cannot and must not be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Instructions on count one, endangering a child. Excuse me. Accusation. The state accuses the defendant of having committed the offense of count one, endangering a child. Specifically, the accusation is that the defendant, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Manuel Flores Jr., a child younger than 15 years of age, in imminent danger of death, serious bodily injury, or physical or mental impairment by engaging in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness one, and having the time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, and delay the shooter, or failed to otherwise act in a way to impede the shooter until the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. B, after hearing gunshots and after being advised of the general location of the shooter by witness one and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. And that as a peace officer for the Uvalde Consolidated Independent School District, the defendant had statutory duties to act as follows: to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater, or after being informed in any manner that a threat had been made by one person to do some injury to another person, to prevent the threatened injury if within his power, or to protect the safety and welfare of the people in the jurisdiction of his school district, and that the defendant did not voluntarily deliver to Jose Manuel Flores Jr. to a designated emergency infant care provider. Relevant statutes. A person commits the offense of endangering a child if he intentionally, knowingly, recklessly, or with criminal negligence by omission engages in conduct that places a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. A person commits an offense by omission only if the person has a duty to act. A peace officer has a duty, A, under the provisions of Article 6.06 of the Texas Code of Criminal Procedure, to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. B, under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, after being informed in any manner that a threat has been made by one person to do some injury to another person, to prevent the threatened injury if within his power. C, under Section 337.081 of the Texas Education Code, to protect the safety and welfare of people in his jurisdiction. Such endangerment is not an offense if the defendant voluntarily delivered the child to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Definitions: conduct, an act or omission and its accompanying mental state. Omission, a failure to act. A person commits an offense only if he voluntarily engages in conduct, including an act, an omission, or possession. A person who omits to perform an act does not commit an offense under the law, unless a law provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Intentional conduct, a person acts intentionally as required by this offense if the person has the conscious objective or desire to engage in the conduct that would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Knowing conduct, a person acts knowingly as required by this offense if the person was aware that his conduct was reasonably certain to place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Reckless conduct, a person acts recklessly as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a person younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person is aware of but consciously disregards that risk. Criminally negligent conduct. A person acts with criminal negligence as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person ought to be aware of that risk. Bodily injury means physical pain, illness, or any impairment of physical condition. Designated emergency infant care provider means an emergency medical services provider, a hospital, or a child placing agency licensed by the Department of Family and Protective Services that agrees to act as a designated emergency infant care provider and has on staff a person who is licensed as a registered nurse and who will examine and provide emergency medical services to a child taken into possession by the agency. Excuse me. Application of the law to the facts. You must determine whether the state has proven beyond a reasonable doubt 6 elements. The elements are that number 1, the defendant in Uvalde County, Texas, on or about May 24th, 2022, engaged in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112, and or B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to the gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 of Robb Elementary School. And number 3, Jose Manuel Flores Jr. was at the time a child younger than 15 years of age. And number 4, the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. And number 5, the defendant was a peace officer for the Uvalde Consolidated Independent School District and had a duty to act by virtue of the provisions of the endangering of a child statute and or other state statutes, providing that he had a duty to perform the said acts that he omitted to perform. And number 6, the defendant's conduct was not a voluntary delivery of Jose Manuel Flores Jr. to a designated emergency infant care provider. You must all unanimously agree on the elements listed above. If you agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you must find the defendant not guilty of count 1, endangering a child. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must find the defendant guilty of count 1. Stipulation of facts by the parties. The defendant has stipulated that the named child victims in the indictment either suffered death or physical bodily injury on May 24th, 2022 as a result of the mass shooting at Robb Elementary School in Uvalde, Texas. All right, counts 2 through 29, ladies and gentlemen, instructions on those counts endangering a child. The state accuses the defendant of having committed the same offense of endangering a child in counts 2 through 29. Specifically, the accusations in these counts are the same as those in count 1, except that the alleged victims, all children younger than 15 years of age, are as follows. Count 2, Azucio Sergio Garcia. Count 3, Xavier James Lopez. Count 4, JC Carmelo Ivanos. Count 5, Annabelle Guadalupe Rodriguez. Count 6, Alexandria Anaya Rubio. Count 7, Leila Marie Salazar. Count 8, Elena Torres. Count 9, Rogelio Fernandez Torres. Count 10, Nevia Alicia Bravo. Count 11, Jacqueline Jaden Casares. Count 12, McKenna Lee Elrod. Count 13, Elena A. Garcia. Count 14, Tess Marie Mata. Count 15, Miranda Gail Mathis. Count 16, Alethea Haven Ramirez. Count 17, Maita Elena Rodriguez. Count 18, Jayla Nicole Silguero. Count 19, Ameria Joe Garza. Count 20, Noah Oscar Arona. Count 21, Chloe Melinda Torres. Count 22, Jordan Demetrio Olivares. Count 23, Jadian Canizales. Count 24, Samuel N. Salinas. Count 25, Kendall Faith Olivares. Count 26, Mia Sorillo. Count 27, Gilberto E. Mata. Count 28, A.J. Martinez. Count 29, Maya Zamora. Relevant statutes and definitions in regard to the above. The relevant statutes and definitions for counts 2 through 29 are the same as those that have been set forth previously in the instructions for count 1. Application of the law to the facts, you must determine whether the state has proven beyond a reasonable doubt the same 6 elements listed in count 1 previously with respect to each of the remaining counts 2 through 29, except that the names of the victims alleged in these counts are different. Likewise, you must all unanimously agree on all such elements with respect to the remaining counts 2 through 29. With respect to each of the remaining counts 2 through 29, if you all agree the state has failed to prove beyond a reasonable doubt one or more of the 6 elements, you must find the defendant not guilty of that particular count. However, if you all agree that the state has proven beyond a reasonable doubt each of those 6 elements, you must find the defendant guilty of that particular count. Rules which control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson or your presiding juror. The foreperson should conduct the deliberations in an orderly manner. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheets. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. Number 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter alone. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your verdict sign his or her name to the particular form that conforms to your unanimous verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Date, January 20th, 2026. Sid Harle, judge presiding. Ladies and gentlemen, there are 29 verdict forms attached. They are all identical other than the name. I'm going to read the first form to you to illustrate what they all say, and the rest will be attached to the verdict for your consideration. Now, the verdict forms are not to suggest to you what your verdict should be. However, should you decide to use these verdict forms, each and every one must be signed by the presiding juror, the foreperson, indicating your unanimous verdict. Count one, verdict, not guilty. We, the jury, find the defendant, Adrian Gonzales, not guilty of count one, endangering a child, as charged in the indictment, with a signature line for the foreperson and a line for the printed name of the foreperson. Verdict, guilty. We, the jury, find the defendant, Adrian Gonzales, guilty of count one, endangering a child, as charged in the indictment. Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical verdict forms for each of the 29 counts alleged. All right, ladies and gentlemen, at this time, both sides have an opportunity to argue the case. The state does have the burden of proof, so they have the opportunity to open and close the arguments. I will ask them to address you at this time.
It's nice that he didn't read 29 times.
Abraham Lincoln said that it is much the duty of government to render prompt justice against itself as it is to render the same against the people. What he was saying was,
Reflect on that.
we have a government comprised of prosecutors and police officers whose job it is to render justice against citizens when they violate the law. And that's what we're accustomed to. Prosecutors and police officers working together when someone has violated the law so that they may be held accountable, so that we may have peace and dignity in our state. But Lincoln reminded that no one is above the law, that those in government can also violate the law. And when that happens, it is the government's job to also render justice against those they work with. And so on May 24, 2022, when 19 children were slaughtered, 10 others were injured, Texas Rangers from all over the state came to Uvalde, Texas, investigated the crime scene, talked to witnesses, analyzed the case for up to a year. And after analyzing the case, one of the members of the government has been brought to you for justice. But ultimately, in our country, in a democracy, it is the people that decide their government. You do that by electing officials. You do that by sending letters or requests to have the law changed. And when one of the members of your government violates the law, you decide whether or not that is acceptable. Because make no mistake, the 12 of you will set the bar for law enforcement in these situations. If it's appropriate to stand outside hearing 100 shots while children are being slaughtered, that is your decision to tell the state of Texas And by the same token, if that is not appropriate, that is not how we expect officers that are charged with the duty of protecting children to act, that will also go out from this court. The judge has told you that your oath was to render a true verdict according to the law and according to the facts. He's given you the law, and it is that same law that we discussed in voir dire some 2 weeks ago. You recall we talked about this is a special statute because we're dealing with a special group of people. We're dealing with children under 15 years of age. And so we're expected to act differently when we're talking about children that are frail, can't defend themselves, 15 years old or younger. And in this law, the law of child endangerment, none of us are allowed to endanger a child. None of us can point a gun at a child, put them in danger, put them in harm's way. But there is also the protection that if you have a duty to act, you can't stand by while the child is in imminent danger. If you have a duty to protect the child, you can't stand by and allow it to happen. We talked about the people that have a duty. Parents have a statutory duty, and police officers have a statutory duty. And those two sets of people cannot fail to act when a child is in imminent danger. And so the charge in this case is that these 29 children were in danger. Not just danger, but imminent, immediate, close at hand danger. And that there was a man who had a duty to act, who failed to act. And that failure to act, he was aware or should have been aware that that placed those children in danger. But we're also very specific about it. How is it that he failed to act?
Are you?
He failed
Let's hear
to
it.
act after being aware that shots are fired, being told the general location of the defendant, of the gunman, having time to respond. He failed to act by either engaging, distracting, delaying, or even attempting to do those things. And also being aware that shots were fired and being advised of the general location of the shooter and having time to act and having been trained in that active shooter training. He failed to follow his training to respond by advancing toward the shooter until after the children in 111 and 112 have been shot. That is the obligation the state has to prove to you beyond a reasonable doubt. Two other quick mentions of the law that the judge has given you that I'm afraid we may not have discussed in detail on voir dire. The first was that the defendant must engage in a voluntary act. The first was on the causation. We talked about when you have child endangerment by omission, there can be two people that can be held responsible. The person that is causing the danger and the person that has a duty to prevent that danger failing to act.
I'm just going to object to that. Sorry, at this point, there's concurrent causation is on his board. It's not in the charge.
I'm not discussing that. That just now we're through that, Judge, and I just didn't mark it off. I didn't say concurrent cause. I talked about what we talked about in the law that.
Okay. All right, I'll overrule the objection. Go ahead. Ladies and gentlemen, I just noticed the clerk brought to my attention, we were working on that charge yesterday. Your date's wrong on that. It's 21. January 21, the last page of it. So it says 20, but it's 21. You know that. Go ahead.
The second issue is voluntary. The defendant must engage in a voluntary act. That's as opposed to an involuntary act. An involuntary act, I believe we talked about during jury selection, is, you know, if you stumble and knock somebody over an embankment and they're injured, that wasn't a voluntary act on your part. A gust of wind blows you into somebody. You're not responsible for that kind of conduct. If somebody swerves into oncoming traffic and hurts somebody, that certainly looks like you should be responsible for that conduct. But what if it was the very first time you'd experienced a heart attack and you lost control of the vehicle? That's not a voluntary act. That's an involuntary act. You're not responsible for that. But if you make a decision to seek cover and ask for cover as opposed to going in and stand by while people are being injured and killed, that is the kind of thing that's the voluntary act. It's defined in the statute. And finally, on mental states, there were 4. Intentional is not really something to discuss. Nobody believes that Adrian Gonzales meant for this to happen, wanted this to happen. But the other 3 deals with their level of awareness. Knowingly means simply you're aware that by standing by, it's reasonably certain the children will be in danger. Aware is reasonably certain. Reckless is 1 degree lower than that, and that is not that you're reasonably certain the conduct will happen, but reasonably certain that there is a risk, a substantial and unjustifiable risk that the children will be in danger. But there's still an awareness. But in addition to that, there's criminal negligence, in which the law is simply, you should have been aware, based on all those circumstances, that by you failing to act, the child was at risk. So that's the mental state. Not that he intended it, wanted it to happen, but at minimum, he should have been aware that by standing there, hearing 100 shots, he should have been aware that children were in danger by his failure to act. And so then we move into, and beyond the law, into what the state's case was. And it's pretty straightforward. This is not the order we put it in, but this is just the order I drew it up, because training is a big part of who Adrian Gonzales was. And you have the training that he trained others, because that tells you what he knows. And it also tells you a lot about what the state has done before you got here. In that lesson plan that was introduced into evidence, it tells you that amidst active shooting, the state of Texas stepped forward and required active shooter training for school police officers. And that active shooter training includes stop the killing, stop the dying. And it's not terribly complicated. The training is go to the gunman, advance toward the shots. Pretty straightforward. Not complicated, not hard. Go to where the gunfire is. That's what the training is.
Suicide mission is the training, apparently.
We brought you evidence that Adrian Gonzales taught the class that said, advance to the gunman, stop the killing, stop the dying. Even if you're the only one there, solo entry, you've got an obligation to go in. Why? Because in our state, we have a priority of life. Innocent civilians, their priority of safety is above the police officers. The officer going through this training is aware that the safety of the innocent is above the safety of the police officer. And in Adrian Gonzales's training, he says, the citizens have a right to expect that. And if you're not willing to do it as a first responder, find another career. Adrian Gonzales is teaching his fellow officers, take your job seriously. It's okay to move aside. It's okay if you're not up to that. Let somebody else step in that is up to it. Because as citizens, we have the right to expect that. When we call for help, we have the right to expect somebody that is put on the badge and put on the gun and put protect and serve on the side of their car will do that when we call. Because if they're not willing to do that, where are you? What are you left with when you're in danger? Who do you call? And so Adrian Gonzales, armed with this training, the next thing we spent a considerable amount of time on was the shot count. The casings along the west side, the casings along the hallway, the casings in 111, the casings in 112. And why did we spend all of the time on that? Because it's the state's position that each shot was noticed to Adrian Gonzales to advance toward the gunfire. Each shot was important to those 19 children and those 10 survivors.
If he heard them.
Each shot.
We heard about auditory exclusion.
But the shot count also, as we did that, and obviously if you have this kind of slaughter, there's going to be blood, and we apologize for that. But the blood also tells you a story of children engaged in this, doing as they were trained. To hide in the dark, remain quiet, and wait for the police. Did the defendant have time to act? We brought you videos, the funeral home videos, as well as the hallway videos, as well as dispatch, to tell you what he was aware of, when he was aware of it, and what was going on as he stood outside the fourth grade wing for 3.5 minutes before he made his first move, before he moved forward. We also brought you the defendant's statement. And the defendant's statement, I think, clears up almost the entire case. That is what he told the Texas Rangers shortly after this happened. If you're worried about whether or not he had notice and whether he had time to act and what his decision-making was, listen to these words from Adrian Gonzales. He's over there. He's over there. He's wearing black. I say where? I hear shots going off. Hear sounds coming from behind the building. I get on the radio and say, shots fired at Rob's school, and give the location and where he is. Trying to get from the front of my vehicle to the back of my vehicle. There's only a tree and a building. She tells me he's over there. She's pointing, saying he's over there. He's dressed in black. I say where? She says the teacher's parking lot. I want to say I saw a black car at the end, and then I hear the rounds going off. When Melody Flores says he's over there, the teacher's parking lot, I hear the rounds going off. some evidence of auditory exclusion. He tells the Rangers, as Melody Flores is telling him where he is, he hears the rounds going off. She goes, he's over there by the teacher's parking lot. Then I hear the sounds going off. I heard 7 or 9 shots while I was inside the building. The coach said parking lot in all black. That's when I heard the rounds start going off. I never saw him. I never went to the school until I got coverage over here. Then I made entry. I heard like 3 or 4 gunfire. When Pargus was the first one I saw, I told him to come to me for cover because he has a bigger unit. But he deterred and went to the other area. I knew there were kids in the class. That's why we didn't fire and hit the kids. I'm responding because they are saying the guy is running to the school. I didn't respond to the accident. That's a PD traffic. I'm going over there because they are saying the guy is going to the school and has a gun. Yeah, that's why I'm going to the school. And so the question is, if Melody Flores is telling him where he is, he's in black, when did she tell him that? Do you really suppose that someone who risked her life to go tell the kids to get inside the door, that is that worried about those children, that turns to run, that when the police officer gets there, doesn't immediately say what she told you she said? He's over there, he's in the parking lot. Where? And she points. And then says, we've got to get in there. And isn't that consistent with what human beings do? Look at Gilbert Lamons. When he sees children in danger, just as Melody Flores sees kids in danger, what does he start saying? Get in there, get in there, get in there, get in there, get in there. Repeats it over and over and over again because of the urgency of the children being in danger. And Adrian Gonzales decides to go to the back of his car, call Mariano Pargas because he's got a bigger unit, and says, I'm not going in until I get covered. We proved to you the children were in danger. And I know that was a horrible thing to have to experience. But each one of those children deserves to be revived. And you needed to know that those 60 shots in rooms 111 and 112 before Adrian Gonzales entered, those shots ended those kids' lives. This was over before he went in. A whole lot of blame for a whole lot of officers. This was over while he stood outside. And we anticipated that the defendant would say I was confused regardless of what he said in his statement. And so certainly gunfire can be a confusing thing. But we brought you teachers that experienced that gunfire. And the teachers told you that experiencing that gunfire, they still put their kids first and they follow their training. Kids first, follow the training. Melody Flores did it. Miss Deming in room 104 did it. Miss Ogburn in 102 did it. Miss Robin did it with her children. And Mercedes Salas said, not till I get my kids out. You can talk about confusion, but their priorities were where they needed to be. Children first.
I'm not sure if the clerk should be like crying in the
When we
courtroom.
talk about the defendant's evidence, or the defendant's case, let me say. We started very early on that Monday, but he didn't have time because it was too far. It was 45 seconds over there. So we brought you evidence that somebody that covered that almost that same distance was able to do it at a jog in about 11 seconds. It was further than that, given 15, 18 seconds, but it certainly wasn't 45 seconds. And then there was the representation. There were no shots fired toward Melody Flores. There's no evidence of that. And so we brought you the evidence of the 8 casings on the side of the parking lot, the shot into room 24. Well, those 8 shots were accidental discharge by a man bent on killing kids. He just made an accident, swung his gun around, and fired those shots, not toward Melody Flores, but toward that window. And so we brought you the casings. One picture shows 3 of the casings, but you remember the FBI agent said we had to go back several times, and so there's 2 more markers that are additional. There's 5 casings. There's 5 shots in the glass and 5 shots directly across up into the, not 5, but shots shrapnel up into the ceiling and down. So where are those 8 casings being fired? If you have those 5 taken care of, as well as in one room 104. Well, we have room 24. And so they tell you, well, that could have come out of room 111. So we brought you evidence that it was circular or almost oblong, saying that's the wrong angle. But more important than that, there's a piece of conduit running up the building. That bullet would have to pass through without leaving a mark. That evidence about Melody doesn't know what she's talking about is so you don't trust Melody Flores. And if you have any hesitancy on Melody Flores, go back to the defendant's statement where he says she told me where he was, what he was wearing. And then I heard the shots. We had a lot of information about slicing a pie and how long that must take. No way you have time. You got to get over to the side of the building and slice the pie. You can't do it quick. You have to do it slowly so you don't put yourself in harm's way. There's no evidence Adrian Gonzales got to a point where he could slice the pie.
And why is that?
And we had evidence from their expert that said, slice the pie. How about taking a quick peek? You have cover, you have concealment, the gunman can't see you. You just peek around from a safe position. Well, it wasn't really cover. Well, it's not cover from the south side, if the gunman's over there. Adrian can see that way. It's not cover from the west side, if the gunman's over there. He's not over there, which Adrian can see. But it is covered from the northwest side, where the gunman is firing 16 shots. While Melody Flores is telling him he's over there. Echo, Adrian did tell the Rangers that there was an echo. So from his spot where he's standing, he's got to find out where that shot's coming from. And he can see on the east side, it's not coming there. He can see on the south side, it's not coming there. He can see on all directions except behind the building where Melody Flores is telling me he is. That's where it's coming. Not only that, but when Coronado runs up and he hears those shots within 2 seconds, he's saying, shots fired, get in the building. And Adrian Gonzales knows which building to go to. And Paige knows which building to go to. And they go to the building where the shots are fired and have been firing for 3.5 minutes. Well, let's talk about the doors, the responsibility of the doors. The doors would have slowed him up. Yes, the doors would have slowed him up. He had an AR rifle that penetrates glass. The glass is right next to the doors. He could have weakened that glass within a matter of seconds. It would have slowed him up 2 or 3 seconds to go through that door. You look at rooms 111 and 112 and you see the shots there surrounded around the window. May have slowed him up another couple of seconds if the door is locked. But we're not talking about a couple of seconds. We're talking about 3.5 minutes. Number one. Number two, the charge of endangering a child means you have to be aware the child is in imminent danger when you fail to act. And that unlocking, that failing to act, failing to lock the doors did not happen as the gunman was firing the guns. The children weren't in imminent danger, immediate, close at hand danger when the doors weren't locked. Their failure to act at that point was not at the point where the children were in imminent danger, nor is there evidence they have a statutory duty to act.
I'm going to disagree with that.
In this case, let me say, there are adults we can be very disappointed in. There can be police officers we're very disappointed in. I don't know how you feel about everybody, all those people. I'm not proud. This is the case of the state of Texas versus Adrian Gonzales and the facts against him. And is he going to be held accountable for his lack of action? And so we concentrated our case on the facts against Adrian Gonzales.
They have the care, custody, and control of the children in the school.
It's radio dispatch's fault because they didn't give significant enough information. They just said, wreck, man with gun, shots fired. They didn't say if he was shooting at the school or not. That's important information we should have known. But their expert got on the stand and said, wreck, man with a gun, what does that say? Not a lot. A man can be with a gun, but not be all that dangerous. But what about shots fired? His testimony was, then it gets real. What does that mean to a police officer? Shots fired. Then it gets real. Then on your way over there, you got time to know I'm facing somebody where there's shots fired. It reduces the confusion by the preparation. Shots fired. This is real. I've been trained. Shots fired at a school. Not the information in the school. Shots fired. Rob Elementary, man with a gun. I've been trained. I may have to go in solo. It was the police administration's fault because they didn't assign a person to each school. I suppose that statement is really, if they had assigned somebody, as long as it wasn't Adrian Gonzales, the outcome would have been different. the defendant's case. Then we move to the other police officers, Page, Hill, Sauceda, Coronado. And they'll ask you to look through your course charge and find where it says evaluate the conduct of Page, Hill, Sauceda, or Coronado. You're here to decide one case. But we're glad to talk to you about these officers. Page, the funeral home tape alone shows you that he shows up 2.5 to 3 minutes after Adrian Gonzales is there. That, along with the raw videotape, shows you that he entered the building within 30 seconds. He shows up, there's shots going on, he assesses the situation in 30 seconds. He's acting. He's acting. Not failing to act. Hill, you recall that it's Hill's responsibility because he was called to Old Carrizo Road. He goes to Old Carrizo Road. He arrives there after the gunman is already inside the school. After the 16 shots from outside have already been fired on the other side of the school. The testimony was there was radio chat about setting up a perimeter. So he sets up a perimeter. Because here's what officers do. They get dispatched and they act. And when they get there, they assess a new set of information and they act. And after he sets up the perimeter, then he joins other people. And yes, the testimony was 25 minutes before he goes in. But Ruby Gonzales told you that once those hallways get full, it can become dangerous to overclutter that hallway. So you find other things to do. Well, if there's a perimeter, doesn't that count for Adrian too? If Adrian got the call to set up a perimeter and he goes there, so be it. But then you gather additional information. And that is 16 shots being fired outside, 24 shots being fired in the hallway, 60 shots being fired in classrooms, and a teacher saying he's over there, you got to get him. And you respond after you get the additional information. Sauceda shows up 30 seconds after the gunman has started shooting. The gunman shooting into the glass, into the classrooms. That's before Sauceda gets there. Halfway up, you know it's when Sauceda gets there because the bag is dropped. And then shots are fired. 6 shots are fired from behind a long row of cars.
Where's Mendoza on this chart?
Having an instant
You want to talk about Mendoza?
in which the gunman we know is hurrying the last part of that trip. We know the gunman is not firing into the building at that point. He's firing somewhere else. They think they're taking shots. If it's behind the vehicles, there's school classrooms with glass windows. If it's to the south and west, there's a man in dark blue or black. Permission to fire. Being careful. And then getting in his car and acting and following his sergeant to the end of the corner where Coronado says, I believe that's Sauceda. Also jogging to find the gun. He's acting.
So they get to be careful, but Adrian doesn't get to
Coronado
be careful.
arrived to the sound of, he said he was receiving gunfire. The man at the funeral home is telling me, I think he says 2 or 3 the building. He's the officer that came that is used to these being bailouts. And maybe it's a road rage. And that's what he's used to doing. Whereas a school officer is used to protecting the school grounds. And so he's thinking this is a road rage. And my guy's shooting at us because he doesn't want us to get him. So he goes around to cut him off. But in going around to cut him off, he's acting. He's acting to stop the shooter. You may not like his decision. You may not be proud of his decision, but he's acting. This is a failure to act case.
So as long as he did something at all.
Because he jogs, he's looking for the gunman. And when he hears shots fired, he acts within 2 seconds. Get in the building, shots fired, and he goes in. He acts.
So Adrian got on the radio. Is that not an
And then
act?
the defense brought you evidence of the challenges that Adrian was facing. We start with tunnel vision. That's the whole issue about whether or not Adrian Gonzales saw the gunman in the parking lot. We have no trouble with the concept that he had tunnel vision and focused on the lady in peach. This charge does not start with Adrian Gonzales arriving at Rob Elementary. The charge starts specifically with after hearing shots fired, after Melody Flores, witness number 1, which you can conclude now is Melody Flores, told him the general location of the shooter, and then having time to act. That's when the case starts. So he has tunnel vision. Okay. Auditory exclusion. Perhaps he didn't hear the shots. Then why would you tell the Rangers when Melody Flores told me where he was, I heard the shots? How does that happen? This was really complicated. Complicated set of facts I have to decide on. Complication, the training is you hear shots, you go to the gunfire. He heard shots and Melody Flores was pointing where to go to the gunfire. There's nothing complicated about that. He's wearing black. He's over in the teacher's parking lot. Go to the gunfire. Perimeter. Why doesn't Adrian get to set up a perimeter if Hill gets to? Why didn't Adrian tell the Rangers? I heard I was supposed to set up a perimeter. That's why I set up a perimeter. That isn't what he said. He said, I waited for cover before I was going in. And finally, this is an issue of stress. And this is my closing remark. I'm sure you're tired of listening to me. That was a dark day. For 29 families, it was extremely dark, and they still wait justice. I can't let that darkness. But I can say this, there were some bright spots. In that stress, teachers put their kids first. In that stress, kids made ways to try to defend each other. In that stress, kids comforted teachers. In that stress, kids came first. Adrian Gonzales had a duty to put the kids first. And he called for cover.
Proceed, John.
Yes, sir, please.
monster who hurt those kids is dead. That monster is dead. And we told you from the beginning. And it is one of the worst things that ever happened. And I told you the first time I stood up here and talked to you, I told you that you were not going to be the same person when you come out of this. And nor should you be. Nor should any of us. Witnessing horror, the tragedy, the loss, it's immeasurable. It's immeasurable. It's unthinkable. That loss is unthinkable. Their loss, it's unthinkable for any of us. You know, I told you guys before, I have a 4-year-old, a 1-year-old. And, you know, we told you we're from San Antonio. And obviously, you know, I want to go back and see him on the weekends after the first week. I went back. The first thing I did was my 4-year-old came downstairs and I hugged him. Right? And hugged him. And started crying. And his hair, you know, trying to, so he doesn't see it. He said, "Are you sad, Daddy?" I said, "No, I'm happy that I'm holding you." Because I know what a privilege, doing this case, I know what a privilege it is to hold that child. I do. Right? I know, I can just imagine what it's like to not be able to do that. And I can imagine the pain, and I can imagine the anger. I can imagine wanting to put somebody in that chair because I can't put the monster that did that to my child in that chair. I can imagine that. And I can imagine putting pressure. And I can imagine them responding to the pressure. And I can imagine them putting him in that chair. Him and only him. In that chair. To try to pay for the pain. To try to somehow this could cover the immeasurable and the immense loss. And so after I saw him on Friday, we have to come back here that Sunday after the first week. And Gary, he comes and picks me up. That's kind of what we've been doing. And my son comes out and he says, "Are you going to go help that man?" And that's what we told him is the reason I'm not there. I said, "Yeah, I'm going to go help." Okay. Adrian Gonzales. Because he needs my help. He needs our help. Because they, the government, the power of the state, has decided that he has to pay for the failures of that day, for the mistakes that were made that day, and for all the pain that they feel. And it's not right. Because the person that they plucked out and put in that chair, that person showed, we showed throughout this trial, that person was acting. He was acting. He was trying. And what I hear from the prosecutor, what I hear from the state, and what you've heard this entire time, what you've heard is that they will massage all the facts, they'll twist them all into a pretzel. That every one of these officers is fine, he's not. They'll twist it. Well, look who acted. They acted. Well, Adrian acted. Well, he didn't act the right way. They acted. Well, they didn't act the right way. Well, yeah, but he didn't act the right way, and he didn't know exactly what was going on, and he remained. Well, yeah, but Adrian remained in the hallway. Adrian remained in the hallway after he got shot at. Well, yeah, he remained in danger at that point, but before that point, he remained, and he didn't know what was going on. Every fact that they tried to bring, they twisted it around. I'm going to show you. You're going to watch. I'm going to show you what they've done to twist this thing from the beginning to the end. But ultimately, what we're talking about is we're talking about duty, we're talking about burden, and all of those things. And I don't want one thing that I'm saying right now to make you believe that he doesn't believe that he has a duty to stop something that he knows is going on. Of course he does. He knows that. He was trying to do it. He started trying to do his duty. You look at some of these other people, no. They're not trying to do their duty. They're trying to stay back. And one of the things that the prosecutor said, he said, what you do here will tell law enforcement, give them how they respond. I'll tell you what, I agree with that, but not in the way that he's saying it. Because the way he wants you to believe it is what your verdict says is that next time these officers will make the right choice, the right decision. They will respond appropriately. They will be perfect. But the problem is is that the issues here are not that Adrian failed to respond. They're not that he was intending not to engage. So you're not going to fix any of that, because I'll tell you, and I kind of hope it never happens again. I think we all know that it probably will. But those officers, what your verdict says is not going to make them perfect the next time. It's not going to make them not make mistakes. It's not going to make them not interpret things differently, strangely, weirdly, based on their own experiences. That's not what it's going to do. But I'll tell you what it would do. If you convict them, they're all going to be Randy Hill on that perimeter. There's nobody going in. What do? You went in. You convict them. What does it tell all the police officers? It's going to tell them, I'm not getting in that crap. I'm not getting in that chair. If I see somebody running towards the school, I'm not going after them, because if I'm mistaken and it takes me to the other side of the building from where the shooter is, and then I can't understand or know where the shooter is, I can go to prison. I can get prosecuted. So what you tell police officers is, don't go in, don't react, don't respond, stay on the perimeter, because Randy Hill isn't sitting in that chair. He's not. Adrian Gonzales is here. Randy Hill is not. None of those officers are in that chair. That's what you're going to tell them. You're going to tell them, don't do it. And you can't tell them that. It's like, I agree with them. You can't tell them that. We cannot have law enforcement feel that way. Feel like if they're not perfect, if they don't make a perfect decision. And that's where they go. The family goes right there. There's nothing that's going to bring these kids back. There's nothing ever is going to solve that pain. Nothing, not that. Because one of the things that Bill said to you is, he said, those kids deserve to be remembered, and they do. But you do not honor their memory by doing an injustice in their name. You don't. That does not honor those children. By doing an injustice, by doing what they want you to do, by letting him massage the facts, by letting the pretzel go all the way around and miss everybody else, but keeps going right back to him, because that's what they need. We talk about the charge. If I can get it up. The duty. So remember this about what the court has read to you. And remember, I'm not saying he doesn't have a duty. Of course he does. But just like every officer, just like the officers in San Antonio, they all had the duty. But that's, and it may have sounded flippant when we compared it. We said, look, you're in San Antonio. You hear there's a school shooting, right? You didn't stop it. Well, no, because it's not happening in the presence. And the reason we're asking that question is because the law is specific about it. A person, they have a duty to prevent an offense against a person about to be committed in his presence. So the first thing you have to figure out is that in his presence? You know, and the judge told you, you know, use common meanings, but he is here, and he never, they're not even disputing, he never saw the shooter, ever. He is never in the presence of the shooter. Now, what Bill may say is, well, he didn't go to the presence. But that's not what this law says. Law doesn't say you have to go and find yourself and make yourself be in the presence. And I'm not trying to make any excuse about that. But the law is the law is the law. This isn't about you have to go seek it out and make it happen in your presence. The law is saying if it's happening right there, there's a duty. Of course there is. He was doing his duty. He was running to the danger. He was driving right in there. If that was the gunman, and God, I wish it was, he would have ran him right over. That's what he was doing. He's going 50 miles an hour at that person. Now, what I'm glad is he didn't run the person over because he realized it's Melody Flores. He realized it's a coach is what he thought, teacher's aide. But he realized who it was after it's already too late, but he's here. And from this point, that shooter is never in his presence, ever. There's never a time. The only time that he gets close is when he goes one of the first 5 people to go up that hallway. That is a hallway of death. Anyone going into that hallway knows, anyone knows, any police officer knows that those rifle rounds start coming that way as they're coming up the hallway. It's death. They don't have any equipment. They don't have anything to block it. It's death. He went in that hallway of death. See, and I thought about it because, you know, there's no way I could tell you about how they feel. But I thought about it as a parent. As a parent with kids there, if I knew that while my kid was in that classroom, Somebody was going up that hallway, risking death to try to get to him. I'd appreciate it. I would. I mean, they're not perfect, but the person who did it, the monster, is dead. But he went up. A lot of people there didn't. A lot of people didn't enter that building until it was the room was surrounded on all sides by officers with rifles. Not one person on the side that he went in had one. Not one person had an AR. Not one person had a rifle. And they went in. Donald Page went in. Coronado went in. Chief Arredondo went in. People all went in and risked certain death. But the only time that he could have even been close to being in the presence of the shooter is when the shooter shot at him and Page to the wall. And you heard that testimony that there's gunshots going through the wall that they have to back up because not only can they not get to the door at all, they cannot get to the door. Joe Vasquez told you, that door, you're going to die at the door. You will die at the door. And I know that what the prosecution's saying is you should. Your job is to die at the door. But there was a lot of people out there. And if that's the training, die at the door, then everybody out there didn't follow. Everybody out there waited until there was shield. Everybody out there, Joe Vasquez included. Everybody. And you remember what Joe said? He said, thought his daughter could be in there, and he still waits 50 minutes for shields, for a plan, for BORTAC. So that's what I'm saying. They're twisting it around, and they're saying, well, his job, every shot was noticed that Adrian had to go in and be the person to die at the door, to be the person that tried to breach, solo entry with nothing. But nobody else did that. So is that the training? Right? Like that's one of the things that you have the right to go, because that's count 2, disregarding his training. Is that the training? Because if that is the training, and all these officers have been trained, and not one of them does it, but only one of them sits there, right? Like you have to twist it every time. For every fact has to be twisted around. That no other officer, I'm assuming, they made a point. Everybody's trained an active shooter. But that's why we pointed out that, well, now it's become a barricaded subject. And that training's different than active shooter. Now, some people are treating it like a hostage situation. And that's different than active shooter. And so the point is with this training was never meant to be twisted and used like this. You think that anybody that's putting on police training is going, yeah, and if you don't follow this, you're going to prison? That's not what they're doing. They're trying to give the best possible tactics and strategies to get to the best possible outcome. That's the point. But go back to the duty. If you find right there, honestly, he was never in the shooter's presence. Never was in his presence. Because that law, do not let them argue that law means that he has to go put himself in the presence. That law says it has to be in his presence. That's what that says. And if that's there, and you say that wasn't in his presence, then it doesn't apply. Under 605, he has a duty to prevent the threat, to do injury if within his power.
Within his power.
So they have to prove to you beyond a reasonable doubt that it's within his power. Because what they're not talking about is, no, this is saying you have the duty to go and follow the gunfire. That's not what this says. It doesn't say you have a duty to follow the gunfire. What it says is if it's within his power. So all of the officers before the breach, all the officers that even, and I don't have anything bad to say about Joe Vasquez. That man went in there. He went in there and he was willing to put his life on the line. But going in there like that in that room, it's not a whole lot different than going up that hallway, the first people to go up there without any protection, without any rifle rated anything, without any fire, without any rifles, without anything. But what that's telling you is that the reason that they waited is because it was within none of their power to get in that room. It was within none of their power to do that. It was not within his power to get in there and stop it. And it was not within any of those other guys until they got the right foot. And then they went in and it was within their power. But if they haven't proven to you beyond a reasonable doubt that Adrian could have done something to prevent, if beyond a reasonable doubt, then that doesn't apply. Then, of course, the education code just says he protects the safety and welfare of people in his jurisdiction. Well, of course. But that's not, a duty. I don't even understand why it's there. It's not a duty to say, well, yes, and if you violate it, you go to prison. If you violate it, you're a convicted felon. If you violate it, you're going to be on trial. That's just telling police officers, and especially those who work at schools, that your duty is to do that. Of course it is. That's your job. Of course it is. But what we're talking about is we're talking about a man who is trying to do that. He is not trying to do that. He's not going, I'm not protecting anybody. Oh, shooter. And then drive off the other way. He doesn't drive around the building. He doesn't drive away from the gunfire. He's still trying to figure this out, because we're talking about 1 minute and 48 seconds under their indictment. They keep saying 3 minutes, but it's 1 minute and 48 seconds. I showed you this in board hour. When we talk about beyond a reasonable doubt, possibly, probably, guilt likely, strong belief. If you have a strong belief that he had a duty, it's not guilty. Right there. That's why I'm talking about duty first, because as the prosecutor explained, if there's not a duty, then there's not. And not one of this is to be interpreted as me saying that he doesn't have a duty. We all have a duty to each other. He's a police officer. He's going to do what he can. But when we're talking about criminal charges, if you even it's likely that he does have that duty. It's likely that it was within his power. It's likely that it was within his presence. I have a strong belief it was in his presence. I have a strong belief that it was within his power. That's not guilty. It's a verdict of not guilty right there. That's the first consideration. But going to the indictment, after hearing gunshots and after being advised of the general location of the shooter, and Nico's going to talk to you a lot more about this, like it's convenient the way they're twisting it. It's convenient the way they're saying, well, of course, he was advised. She told him 1, 2, 3, and told him exactly where it was. And she pointed over, she's over here, pointed over there, and he knew. That's how they're presenting it to you. But that's not how we know that that's not how it happened. We know, we have to know, because she is frantic. She is very unclear about a lot of things. And so if you have a reasonable doubt that he was advised of the general location of the shooter, that's not guilty.
Is general
if you have a
location
reasonable
even
doubt
enough?
that he had time to respond to the shooter. Clicker slow on the uptake. Right. Having time to respond to the shooter. If you have a reasonable doubt as to that, it's not guilty. Right? Because what we established, and even now when he's reading Adrian's statement, shots fired, or she told me where it was, shots fired, I radioed it out. He's compressing time in his interview. We're going to talk about that. He's compressing that time. The way he's telling it, she tells him, and then he communicates it on the radio. We know that that's not what happened. We know that from the time of shots fired to the time he communicates it on the radio is a longer period of time, which is accounted for by the fact that he is trying to get the information out of her. Once he does, he communicates it. Once he communicates it, we told you, it's a second after this monster's already gotten in. Not an unlocked door, but it's already gotten in that door. When he communicates this out, the guy's already there. So having time to respond. Once he finally figures out what it is, does he have time to respond? And if he does respond, we were showing you, if he does respond over here, he's responding to something that's not even there anymore. He's doing basically what Coronado does, which is go completely away from where they saw him go in and go all the way around the building. So if there's a reasonable doubt as to having time to respond, that's not guilty. Any reasonable doubt as to any of these things, these are all elements that they have to prove to you beyond a reasonable doubt. And if there's any reasonable doubt as to any of these things, if there's a reasonable doubt as to Melody Flores and what she said, that doesn't say anything about her. That woman was traumatized. Of course she's going to be confused. Of course she's going to say it's a handgun when it's a rifle. Of course she's going to describe a completely different police car. Of course she's going to do those things because she's traumatized. But the reason we point those things out is they want him to be perfect, but they have to be perfect. They have to convince you perfectly, almost, beyond a reasonable doubt of their evidence. And that evidence rests on what did Melody Flores say and when did she say it? And they did not prove that. They did not prove it because even when she testified, Nico's going to go over it, she agreed that she was not just saying clearly, hi, this is what's happening, and this is where it is. She was saying a lot of different things. And it goes back to that chart. Anywhere you are, if you're suspected, if he's possibly guilty, if he's probably guilty, I told you at Bordire, I mean, most people get convicted at that probably. Because jurors go, well, he's probably guilty, so they convict him. But that's not what the standard is. That's not what the law says. The law says it has to be beyond a reasonable doubt. It's the only way that our Constitution works. It's the only way our system of justice works. Now let's talk about this. Let's talk about Ranger Hill. Okay. Look at this. I froze it on this animation that he did. Right at the point that Adrian's passing that spot. And that's where he has the shooter. He says it's approximate. Well, guess what? Approximate's not beyond a reasonable doubt. Their whole case is based on approximate guesses, speculation. We don't know. We're just really mad and we're upset that we have to put somebody here. Somebody's got to go in that chair because the guy who actually did this thing, the monster who did this, cannot go in that chair. He's dead. And good riddance. Good riddance. The devastation and the destruction he causes, unlike almost anything that has happened to us as a country, as a people, and definitely in the state of Texas. The devastation that he caused. Children that young and that many. Good riddance. But that's not him. But they have to have somebody. So what do? They give you an animation that looks like that. Which, as we know, we had to bring a witness. We had to bring Claudia to tell you and to show you. Look, you'll see him. He's walking right there. And you see him walking in between those cars, and he stays there. Now, in a few seconds, you're going to see Adrian's car drive by. His head kind of popped down when it happens.
The worst camera ever, the potato, as Ian said.
He's going right there. You see the white car is flashing right through. That's Adrian driving by him between the cars. So what would an honest rendition of what you just saw, what Claudia testified, what does an honest rendition of that look like? It looks like that. That's what that animation should have looked like. Because we have actual proof. And Ranger Hill can't act like he didn't know that existed. He told you about the puff of smoke. That's the same video he's looking at. He knows that this guy's between the cars. But he told y'all, they sponsored it, that he was here. Why are they doing that? Because they're willing to twist things. They're willing to twist things for you guys in order for you to do their bidding. But those kids aren't honored by an injustice in their name. They're not. It's not honored by a conviction in their name.
And first the window going out and then 111. Melanie Flores is still urging Adrian Gonzales to go in. She sees the shot come through the window. Adrian Gonzales tells the police that shoots the shot go through the window. Adrian Gonzales gets on the radio and says, guys, I think he's made it in the building.
See, that's what they told you at the beginning. They told you that Adrian Gonzales got on the radio and said, guys, I think he's made it in the building. Why are they telling you that? Because they want you to believe that he had that knowledge early, that he knew that he was in the building. What else did he say? In the opening statement, the Melody Flores saw the gunshot go through the window. When she testified, she said, I didn't see that. Why is it important? It's because Coronado radio, we've talked about it. And I feel like it keeps going into a memory hole every time it goes back over here. Right here, Coronado says, guys, I think he made it in the building. He established that. He said, he's the guy on the radio. He's the guy that thinks. Even Ranger Hill said, Coronado is the one who said that. Why did he say that? Because these three saw him do it. Because these three had line of sight. And he's radioing that around. And one thing we were clear to point out is that a gunshot did go off at the exact same time as that transmission. Why is that important? Because we don't know who heard that or who didn't. We don't know who heard Coronado go out and say that he's in the building. But we know that Coronado knew that or said that. And so that's the knowledge he has when he's driving around. Why is that important? Because prosecution, what have they tried to make you think? Coronado knew immediately that the gunshot fire was coming from the building. Coronado knew immediately that. Look at Coronado. He knew it immediately. Of course he did. He saw him with the building on the side. He knew it from here. Once he came around here.
Actually, that's not admitted into evidence. There's no evidence that Coronado saw the shooter. There's no testimony of that or anything like that. So now he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what the lawyers say is not evidence. If the evidence based upon your recollection differs, rely on your own. You may proceed.
Well, and I can understand why they're trying to fight against that, because look, this is, what I'm saying is we know that he radioed. I think he's in the building. When he's on this side of the building going to the other side, we know why. He testified. I thought he was going through the building, which implies that he knows that he went in to the building. But they keep fighting against that because this, knowing that he's gone into the building on this side, all their training, what does it say? Go to the gunfire. Even Ranger Hill they're twisting everything. They're twisting it all around. Ranger Hill said, well, yes, going to the gunfire is going all the way around here to the other side of the building, from where you saw him enter and from where you heard and saw him shooting into the building. So that to them is going to the gunfire. That to them is following their training, exactly how they're supposed to. That to them is working to distract, delay, all the things they charged him with. Well, they're not charged because they did that, even though they watched this happen. Had to have. And then Mike Whitskill. Now, I thought this was interesting. Mike Whitskill, I mean, he's an interesting guy. He said, I'm here as an expert witness in training, right? He didn't have any opinion. This is the interesting thing.
I noticed that too.
They had every opportunity to have Mike Whitskill go, I trained this guy. And I've seen all this stuff that you've given me. And I reviewed all of these things. And Adrian Gonzales did not follow the training that I had. They had every opportunity to do that, and they didn't. They didn't ask him. He said, I didn't review anything. I don't have any opinion about whether or not Adrian Gonzales followed his training. In fact, you don't have any opinion at all. You don't have any real statement from anybody about whether or not he followed his training. And the things that you have from the officers are always with a caveat. Yes, you run to the gunfire if you know where it's coming from. If you don't know where it's coming from, you take cover and assess until you know where it is coming from. That's the first thing. You run towards the gunfire if you know where it's coming from. You look at their active shooter trainings. All the active shooter trainings involve them seeing the shooter and then going after the shooter, which makes sense. But they are prosecuting a person that they will have to admit, and they have admitted, and they've stipulated and never contested that Adrian never saw the shooter. I mean, he talked about the death by PowerPoint. In Adrian's 40-hour class that they were talking about, the 40-hour class he took, he said, look, we do 75-25, the practical versus the death by PowerPoint. I'll point out that, and you'll see that in the training that the prosecution mentioned about, well, Adrian taught a training. He facilitated a training. He did. There was somebody else who wrote the materials. There was somebody else who did it. And that's really what they kind of do. They have to facilitate for each other so that they can get their training out. But in these trainings that are happening, in the trainings that are going on, all of the trainings are training them to come in, have a rifle, come in, go in and be prepared to come in and do those things, and mainly to come in and see the shooter. Mainly to come in and know where the shots and the shooter is happening. And what they have done is they have just said, oh, we don't care. Yeah, he said he didn't know where the shooter was. We don't believe him. We believe everybody else. Everybody else gets a pass. Everybody else. Randy Hill gets a pass. Saucedo gets a pass. Well, yeah. Saucedo said, I think I see him, permission to shoot. Well, we don't believe he said that. Or if he did say that, he had kids behind him, so he shouldn't shoot. That's crazy. That's crazy. Talking about this backdrop, that's crazy. And if that's the case, these officers are being overtrained on backdrop, because you do not fail to shoot a mass murderer of children because there's a backdrop where you could potentially shoot a child. You don't do that. You have to take that shot. And so if that's what they're saying, well, no, Saucedo has a reason why, because there's this backdrop. But then we pointed out, well, if Adrian did what they were asking him to do and came around here, we know now that by the time he transmitted, the guy's in the school, so he would have come around and nobody would be there. Thank you. But even if he came around and somebody was there, shooting back here that's his backdrop too. But nope, not for him. No excuse we make for every other person there applies to him. And I think that there's something fundamental in each one of us. I think it's fundamental in each one of you that that's not fair. I think it's fundamental that that's not how justice is supposed to be done. It's not. It is not fair. It's not how justice is done, that they can do that and interpret every fact against him, but for everybody else, similarly situated or better situated. He agrees it takes 10,000 hours of practice to reach expertise. I mean, these are not experts. Adrian is not a SWAT expert. He is not an active shooter expert, right? He is doing the best he can. And this was obviously the worst situation of his or any of their law enforcement lives. 5 minutes to dress like one, 5 years to be one. I mean, it's the training is so extensive, and it's much, much more than Mike Whitskill gave 40 hours on that day. And then they talk about, well, you stop the killing, stop the dying. They never tell you how when he's training. They never say how. They never say, how do you do it? How do you do it if it's just you and a gun and they have a rifle and you're in an open field? They don't say how. They just say, do it. Go in, win the game. Now, this is what in his instructor course, CME does not endorse nor encourage going it alone. See, what I'm saying is that these are sending mixed messages to the people who are being trained. They're reading this. They're seeing it. And then when you're talking about beyond a reasonable doubt on count 2, did he follow his training? It's like, even in the training, they're telling you, well, you should go in, but we don't endorse, we don't encourage it. Because having greater numbers significantly improves a first responder's odds for success. Now, what does that mean? Odds for success. Because what they keep saying is that there's a continuum of life scale, and there's a priority of life scale, right? And then proof success. This is not saying odds for success, meaning odds that I stay alive as an officer. Odds for success in being able to protect civilians. Odds for success in being able to actually do this. Because if you try to just run in and you don't have any of that, that shooter, remember the shield comes in when they finally came in, pop, 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 he's putting it right on the shield. The guy in the back of the stick, he comes in, shot in the head. That guy was ready. And anybody who approached that door was dead at the door. They were dead at that door. So what they're saying is the numbers improve the first responders' odds for success in saving lives, because a dead police officer is protecting no one. And that's what his training says. That's the person they brought you to say what his training was. That's what the training says. So they're sending mixed messages to these officers. And then if you better read the mixed message the right way, or the way they want you to read it, otherwise you're in this chair. It's not right. We saw the training pictures. This is how they're training to respond to active shooter. You got 2 people, you got rifles, they're coming in together, they're coming in different ways. That's how they're training. But that's not how it was. And we said in those hundreds of pictures, they didn't bring you one picture where they're coming in with all they got is a gun. All they got is a handgun. Not one in the hundreds that they took at that training. Because they're training these officers to have the right equipment. Adrian didn't, because the school district didn't buy it. Bailouts, we talked about it. Why is it important? Because everybody is responding strangely to this thing because of this red. They all think, they're going, well, it's okay that Coronado and them thought, well, this guy's running through the school because it's a bailout and he's just trying to get away from us. But it's not okay that Adrian thought that that could happen. It's not okay if Adrian's standing here going, well, these guys are here and I'm here and I don't know where these shots are coming from, but he's probably trying to go here. I still have a whole school down here. It's not okay if Adrian thought bailout, no, he didn't follow his training. What Adrian said, he cooperated every time. Remember, this is a day later, and you know he's experiencing time compression. You know he's doing that because he's saying, I hear the shots. She's telling me I radio it out. That's not how it happened. So he's going through the same problems that we've talked about in all the other witnesses having to recount and recall what happened. He's having that same issue. He drove to the danger. And Nico will talk more about it. And then hindsight bias. And here's the thing that they keep trying to get him on. They go, because hindsight bias for Adrian is when he's telling the story about what happened, he says, yes, it was a female. It was a coach. Because he now knows that that's the truth. At the time, though, he did not know that. At the time, he didn't think it was a woman. He thought it was the shooter at the time. But when he's telling the story, he's now telling it in a way, using the knowledge that he has, and he's explaining the story. And the same thing goes for when he's talking about what Melody Flores told him. When he's talking about what he understood, he did eventually understand what she was communicating and communicated it out. But in hindsight bias, he's not going through with the ranger, and the ranger's not asking, was she clear about it? Do we know beyond, did you know beyond a reasonable doubt when you got out of the car that she said that he's over there and you knew exactly where it was? He didn't follow up with any of that. So what Adrian's doing at the time of interview is he's skipping all that stuff. And he's getting to, I figured out what she was trying to say, and I communicated it down on the radio. He skipped it all because nobody's asking him. Because when they interviewed him, they're not prosecuting him. They don't think he did anything wrong. Nobody does. Nobody does. So years later, after all of this, they had somebody's got to go in that chair. So ultimately, it's the same thing I said from the beginning. You know, I told my kid, and so I'm here, I'm helping this man. But I can't be the only one, and Nico can't be the only one, and Gary can't be the only one who needs your help too. Y'all are all citizens, and he needs you. He needs you to look at these facts as you have. Y'all have been very attentive, and y'all have to see very horrible things and hear horrible things. A lot of those things didn't have anything to do with those 3 minutes. Why did they bring it? You know why they brought it. You know why they tried to do it. The horror can make you so angry with him that you convict him. They played on your emotions. They presented all that in front of them. They're trying to do all of that, but they're not really going to what Adrian was experiencing and thinking and feeling on that day. But the one thing you do know, he went up that hallway. The one thing you do know, he went after somebody he thought was the gunman. That man didn't just stand by. He acted, except they just ignore all of his actions because they're trying to pretzel it, massage it, get it in there, do anything that they can to get the conviction. It's the most horrible thing, one of the most horrible things ever. One of the most horrible things that's ever happened in this state. But those kids are not served. The memory of those children that I agree should be honored is not honored by an injustice in their name. It's not. And so we're asking you to find him not guilty.
Goss took me by
Ladies and gentlemen,
surprise
the jury,
there.
we had discussed prior to beginning the argument to take a break at some point, and everybody agreed this would be a good time to do it. So take 10 minutes and we will resume the arguments. But do it as quickly as you can. We'll be in recess for 10 minutes. Remember my instructions, do not discuss the case.
Taking a little break. I'm just gonna, well, I guess I won't leave it on. He's just giving them the same old instructions. Don't discuss the case and so forth. I'm impressed with Mr. Goss. He did a lot better than I thought he was going to. So a couple things that stood out from the charge conference. Reiterated, they don't get their notes in there, guys. They don't get their notes. But part of the reason why they don't get their notes is because if they are in disagreement about what they remember, they can ask for the testimony to be read back. Some courts allow that, some courts don't. We saw in Karen Reed's case, judge told them very specifically, you're not going to get to hear the evidence again. You know, you're not going to get to hear the testimony again. You've got to rely on your memories and your notes. Not the case in Texas, but there's going to be a process they have to go through to have the testimony read back. They have to send a note. It has to be from the juror foreperson. It has to say that there is a dispute about what the testimony was. And they have to specifically ID the witness whose testimony they want to have read back. I wonder if they'll get to watch it on the live stream since they have it. Can they just watch it back? I don't know. Possibly. So it is kind of helpful to know that, I guess. So then corrected some of those things we saw in the indictment. They must have filed an amended indictment where they changed some of those ands to ors, and they brought in this witness one being advised by witness one as to the shooter's general location. And then the duty, we got some clarification on the duty, the nature of the duty. So I went ahead and found what that was. It starts with, let me pull it up here. This one right here. Conduct of the police officers is to be, oh wait, hang on. This one here. The duty to prevent injury whenever in the presence of a peace officer or within his view, one person is about to commit an offense against the person or property of another, including the person or property of his spouse, or injure himself. It is his duty to prevent it And for this purpose, he may summon any number of the citizens of his county to his aid. He must use the amount of force necessary to prevent the commission of the offense and no greater. Well, that's pretty explicit, isn't it? He's got a duty. He's got a duty to prevent it. So, yeah, in the presence, defense is focusing on that in their closing. Seems to be the reasonable place to focus. And then this other one over here, that as to the threats, same thing, very explicit. It's the duty of every peace officer. Is he a peace officer? Then he's got this duty. If he's been in. Okay, bad ad. When he may have been informed in any manner that a threat has been made by one person to do some injury to himself or to the person or property of another, his duty to prevent the threatened injury if within his power. Very explicit. So that kind of resolves my questions and or concerns about what exactly is the duty here. They had litigated it pre-trial. Didn't see any of that. Came up in the instructions argument yesterday. Found this case. It's like, hey, I didn't realize we were kind of operating within the framework of a duty, but there's this case that says, like, yeah, under this child endangerment statute, you have to have some kind of duty. Prosecution's arguing the school doesn't have a duty. The case law says if you've got care, custody, or control of the children, and a lot of these cases that I happen to look through involve things like we looked at one that involved the grandfather who's like the babysitter for the kids. He's not their custodial parent, but the parent left them with you to take care of them. And you assume the care of them. So he had the responsibility. He could be prosecuted for not rendering medical care to that child. I don't know how you're going to tell me that the school where the children are legally obligated to be, they are required to go to school. School attendance is compulsory in the United States. They have to be there. And they are there all day. And the teachers tell them what to do and where to do it. You're gonna try to tell me the teachers, the school doesn't have the care of those children, so they don't have a duty? That was not a good argument for me, but I'm getting a little bit ahead of myself. So the duty, I thought, was clarified. Very helpful to have that spelled up, and for them to give me the citation. I love when they'll just give me the law. Go check. Go look for myself. That's what it is. Seems pretty crystal clear. Legislature chose to impose that duty on them, so not really an issue from a legal standpoint, as far as I can tell. I noticed the judge has the same terrible gringo accent that I do when trying to read out the Mexican names. You know, so sometimes you'll be able to pull off the accent, but sometimes you will not. But he tried. I did appreciate that. He did try. He's not going to have the mellifluous pronunciation of Nico LaHood. Nico's is just glorious hearing him say the names. I try, like I'm trying to mimic him. Coronado, Mendoza, Sosero. I can't quite do it. It's just like something about how he shapes the sound is perfect. Judge doesn't have it. I don't have it. But I appreciate him trying and giving a little bit of honor to the legacy of those kids, because, you know, I do kind of think it matters a little bit. Saw in kind of some of the commentary about the case, the fact that, yeah, these are mostly Latino kids, probably mostly Mexican, you know, ethnicity, origin, given where they are. And not necessarily going to get all of the outrage and sympathy and so forth as other kids. Is that playing into why they're doing this prosecution? I don't know. You know, I don't know. But I appreciated that they are kind of honoring that aspect of the children as best as you can. So that closing from the state. I don't think it was prudent to start with Abraham Lincoln's quote about it being as much the duty of the government to render prompt justice against itself as against for the public, because it's saying that the government needs to be reflective about its powers. And I think you need to turn that on yourself. I think this is a doctor heal thyself kind of moment. Have you applied that to yourself in your decision to put these witnesses on, to expose these jurors to this horror for what? To make this call that this one guy out of everybody who was there, everybody who had different opportunities to do different things, he's the one that needs to be sitting in the chair. I'm just not sure that really landed. You better hope, if you're going to start like that the jury is already looking at the case the way that you are, or I think that's going to go real sideways. It's going to be real off-putting. It was like instantly off-putting to me. Consider applying that standard to yourself. It's literally saying the government needs to apply the standards to itself, and you should take that to heart. Very much a do as I do, do as I say, not as I do kind of situation, in my view. He talked about the message that this sends. Now, that's objectionable, at least in Washington. The send a message type of argument, extremely objectionable, because the jury is not supposed to be thinking about what's the message this sends. They're supposed to be thinking about, has the prosecution met its burden of proof beyond a reasonable doubt? This would be super, super objectionable in Washington. It's misconduct. It's well-established misconduct. You do not get to argue about what message it sends. So that jumped right out at me, the fact that he makes that argument, but also that they didn't object to it. Maybe it's different in Texas. I don't know. I'd be kind of surprised if it was. But his argument is, if you don't convict, then you're saying this is okay for police to act. And I'm not sure that conclusion follows, because there's lots of ways of holding people accountable besides criminally convicting them. There's lawsuits, there's employment consequences, there's just public humiliation and shame that this guy is going to face no matter what happens here, legally speaking. You know, you're going to go through the rest of your life with the taint of something like this. I still have it for the Parkland guy, even though now I've kind of figured out rationally, oh, the facts probably aren't like what I maybe, would imagine they are. But I still have that, like, just off-putting. Probably need to go watch that trial now and educate myself. Well, it looks like they're already coming back. No sound yet, but we'll be ready for it. He brought up causation, and
Okay, be seated in the courtroom, please.
So now we go to Nico.
All right, members of the jury, when we recess, the defense was in its closing argument. You may proceed.
Closing counsel. I think what we're all struggling with is, how could one person do such a horrific and evil act to those children? And it's real. I mean, we're all thinking it. We're not immune from it. Everyone's thinking that. And the issue is that generates emotion. This has been an emotional trial. I can only imagine what it is to the families, and I'm going to talk about that in a second. I know it's been emotional for you. We've been watching you, rightfully so. It's been emotional to you. It's been emotional to us as well. Do you not think that burly man when he goes home and he gave you that story about his son, that he's not digging his face in his chest, weeping? I have permission to say this because he did. Weeping. Do you not think that Gary, when he's doing FaceTime with his twins, that he stays on a little bit longer or lets them call past their bedtime so he can talk to them, never knowing if that's that last time? Do you not think that Michelle doesn't rush home to go to her granddaughter's games? Because she does. It's emotional for all of us. Or Joseph, and he gets away and disappears at the house that we're staying in because he wants to talk to his children, making sure they're okay. I shared with you in jury selection the journey my parents went on and my family went on with the murder of my brother in our driveway. Do you not think that when I close my eyes that I don't rethink picking up my mom off the ground in our driveway, loading my brother's body on the gurney after they finished the investigation and helping my pop wash off my brother's blood in our driveway? There's nothing like a mama's cry. Nothing like a mom's cry. You can't explain it. It nothing compares to it. And that's real. We don't ignore that. It's never been us against the family. It's never been Adrian against the family. It's been a pursuit for truth. Remember the totality of the circumstances? It's a pursuit for truth. And because this has been so emotional, the only way that can be dealt with in a justice system is through a jury trial. I love a jury trial. I love the justice system. Thomas Jefferson, as we talked about in jury selection, we talked about Thomas Jefferson. This has a little bit of a delay. I consider trial by jury as the only anchor ever yet imagined by man, by which the government can be held to the principles of its constitution. One of our founding fathers believed that. I do. In a system of the people, by the people, and for the people, you're the equalizer. You're the one that has the final say. With all due respect to the judge, who I respect very much, not him, not the bailiffs, not the government for sure, not even the defense. It's you. It's the people. And that's why I love a jury trial. And it deals with the emotion. It's the only way to balance this emotion and reason. And I say this respectfully as I can. They're trying to hijack your emotion to circumvent your reason.
You make it all
That's what they're
hijack.
trying to do. But they're your emotions, but they're being hijacked. We know that. So how do you deal with that? Because in a world where we don't agree on anything, we definitely don't agree on politics. We don't agree on worldview and religion. We don't agree on definitions. Most people agree, no matter where you're at, most people agree that we don't want innocent people convicted and punished. Most people agree on that. And the only way we do that is through the justice system. And the representative of that is Lady Justice. She represents the justice system, not Lady Liberty, it's Lady Justice. And this comes back from the Greek times, the Roman times, where there was a polytheistic society and there was Greek gods. And she was the god. I don't believe in Greek gods or goddesses, but she was the goddess of order. The justice system is supposed to bring order to a society. And everything means something on this symbol, right? The blindfold means something. She doesn't look at politics. She doesn't look on whether you're a Hindu or Buddhist or Islamic or atheist or agnostic or that I'm a Christian. She doesn't look at any of that stuff. What she does is she tries to get the facts and the law and merge them together to reach this elusive concept called justice. The sword. The sword represents strength. The justice system has to be strong. There's something called the death penalty and life imprisonment. That's in the justice system. So the justice system should have a sword aspect to it. And then her foot's on a book, because you have to have a command of the law, right? You have to know the law and have a commandment to dispense it properly. And her foot is on the book as she controls the law. And regardless of your religion or your worldview, the universal symbol of a serpent is evil. And the justice system should smash out evil in a society, true evil in a society. But yet she has those scales. And these scales are important. These scales say, I don't care about those cameras. These scales say, I don't care about the false narrative that's been out there. These scales say, I don't care about all the resources of the government. The scales even say, it doesn't even matter what the judge thinks. The scales says is we have to balance all that out, look at everything, and come find this concept called justice. And I love it. I love her. I loved her when I was a DA myself in Bexar County, as we talked about, when I made death penalty decisions. when Jason and I were prosecuting murders. I loved it. I love it as a defense attorney, sitting at that table, either defending people innocent like Adrian of an allegation by the government with all the resources. I love it. And in a world that has this dichotomy and this battle, the justice system brings us all together with a blindfold, not made of mesh, and not lifted up when it's convenient. It stays on the whole time. And so this is the point, though. This is the point in a trial, in a jury trial, and this is the point in our justice system, where Lady Justice takes the scales and she hands them to you. And now you have them. And that's what we're arguing to you. And that's what we've presented to you. And so all of this gets me to a point of where I'm in a dilemma. Let me tell you what my dilemma is. My dilemma is that I'm a passionate person, if you haven't noticed. And my passion, I think, can be a strength, but can also be a weakness. And so I wonder to myself, if I look like I haven't slept, it's because I haven't. Did I do too much? Was I too passionate? Was I too aggressive? Or did I not do enough? Did I not ask the right questions? Should I have gone even harder? And I struggle with that. But my dilemma is I can't apologize for it. And I won't be fake. And I won't tell you something that I don't believe. I haven't done that since jury selection. I won't start now. And so I can't apologize for it. And because I can't apologize for it, all I can do is ask you for grace. Just extend some grace to me. So if I've done anything, if Jason's done anything, if Gary's done anything to offend you, please, you don't have to, now you have to, please hold it against me or Jason or Gary, not against Adrian, okay? So that's what I'm asking you to do for us. And so we have to look at things, because what came up during the trial, and at the beginning when I told you, is there was a concept called totality of the circumstances, right? This case, ultimately, we're going to consider everything, allegedly. We want you to consider everything, but this case boils down truly to 1 minute and 48 seconds. Not 3.5 minutes, not 77 minutes, to 1 minute and 48 seconds. And it came up during the trial. And so Jason talked to, how do we know that? I'm not making that up. I'm going to their charging document. I'm going to their instrument that they charged Adrian. It goes up until after the shooter entered the room, 111 and 112. Until after the active shooter shot at one or more, one child or children in rooms 111. So it's from when Adrian showed up at the scene as the shooter is there, and until that shooter goes into those rooms and does what he did to those children. So we have times on that. That's what I'm saying. We have times. We know. Remember this? It's over here, but we took a picture of it. So Adrian parks. It's not contested. Adrian parks at 11:31:55. He parks. We'll talk about what he was responding to and how other people responded and how Adrian responded as he's going to what he thought was the danger. And we'll talk about shots fired. That's true. He calls shots fired because he hears them himself, but he parks at 11:31:55. He's not at 11:31:55 knows what's going on. At 11:31:55, he doesn't have a full concept of what's happening. He just parks at 11:31:55. And the shooter enters the building at 11:32:58. That's 1 minute and 3 seconds. And then some time goes by, 22 seconds later, he's shooting at those doors, and then 20 seconds later, he's in. If you add it all up, it's 1 minute and 48 seconds. That's what their indictment says. It's not 3.5 minutes. It's 1 minute and 48 seconds. Parked, enter the building. That's it. And then there's 22 seconds later, and then he enters again. 11:33:43. This is when he enters room 111. This is where we get the extra 45 seconds. And that's why I say 1 minute and 48 seconds. I'm going by facts that you've heard. They're charging that no one's making things up on our side. Okay? I don't know what happened there. Give me 1 second. It held down on purpose. I'm trying. Give me 1 second, guys. Okay. So here's what the government wants you to compare Adrian's actions to others. So let's do that. And that's all we were doing during the trial. We were asking questions. We got permission. I mean, Mr. Espinosa sat to your right, and then Mr. Starbeck over your right shoulder, sir. And we asked everybody permission. For where you were sitting, Mr. Pena was between you two. And we remember in jury selection, we talked about that. And we got permission from you to be able to ask tough questions, even about sensitive matters. We did. And everyone said yes. So let's compare some actions. We're going to compare the actions of Mendoza, Saucedo, Coronado, and eventually Hill. And yes, they could figure that out during trial. So of course we're going to talk about it. So just to lay the ground, you guys know this already. So here's an aerial view. We can't even see Adrian's car. It's so much to the southeast side. But Coronado, Mendoza, Saucedo are on this side, a little bit outside of it. You've seen this picture multiple times. This is the scene. Here's a better view. We can see Adrian's car way over here. He's driving into the eye of the storm. Many witnesses said that. He drive all the way to the back. And then we had those 3 officers still at the corner. Here's the west door, and here's where the shooter was shooting. We have evidence of that, and he enters this door at 11:32:48. So let's compare Adrian and Officer Mendoza. Adrian drove into danger. Officer Mendoza stayed away at the perimeter. Adrian had no line of sight, not contested. Christina's not going to come up here and tell you that he had line of sight. Mendoza was the same side. He was on the same side as the shooter. Adrian was alone. Mendoza had backup. Adrian was one of the first 5 in the building. Remember, we're going to talk about that first 5 because Joe Vasquez and others talked about that first 5 and what they did and what they potentially prevented. Mendoza enters the east door at 11. The east door, even though he's on the west side, the east door at 11:42:48. But before that, he drives away, not towards the gunfire. When he's facing the door, when he's looking, when he has backup, and someone has an AR-15, we're going to talk about Saucedo next. He drives away, not towards the gunfire. Remember that pretzel that Jason's talking about? There's one of them. Let's do some more comparisons because they're going to compare Adrian to everybody else. Adrian and Officer Saucedo. Adrian drove into danger. Officer Saucedo stayed away at the perimeter. Adrian, no line of sight. Saucedo saw the shooter, and we're going to look at the video in a second, and asked to shoot. Adrian, alone. Saucedo, God bless you, has backup. Adrian has a handgun only. Saucedo has an AR-15 rifle. Adrian, one of the first 5 in the building. Saucedo never goes in the building.
Never went in.
After having line of sight, opportunity, and ability to do something, and he doesn't. He never goes in the building. And he also drives away, not towards the gunfire. But let's look at this. This is the dashboard of Coronado. Here's the sergeant. Mendoza's here. They set up perimeter. They're acting as if they're being shot at, but there's no evidence. There's no defects. There's no objective evidence they got shot at. Here's Saucedo. There's a long rifle. Watch his behavior. Watch him aim. And watch him do this point. He's there. He's there. There he is. He had aimed him. He saw. He's pointing at him. He's there. And then they saw him walk into the building, so they leave. We're coming back to this video.
There's no evidence that's a misstatement of the facts, Your Honor.
No, it's not,
I'm
Judge.
going to object. I want it on the record that he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what they say in argument's not evidence. If it differs from your own recollection or rely on your own, you may proceed.
It's in evidence, guys. I asked questions. I was very specific about questions. I gave people opportunities to talk. I wasn't trying to be a bulldog on anybody. Maybe you can think I was on Ranger Hill, and we'll talk about that in a second. But we're just asking. We're just asking questions, specific questions, not general ones. Okay. So let's talk about Officer Coronado, Sergeant Coronado. Adrian drove into danger. Sarge stayed away at the perimeter. Adrian, no line of sight. Sarge, same side as the shooter. Adrian, alone. Coronado has backup. Adrian, frantic witness he was dealing with. Coronado, frantic witness he was dealing with Claudia. Remember that? We're gonna look at the video again, and you'll see it. Adrian, unfortunately, and again, we're not ragging on her, okay? You saw me cross her. But she was wrong, and we'll talk about so many things that she was inaccurate about. A frantic witness that was wrong and inaccurate because she was on the wrong side of this issue. But the frantic witness, Claudia, the sergeant, on the same side, was accurate. Because you know why? Because she said, he went in the building. He went in the building. And you see the video yourself that they're acting like they knew he went in the building. Because you don't go from this thinking you're being shot at to this unless you know that the danger is gone and they're in the building. You saw the video yourself. We're going to watch it again. Sergeant Coronado unfortunately drives away, not towards the gunfire. So now listen, now we're going to watch it again, but now we're going to focus on Sergeant Coronado, okay? This is him again. We already looked at Saucedo's behavior. Look who he's talking to. He's yelling at somebody, and that's Claudia. You go inside, okay, what? They're talking. She testified. I told them he went in the building. And guess what? He acts like he knew he went in the building. Because you don't go from ducking like that to watch his car drive off. Watch all of them. They all know he went in the building. They don't believe what they're trying to prosecute. There's no way. Our defense is not, well, if you're going to prosecute Adrian, prosecute other people. They don't believe it themselves. You can't. I'm going to go through a list in a little while of all the things that they're going to have to, Christina, with all due respect, is going to have to come up here and tell you to ignore to get to the man at the bottom of the totem pole. I'm going to show you that list, and I'll be right. With humbly, but I'll be right. Where's Randy Hill? I know it bothers them because he's the one dispatched. Why didn't they call him? Why didn't they call Saucedo? So we can ask them questions and bring you answers. The government has all the resources, all the rangers, this whole road. They had the whole government of Texas and all the resources to bring you evidence. And we expect that of them. Where's Randy Hill? Where's Mendoza? Where's Saucedo? None of them. The only reason why they brought Coronado is because they wanted that video in. He's dispatched at 11:29:36, 3 minutes before the shooter enters into the building. What was 911 told? That is another aspect of the bill, and Bill's right. I mean, he could hear. He's an intelligent man, and tremendous respect for him. But he heard our questions. I mean, that's a factor. If we're looking at the totality, what were they told? What information did they all have? Someone shooting a gun. This is what Mr. Limon is told, dispatch. They just shot at us. He's shooting at the school. That wasn't relayed to anybody. He's jumping into the schoolyard. Wasn't relayed to anybody. He's just jumped over the fence. Still wasn't relayed to anybody. He's running towards the school. Nobody knew that, but that nobody knew that includes Adrian. That includes Adrian. He's wearing black. No one knew that. That would have been helpful to know. But we know for sure, and I know Ranger Hill's here. He can come sit right here if he wants to. I asked him, you don't know, I know when he showed up on the scene. You do? It wasn't in your critical timeline. Well, it's in a different timeline that he gave to them, that didn't give to us. Interesting. But so in his critical timeline that he didn't review for 3 years before he sat in front of you and testified to this, he said that that's all that's in his critical timeline, not when Randy Hill supposedly showed up, because Randy Hill didn't check in at location. Let me know what's going on. Nothing. No communication. So all we have in the first critical timeline is this. Randy Hill at 11:33:32. Just standing there. Said, did you hear how difficult it was for him to try to make up an excuse for what Randy Hill's behavior was? Did you hear how difficult it was? Because you couldn't objectively do it. Not based off Nico's standards or Jason's standards, just training standards, tactics. I asked them tactical questions. How does this make sense? Well, he was just there momentarily. Where's that? I don't understand where you're getting this from. What we know for sure is that Sergeant Coronado is driving around the school, and there's Randy Hill. He's already out of his car. He's been there for a little while. I don't know how much it is. The ranger thought he knew. I don't know how. But there he is, setting up perimeter when nobody's asked him to set up perimeter. Oh, they said there's a dispatch, again, that we didn't get from an unknown person. Remember that exchange? Figure it out.
Again, object. This is misleading the jury, and he's having them believe that we did not turn over everything to him, and it's
Okay. Overruled.
Sit down.
I was just asking questions based off the evidence that we were looking at. I let him, what are you looking at? So I can ask you about what you have in front of you. There was no trick question, no gotcha. I told him I'm not going to question your character, but I will question your opinion. I'm going to question your investigation. He knew that. He's coming before you after 3 years of all of this and the resources, 3 years, and that's what they brought you? That's the mortar to their case, Ranger Hill, bringing it all together in this critical timeline. Well, where's Randy Hill? We all want to hear from Randy Hill. And then we have a hero, a true hero, Joe Vasquez. You heard about Joe. I mean, he gave me permission to call him Joe. He called me whatever he wants to, but we went through scenarios. We went through breaching. We talked about when you breach an outward swinging door versus inward swinging door. Well, what did Joe tell us? At 11:56:28, he linked up with Lieutenant Gonzales, who briefed him. Very different when you're being briefed by fellow cops after the situation has already been assessed. Very different, but they want to conflate that to Adrian. Well, they did that. They listened to instructions. They moved in. We have 27 officers around with. Everybody has guns and helmets and vests on and AR-15s and said, here's what's going on. And oh, yeah, of course they're going to listen. That wasn't Adrian. I asked if he wanted me to make entry. He didn't do. He asked. He understands there's an order. He understands the danger of it. We talked about the danger of it and fatal funnels, and there was two of them. There was the hallway, and then there was the actual doorway. We talked about that. Response, no, we're trying to negotiate because we've been fired at. That's what he was told. Waited with Gonzales for a negotiating team and the TAC team. So a true hero. I hope you like Joe, because I like Joe. I mean, he waited. There was still sporadic shooting at times. We look at the timelines, the critical timeline that's kind of complete. But he waited with Gonzales for the negotiation and the TAC team. Should Joe be sitting in that chair? Is Joe a coward? Are board TAC a coward? Are all the other officers cowards? Eventually, board TAC showed up. It was a bit of a blur. He doesn't remember. A lot was going on. Then they had a planning. They planned the entry. How long did you wait there? I asked them that. They entered at 12:50:01, almost an hour after he arrived. So Joe Vasquez is a real hero. He thought his daughter was in there. Could have been in there because she went to school there. But he still waited an hour because he knows there's a pecking order. He knows there's a way. He understands fatal funnels. He said you're going to die at the door. That's what he said. We got that from Joe, not from us. And he waited because they were planning entry. Part of their training too. Waited 50 minutes, over 50 minutes. But board TAC was rehearsing and opening the door. And again, I'm not saying that's good or bad. That's what part of their training, because an open outward swinging doors is difficult and it's dangerous. But they had the equipment at that time. Adrian didn't. The first 5 didn't. Taking cover is reasonable. Then we asked them about Adrian's behavior because they didn't bring an expert, so we had to ask somebody, and we're going to ask somebody who's in law enforcement. Well, taking cover is reasonable if you don't know where the shots are coming from. From Joe, their witness. Containment. Remember I asked about containment? We talked about that. And he said, if those first 5 officers, we call them the first 5, if the first 5 hadn't contained the shooter, he could have done the same thing to the whole school. Think about that. When he didn't contain, he didn't do anything to distract or detain or to impede. That first 5 group held them in 111 and 112. And let me submit to you humbly. If it wasn't for that first 5, that person responsible, because I know I've called him an animal and I know I've called him a monster because he is. You know, you get the point. But if it wasn't for that first 5, what would have stopped him from finishing off those precious babies in 112? Was it a distraction? He knew there was talking. There's negotiating. He waiting for them. He wants to be a cop killer too. I mean, he wants to be a cop killer, so he's distracted. He's done damaging. He's done what he's done in 111. He did what he did in 112. But what would have stopped him to finish everybody off? The 5 outside, knowing that they could breach at any time. He doesn't know what they're doing. And he was waiting in that closet. He knows that closet, remember? 111 was his home room. He was going to 111. He went to school there. 111 was his home room. He knew that room. But even Joe Vasquez said, if those first 5 hadn't contained the shooter, and by the way, and I know it bothers them, Adrian's part of that first 5. And not that 3.5 minute that Christina's going to come up and argue, that minute and 48 seconds with no line of sight. Talking to the guy on the stick. He was talking to the guy on the stick. Remember that stick is the stack when they're breaching behind the shield? He said he couldn't hear me because I realized I was wearing a gas mask. He himself was experiencing perception distortion. He didn't even realize he had a gas mask on. There was no gas, but he put it on and he couldn't hear. And he's talking like, oh, what am I doing with this gas mask on? And so he took it off to talk, but he didn't realize it at the time. But everybody, it's okay for everybody else except for Adrian, because he's the man on the bottom on the totem pole. He's easy pickings. Except for you guys, to settle that. Now let's talk about Mel Flores. Look, I mean, if you couldn't tell that I had an affinity for her because she's a special ed teacher, then you weren't paying attention. I have a special needs son, and I told her that, and I appreciate that. And it takes a special person to spend 25 years teaching and taking care of and nurturing and stewarding special needs children. No one is attacking her character, but she came in almost 7 days after the event. She admitted she's watching these cameras and reading the stories and listening to talk, and that's human. That's normal. She wasn't given an order by the judge or anybody else not to talk to anybody, but that was influencing her talk. And so, but she's witness one. She's in their indictment, the training, and then witness one, based off what she said. She thought the shooter had a handgun. She was sure of it, but he didn't have a handgun. Did not see the windows break on the east side of the building. I could not see from where I was, but Bill, in opening statements, expected you to say that she did. Why? Because that puts Adrian in a disadvantaged position. But then the truth came out during cross-examination, right? Remember we talked about that in jury selection? The greatest vehicle ever invented to find the truth, I was taught, is cross-examination. It's in Proverbs as well. Because we had to, and we asked you, and I told you that direct examination for the government was going to be like a waltz, and then cross-examination was going to be like a dental visit, pulling teeth, and I think you saw that. It wasn't our intent. We can't control the way the witnesses respond, but some of them were very honest. State Exhibit 921 identifies the wrong PD. She identified the wrong PD vehicle. She identified Sergeant Page's vehicle. She ID'd Donald Page. Khaki pants, Adrian didn't have khaki pants on. Full beard, Adrian didn't have a full beard. You saw the interview. Short sleeves, white short sleeve shirt. Adrian wasn't wearing white short sleeve shirt. We believe she saw Sergeant Page, but she also testified that she was frantic. Yes, I was. Let me submit to you respectfully. Again, this is nothing against Ms. Flores. God bless her. Let me submit to you that you heard the 911 call from Mr. Limones. You heard Amy Marin's 911 call. Understandably, it's frantic in the background. You heard Claudia in the background of Mr. Limones' 911 call. Ms. Flores was more like that. Adrian's dealing with that type of franticness. Understandably, again, it's not a criticism, it's just an observation. He was pacing. Remember we talked about that? Assessing because you're shouting, yes, there's shouting, south entrance, west entrance, shots fired. And we'll talk about when he transmits something in a second at 11:32:59. She was with Adrian from 2 to 7 minutes. You can't cherry pick what you want to believe from her, Christina. You just can't do that. Or you shouldn't do that. It's not right. It's not fair. I mean, so we know it couldn't have been 7 minutes because the timelines don't work out. The stuff that we do know, it couldn't have been 7 minutes. But even if it's 2 minutes, it covers the 1 minute, 48 seconds that Adrian had no eyesight on the shooter. He had no opportunity. He didn't have the ability. He's with her. She's a victim/witness at the time, yelling, frantic, giving instructions. He's taking shots. He's looking around. He's taking cover. See, it's okay for everyone else to take cover but Adrian. For a minute, he can't take cover for a minute to observe, orient, decide, and then act. Remember their training? But she's going to have to come up here and tell you it's okay for Coronado, for Saucedo, and for Mendoza to take cover and then run from the shooting, run from the gunfire. Make a note, run from the gunfire, not run to the
Your
gunfire.
Honor, I'm going to object to the sidebar comment.
Sustained.
So she's going to have to argue that to you. And I don't know how you do it in good conscience. I just don't know how you do that. But 2 to 7 minutes, it's a big deal. That's a big deal because it came out in evidence, and you should consider that. And the reason why it's in the big deal, I want to say this because I asked Ranger Hill. I said, well, why isn't that in your timeline? Why didn't you know that information? I go, would that have been important? And he said, yes, it would have been important. So good for you for answering that way because it's true. It would have been important for him to assess critical, important, his definition, important timeline, 2 to 7 minutes with a witness/potential victim. It matters in your assessment of someone's behavior and what they didn't do and what they were actually doing. Excuse me. Shots being fired while with Adrian Gonzales. Yes, while they're together. So now he has somebody he has to protect as well. And himself and her, and think about it. He has no idea that this person's going, he doesn't know that. There's no evidence that he knew he was going in the building. He's going in the building, Adrian. There's no evidence of that. He couldn't even see this guy. And we said pacing could be taking cover. She says, I'm sure. Said the shooter went in the south door, but pointed to the west side. Yes, I did. And then in her interview, the investigator, the ranger, had to say he did not go in the south side. Oh, I really thought he did. And she was honest about it. I really thought she was mistaken. She just was inaccurate. At the time, he thought the shooter went in the south door, yes. Told him the 4th grade building. He said, what building? He doesn't even know that. He's not part of that. He's assigned to the high school. He didn't even know which building you're talking about. Yes, I just wasn't listening, she said, because there was a lot going on for her. That's understandable. Then said he's on the west side of the building. Yes. So south side entrance, west side building. Yes. Dialogue between you two was 2 to 7 minutes. Yes. So here we go. Adrian with her 2 to 7 minutes. Shots being fired while with Adrian. Yes. You say pacing could have been taking cover. Yes. Said shooter went in the south. Yes. At the time you thought the shooter went in the south door. I did. Yes. Told him 4th grade building. He said what building? Yes. So there's confusion there. Not confusion like he's confused. He's trying to figure things out. He doesn't even know where she doesn't even know where she's directing him to. And again, there's a lot going on for her. Dialogue, yes. I just wasn't listening. Now we have Ranger Nick Hill. And I'm sorry, Christina, I didn't mean to be disrespectful to you. I apologize. I'm gonna temper myself. I really believe, with all due respect, Ranger, I really do believe that Thomas Jefferson was talking about someone like Ranger Hill. And I'm saying that with him in the room. I consider trial by jury you as the only anchor ever yet imagined by man, by which the government, including him, the government, can be held to the principles of its constitution. And one of those principles is due process. You know what due process means? It means fundamental fair play. Fundamental fair play. Everybody gets it. Remember that blindfold? We don't do this. Doesn't apply to you, can apply to you, doesn't apply to you, sir, applies to you, ma'am. It doesn't work that way. That's not how Lady Justice operates. That's why she's so beautiful. She wears that blindfold at all time. I'm not going to go over all of Ranger Hill's testimony and our back and forth. And again, if I offended you by my question of him, please hold it against me. I can only ask you to do that and extend some grace to me. But like Jason said, this was his presentation to you in good conscience. This was. And if you had not known any better, if we didn't ask questions, if we didn't push back, you would think that the shooter was right there and the angels just drove right by him. That's it. And then he placed the shooter where the shells were, and then we went through the whole ejection thing. Remember that? And it was at versus towards, and can you look at two people, and how many fingers am I holding up? We went through a whole bunch of stuff, and I just asked him pretty simple questions. But that's how you presented it to you, and that's not the facts. Jason told you. We know that because we have some video. Grainy, yes, we have video. But more importantly,
grainy ass video.
He interviewed. He didn't review someone else's interview. He interviewed her. And not only does she, but also Mr. Limones and even Amy Marin loses the shooter in between cars. He's in between cars. That's where he should have been if he was going to present that to you, this animation. But the government sponsored him anyway. Now, whether they knew or didn't realize it, I don't know. I'm not inside their minds, and that's between them. But they sponsored him anyway. So what is Christina going to come here and say to you? 3 minutes. She'll say 3.5 maybe. Okay, because Bill kind of gave you the heads up on that. Didn't follow training. Well, Jason went over the training, so I asked him a lot of questions. I talked about tactics with him. He was a very, very nice man. He agreed. Just my opinion. I'm one opinion of many. These are suggestions. And I said, I understand. Thank you, sir. Very respectful. Didn't follow training. Then we showed you the training. We don't recommend going in alone. But we're not even saying Adrian made that conscious decision, by the way. We're talking about 1 minute, 48 seconds. Had an opportunity, best opportunity. I mean, Ranger Hill, over the three in the corner, said that Adrian had a better opportunity to stop that shooter than Coronado, Saucedo, and Mendoza. You're the judge of the credibility. That's why you're here. That's why I love the jury section, the jury trial. And here's what they're going to do. They didn't say it, but they're saying it. They're trying to feed you a coward sandwich. They want you to eat a big coward sandwich and say that Adrian's the one that gave it to you. The problem is, it is wrapped around 2 slices of bread of bravery. That's the problem. You have this coward sandwich, but you have bravery and bravery around it. The bravery of driving into trouble, thinking there was a shooter, Only one didn't set up perimeter, goes into the trouble, into the eye of the storm. And then he's one of the first 5 that goes in the building. Takes rounds, what Martinez does, takes rounds, and you saw the video. Adrian has his weapon out. He doesn't move. Paige is there. He's in the fatal funnel. All that shooter needed to do was turn this way and start shooting at them. He didn't run away. He only went outside when his radio didn't break, because the radios don't work inside of schools, which is interesting. And so then he had to go outside to call for SWAT, call for cover. Everybody's doing that. It's for the cover for the situation, not for him. That wasn't accurate. And then what Bill told you in opening is that Adrian, if you listen to Bill's opening, and again, this is respectfully, you would think that Adrian showed up and just stayed there and stood there. If you remember opening, I don't know if you do or don't, but that he just stood there and didn't do anything. And the evidence didn't play that out. The only thing Adrian remained in, he remained in danger. He went into the danger and remained. Once he figured things out, he went further into danger and remained. That's the only thing he remained in. And they're going to ask you to send the message. Jason couldn't help himself. He had to talk about it, and I understand. The problem is the message that will be sent is be Officer Hill. Set up perimeter, even though you're not asked to set up perimeter. Don't go in. Don't go into the eye of the storm. Don't even wait 30 minutes. Stand back. Don't do anything, because I don't want to be sitting in that chair. That's the message that will be sent. Not just to Uvalde County, but also to Nueces County, Bexar County, because people are watching. And that's the message that would be sent. That's not the message that needs to be sent. They need training. They need good training. They need proper training. They need resources. They need help from those schools to work with them in conjunction. And we'll talk about doors being locked here in a second. And all working synergistically together to protect the most precious thing we have in our community, and that's our children. No doubt about that. But to pick the man lowest on the totem pole and drag him into court and to come before you, there's a lot of things they're going to have to ask you to ignore. They're going to have to ask you to ignore inaccurate dispatch. They have to. I'm not saying it's their fault, but they're going to have to ask you to ignore it. They're going to have to ask you to ignore that Andrea drove into danger. Remember that sandwich? They're going to say, yeah, okay, the bread is fine, but the coward sandwich is full in the middle. And then, yeah, I understand the bread at the end is bravery, but we just want you to focus on what's in the middle. It's like an Oreo where you take off the up top. They want you to have the coward cream in the middle. Remained in danger. They're going to have to ignore.
No coward cream for me, please.
That you remained in danger. That he had no line of sight. They're going to have to ask you to ignore that. He never had a line of sight, but other officers did, not him. They're going to have to ask you to ignore that it was truly, because I looked at the indictment and we're looking at the facts. It's truly 1 minute and 48 seconds. They're going to have to ask you to ignore that. She's going to argue something different, and give her your attention, please. They're going to have to ask you to ignore that. They're going to have to ask you to ignore Mendoza, who showed up 27, 28 seconds after Adrian. That's it. That's the difference. He was there too, before the shooter made it in, with line of sight, with backup, with guns, with superior weapons. They're going to have to ask you to ignore Salcedo. Line of sight, never goes in, drives away. You saw the video yourself on the dash cam. They're going to have to ask you to ignore Sergeant Coronado. They're going to have to ask you to ignore Randy Hill. They're going to have to ask you to ignore building doors being unlocked. Everybody, Wixel, all of them, all the Rangers said if those doors were locked, it would have made a difference. Since time is of the essence, those doors being locked would have made a difference, because you had 3 officers on that side. You had 3 officers on the side, on the west side, one with an AR-15, getting instruction from Claudia. He's going in the building. They're right there. And if you would have been locked out, you don't think that would have made a difference? But they have to ask you to ignore that. I don't know what you do with the school board on that. That's not what this trial is about. But you have to ignore that. They're going to have to ask you to ignore that. But it's not that important. It's more about Adrian. The classroom door is being unlocked. I'm sorry for what Mr. Reyes went through, but that door was unlocked, and it should have been locked. That would have made a difference, a key difference. And you know what really made a difference? If that door was unlocked and those 3 officers in the corner followed the gunfire and made it in the west door, not drive around for whatever reason. You can talk about, I want to hear the excuse. Made it, and then the shooter's in the fatal funnel. This door's locked. Even if he got into the school, the classroom door's locked, and he starts shooting at the door. But then here's these 3 officers following their training, cutting the pie, getting with him, and then he's in the fatal funnel. That would have changed things. We can what if it all day long, but they're what ifing it, and they're asking you to make presumptions and speculate with Adrian, but they don't want to do it with anybody else. This is the hardest part of my job. Because I have to sit down and I can't talk anymore. It's not that I like talking, I just have a lot to say. I get it. You can ignore me, you can say I'm full of it, that's fine. You can tell me after. But because the state has, the government has this burden that Jason went over, the highest burden in our justice system, the burden that the government has to prove to take away someone's liberty and change the course of their family's lives and that person's lives. And it's a burden that we all agreed was appropriate for the government with all their resources to have. They get to go first and they get to go last. They gave us that sandwich. They gave us the burden of proof sandwich, okay? It's the other way around. And so I have to sit down and I can't talk. And please give Christina your attention. And she's gonna make arguments to you. And you're gonna see me in the corner and I'm not gonna be looking at her, but it's not to be disrespectful. I wanna give her a heads up. It's because I get frustrated because I wanna talk and I got an answer and I got a question and I have an argument. That's just my personality, for good or bad. That's just the way God wired me, okay? But I'm gonna be looking down and be writing notes and my legs are gonna be going 100 miles an hour. I already know. But you can ask yourself, not just what would Nico, Jason, or Gary say, but what did the evidence show, right? And I'm gonna do I promise you, I'm gonna do my best not to object during her closing. I will try. She can do it. I'm not offended by it. I'll do my best not to object, but listen to her, okay? And we're gonna ask you now, I'm asking you to apply this burden, the burden that's the highest in our justice system, the burden that says not sure is not guilty, the burden that says, no, you can't take the person from the bottom of the totem pole and move them up and ignore all these things. You can't ask me to ignore all those things, government. You can't. You can't ask me to ignore all those things and apply this high burden. The judge told you in the charge that if you have a doubt and it's reasonable, one doubt, and it's reasonable, it's a not guilty. Just one doubt. Did they eliminate every doubt from your mind? I hope that's not the standard. If it did, then I'll deal with it. It'll be horrible, but I'll deal with it. But that would shock me. Because that can't be the standard. That can't be the standard. That can't be the message, because she's going to come up and say, send a message. Well, but send a message also to the government. Send a message that, like Bill said in his closing, so we concentrated our case on the facts around Adrian Gonzales. Send a message, you can't do that. You can't pick and choose. You've been given authority to steward well. People in our community say, steward this well, government. A huge responsibility. This is not how you steward it well. And if you apply the burden by law, if you buy the facts objectively, if you can acknowledge two things at one time, if you can acknowledge that families have been destroyed, because she's going to make an emotional plea to you. Everyone's cried, and you'll probably cry again. It doesn't take away something that my family's gone through or what they've gone through. If you apply them objectively and do what our founding fathers expected juries to do, we're asking you now, and we're hoping that you'll pick a 4-man or 4-person, 4-woman, and do a quick verdict, and a quick verdict of not guilty. Because the evidence has shown he's not guilty, folks. Thank you, and God bless you.
State.
Thank you, Judge. I just wanted to, just a quick note that the judge is going to decide the punishment. I think that was made clear to y'all, but I don't know if it was confusing here with the closing statement. So I guess I'll kind of address quickly the idea that I bow to political pressure. There's no evidence in this case that I bow to political pressure. And I think if you remember in the opening statements, the defense talked about all these third-party investigations that went on in the opening. And the easiest thing would have been me to do what all those did, which is say, don't blame us, blame somebody else, or everybody's to blame, therefore you can't hold anybody responsible. That would have been the easiest thing. So, I've never bowed to political pressure.
Talking about making it about yourself.
That's not what it's about. The defendant, in their opening statement, they talked to you about, and they did here in the closing, that he was not assigned to the school. He relayed information. He drove to the school. He went into the building. He called for SWAT. He stood perimeter. He evacuated students. He had no shields. He checked on another officer. He got the building plans. He secured a master key. And there was even testimony during the trial that he evacuated students, and wasn't that a good thing? A good thing.
Was it not?
He relayed information over the radio, and wasn't that a good thing? Ladies and gentlemen, this is not about doing a good thing. I am not standing in front of you. In this case, it's not been about handing out participation trophies. That's not what this case is about. This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. Mr. Turner and I, as prosecutors, we have these big books that we're supposed to follow and the laws and all that. And he described to you that there's a special law in these books. One special law with regard to children. And that's what this case is about. All of this, the personal attacks, all of that was an attempt to justify the unjustifiable, in my mind. We're not talking about people being perfect. We're not talking about pretzels. And I'm not here to send mixed messages. I'm here to say that when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty. You know, when we had the active shooter training that was brought in, that active shooter training goes through all the mass shootings of schools back to Columbine. At the time that the Rob shooting happened, we've had, 23 years of mass shootings. And school districts have begun their own law enforcement police force. That's saying, we're not just going to depend on the local police department. We're not going to depend on the sheriff's office. This school district, the Uvalde Independent School District, we are going to have our own police force. So what does that mean? That means these buildings, they are their homes. Those hallways, there are their roads. Those students in those classrooms, those are their people to protect. Even Mr. Gonzales, the defendant, says that in his video recorded statement to the Rangers. He says, it was a car wreck, but that's not my responsibility. That's the local PD's responsibility. But when I heard that there was a gunman and he was near the school and entering the school, that's when I got in and went, because that's his jurisdiction. That school district, that's his jurisdiction. Those students are his people. The charge that you have talks about the legal duty that the law enforcement is supposed to be responsible for. And then it talks about the Texas Education Code. And that's because our legislature had mandated that. And we cannot turn a blind eye to that. You know, their own expert witness talked about being in San Antonio and how he went into hot situations. Ladies and gentlemen, I would argue to you there's nothing hotter than a gunman in a school. That's pretty hot in my book.
Nobody denied that.
And we have training. And he said, if you have training or you don't, you figure it out. This defendant had training. He even provided the training. He put on the training. The defense would have you ignore all of that, all the things that they say that he did and that he's the low man on the totem pole. No, he's not. He's the top man. He was the police officer for the school district that showed up first. And why do we go back to having school police officers since Columbine? Because on any given day, you can have a monster that makes his way into your school. On any given day. On any given day, they would have you believe that because there was a wreck outside the school, that confused me. I don't hold me responsible because, I directs too much. So not my day. They would have you believe that on any given day where we have bailouts in a community, bailouts happen all the time. I mean, even in large urban areas, you have people who outrun the police. But they want you to believe that because there were bailouts on this given day, but don't hold me responsible. Not my day, not my responsibility. They would have you believe that because he wasn't assigned to that particular school on any given day, don't hold me responsible. Not my day, not my responsibility. They would have you believe that because the doors weren't locked, it's not my responsibility. On that given day, the doors weren't locked, so not my day, not my responsibility. On any given day, I only had a pistol. He had a rifle, so it's not my day, it's not my responsibility. And then they would have us tell, the argument is because you had 3 other officers show up who believed that they were being shot at. Don't hold me responsible, because on any given day, if you've got 3 other people that showed up, it's not my day, it's not my responsibility.
This is missing the point.
And what strikes me so much in this case, and something that we believe the evidence has been brought to you that's going on, is the contrast in the training of the schools. If you think about it, since Columbine, the students have been taught, and you heard that, lock the door, lights out, be quiet. We are basically teaching these kids, and the kids in room 11 and room 12 were taught to practice for their impending death. You don't cry and you don't scream, but we're going to teach you what you do when a monster makes his way into the school. We're going to have you rehearse your own death. But yet, we have active shooter training that says to go to the fire that the defendant taught, but we're going to ignore that. Because on any given day, if he says, not my day, we're supposed to just look the other way. And I am sending a message, and I'm sorry if I'm repeating myself, because I want officers to know those days are over. We're not going to continue to teach children to rehearse their own death and not hold them to the training that's mandated by law. That when you hear the gunfire, you go to it. You go to the shots. You stop the dying, and you hold civilians, children, above yourself. You hold them, they're the highest priority of life. I think it's telling, and Mr. Turner touched this with you about the defendant's statement, and if you're going to get all the evidence to go back in there. He says in that statement, the teacher, she told me, he's over there, she pointed, he's over there, he's wearing all black. I think that statement is very telling, because in that statement, he says on 3 different occasions, I walked over there. I walked to the school. I walked. And you contrast that with Miss Flores, and what is she saying? I ran, and I tell him, we need to get in there. We need to get in there. She's not saying you go. She's saying we, because in her mind, I believe you can infer that those kids and the protection of those kids are still tantamount to her. And there's no evidence that she had active shooter training. There's no evidence that she taught active shooter training. She was just a teacher. So are we going to continue to hold teachers and students to a higher level of responsibility than we are going to hold police officers for school districts who raise their hand and say, I will be a police officer. Those hallways will be mine. Those children are my people. Those classrooms are my houses. I will protect them. Are we going to continue to do that? No.
No one said she had a duty to go
Because on any
in.
given day, you can be like Mr. Salinas and Miss Torres, who came in and testified to you. They dropped their children off for school that day, and the next time they saw their children, it was at the hospital. Mr. Salinas told you that the child that he dropped off for school that day is not the same child he picked up. Because on any given day, a monster can make his way into an elementary school. Miss Garcia testified that she dropped her child off for school. She went to the award ceremony, and her daughter wanted to come home with her. And she said, no, I paid $2 for that pizza party. You're going to go and have a good time. And then she never saw her daughter again. Because on any given day, that can happen. We know that. We see it. Nueces County is not any different from Uvalde County. It's just not. What happened to Uvalde on May 24th can happen anywhere at any time. And if it's going to happen, and if we have laws mandating what the responsibility of a law enforcement peace officer is for a school district, then we better be ready to back it up. You had the teachers come testify to you about what was going on. And what do we know about what the defendant had versus the children in rooms 111 and 112? The defendant had his car. It was on the corner building. He had cover. What did the children have? They had chairs and desks. Defendant had a pistol. What did the children have in rooms 111 and 112? They had unarmed teachers. The defendant had a vest on. And what did the children have in rooms 111 and 112? They had curtains to hide behind. I would also, if you get all the evidence back, that you listen to the defendant's statement. And I think it's always telling, is when that ranger asked him, why didn't you engage? Why didn't you go and approach? And the look on the defendant's face is like, not me. Really? I mean, it's like he catches himself because it wasn't his day. On any given day that this monster made his way to Robb Elementary, that wasn't his day.
So face reading is why he's guilty.
You heard a lot about the time compression, the auditory exclusion, the fatal funnel, the OODA loop, the echoing. You even heard about a fatal field. Because we all know on any given day, there may be a fatal field. And we have to be ready.
So how do you prepare for a fatal
You're
field?
going to get all the evidence behind you, sent back with you, and you'll have the radio traffic, and you can look at that and decide if it's 1 minute or 3 minutes. But even a minute and 48 seconds, what he put up here, a minute and 48 seconds. I don't know if anybody just sat still for a minute and 48 seconds. That's a very long time to distract, engage, and delay. And his backdrop was right here. All you had to do was to even attempt to distract, delay, or engage.
His backdrop was the other cops in the funeral home. And anybody in the parking lot.
I know this case is difficult, and it has been difficult. But we cannot continue to let children die in vain. We cannot. Nueces County is not any different from Uvalde County. We cannot let 19 children die in vain and another 10 to suffer. They're going to be suffering for a long time. On behalf of those 19 children, I respectfully request that after your deliberations, that you return a verdict of guilty. Thank you.
Okay, ladies and gentlemen of the jury, you will have the charge of the court back there. You'll have the evidence. I will ask you to deliberate and give us the word when you have a verdict, and we will alert everyone and give time to get people back in the courtroom, and we'll bring you out and receive the verdict. We're going to have lunch served in the jury room for you. You're welcome to deliberate while you're eating lunch. And could I ask the three alternates to remain? We're going to have them go back, and I'll talk to you further. Okay? So let everyone rise for the jury.
Well, that did not reply to the defense. It was really not a rebuttal argument.
Correctly. We are in recess, ladies and gentlemen. You can see it in the courtroom.
Just waiting to see if they're going to say anything else, but it looks like not. I'm going to go straight to verdict watch. Yeah, I am not expecting anything real rapid here. I know the defense asked for it. Nico asked for it. I don't think they're going to get it, even though this is not Uvalde. This is over in Corpus Christi. It's a different county, different jury. They're still going to want to show respect to these family members and what they suffered, and they're going to want to be very careful. And even if they are kind of all on the same page, which they may be, but they might not be. I mean, if they're roughly 80%, that means there's still a couple jurors who are on the opposite side. But even if they do all generally agree, they still want to look like they're being really careful, just because that's how you show respect. So we'll go ahead and, because I was just barely starting to recap kind of where everything started when we came back from the recess. So I'm just going to go ahead and start with the states. We already talked about the Abraham Lincoln quote. I don't think that was a good start, because it just is inviting the jury to consider, are you applying this standard to yourself? You are the government standing here telling us how great it is that the government can do justice against itself. You, the prosecutor, consider your judgment. And has this been fair? Has this been just? If we're not already on your side, that's going to be real off-putting. And you have no guarantee that the jury is already on your side. So it was a bold move. Bold move, starting with that quote. The send the message we talked about. Super objectionable, super improper where I am. Unquestionably prosecutorial misconduct. But they didn't object. Maybe it's by design. Maybe they think it helps. Maybe they think because they were able, the defense was able to respond to the state's argument in a way that the state was really not able to respond to the defense's. The defense thought, hey, we can turn this to our advantage. Yeah, think about the message. You know, maybe they think it works for them if that door is open and you want to talk about that. But I certainly notice the prosecution doing that because it's improper and it's cheap and it's exactly not what the jury is supposed to be basing their decision on. What kind of message would it send? Based on what? Based on perceptions of people who didn't follow the case, like me with the Parkland guy, you know, is that what you're saying? Placate the uninformed gut reactions of people who, like me, who are just kind of instinctively like, I don't like that guy and what I think he did, but I don't actually even really know what the situation was. That's exactly not what the jury is supposed to do. They're supposed to do justice on the facts and the law, even if it's hard, regardless of the message that it sends. So the fact that the prosecution has to rely on that, to me, it's such a tell. It's such a tell. You don't have the facts and the law on your side. So you're arguing everything but. So this prosecutor, Bill, all I know them as is Bill and Christina at this point. I know the others' first and last names, although I can't remember the name of the English guy. Hollier, was his name Mr. Hollier? I can't remember. Anyway, Nico LaHood and Jason Goss, I remember them very clearly, but Bill and Christina is all I remember the prosecution team. Bill at least has the grace to acknowledge something good about Adrian. We don't have to actually make everything real extreme, turn him into a monster since he's sitting at the defense table. We can still acknowledge there's something good about him. Nobody's saying he intended for this to happen. It's not much of a concession. Okay, it's not much of a concession. But he's at least able to make it. I swear, I feel like this lady, if the lady, Christina, had made the first closing, she would have argued he intended it. Like, she would have argued for this element. She just can't give anything. This guy at least can. He brought up the causation, and the causation to me is such a weak part of this case. Mr. Goss objected to him bringing it up because it's not in the charge. The objection was overruled. So he gets to talk about if there's like multiple people contributing it, they can both or like all be responsible. And I think that the state has to make this point because it's so clear on the facts that there are so many things that contributed, so many mistakes that were made. The doors being unlocked, the information not going out on dispatch, the people not having the right equipment when they show up, the radios not working. I mean, it's just detail after detail after detail. And a lot of that stuff, if not most of it, was not in Adrian Gonzales's control. So you have to acknowledge the other contributing factors. It just surprised me that Mr. Goss objected to it, because just like you can turn to send a message to your favor, I don't know how you can't turn the causation to your favor as well. Causation means his inaction caused this, but for his inaction, this wouldn't have happened. That was like the whole point I started with when I came to this case, when I kind of started looking at what are they going to have to prove. They have to show, but for his inaction, this wouldn't have happened. And that's so important because that's where it gets into the duty. And what is feasible? Why do they have these tactics in the first place? The slicing the pie, the avoiding the fatal funnel, the cover and conceal, all the things we heard so much about. Why do they have that in the first place? So that it makes it feasible to engage a dangerous situation. And so if you are not able to do those things, the risk is much higher that you're going to get caught. You're going to get caught slipping. You don't know where that gunfire is coming from. You know it's generally over on that side, but you don't know if he's on the north end of the building or the south end of the building. You don't know which direction he's going. You don't know if he's going to pop right out as soon as you get out from behind the cover of your vehicle and start moving that direction, and you're out in the open because there is nothing there to hide behind. And you got to work your way around that weird corner with all the AC units and the fence. So you can't just like hug the wall, even though they told us you don't really do that anyway. But say you did, you have some cover. You can't do that here. And so you have no idea if the shooter is just going to pop right back around, see you right there in the open, and he's got a rifle, and now you're shot and you're dead, and you haven't stopped anything. Causation. That's why it matters. That's why these tactics matter. was because if you can do it tactically sound, it makes it more likely. But so much of those circumstances were beyond his control. He didn't control that corner. He didn't control the fact that there's no cover over on this side, nowhere for him to go, so that he wouldn't be just exposed if he came out and tried to approach. Causation really could have been turned into the defense favor, I think. So I just noted that. They objected, really could have turned that. I think made a lot of the same points, but just did it in a little bit of a different way. So they focused on, he had his list. It's good when they had lots of visuals in the closing. I think it's always good for them to have the visuals. It makes things very easy to follow. Focused on the training. They really did simplify the training though, didn't they? Just stop the killing. It's not terribly complicated. Stop the dying. Just stop the dying. That's all you have to do. The whole training is about the how. Nobody needs to go to training to be told, stop the shooter. I mean, is this guy for real? Did they need training for that? Is that the level of the cops that you hire? That they need to be specifically trained? You should stop. When a guy's in a school shooting up kids, you should stop it. They need to be told that? Of course not. The whole training is about how do you do that? And so as much as they want to try to like flatten that and simplify it, that's the whole problem of this case. And this is the fundamental weakness that I see in the prosecution's case. They were never able to get to how was he supposed to do that? What exactly? Let's be specific. What actions should he have taken? What steps? What direction should he have moved in? How quickly should he have moved in that direction? What should he have done with his gun? What should he have done with his radio? What should he have done with Melody Flores? How should he have navigated that corner? Spell it out. What was he supposed to do differently? But they couldn't do that because they have to just result on this flattened, just stop the shooting, just run, as if your duty is a suicide mission. You must charge the machine gun nest. Your duty is to die quickly and unnecessarily. It's a problem. It's a problem. And he says he's relying on it's because they have this priority of life. Innocent lives matter more than police lives. Yeah, they do. It's good that they have that concept. I appreciate that. With the power that we give to police, the responsibility is big. And they should have the responsibility to put innocent lives first. But how do you do that? Are you putting innocent lives first if you run out willy-nilly and get shot? If you start firing and take out your other officers, friendly fire casualties, is that helpful? Is that putting innocent lives first? The shot count, a part of their case, that each shot was notice to the defendant to advance. If I'm the prosecutor in this case, I would hate to draw that short straw, but if I were the prosecutor in this case, this is what my case is entirely about. This is it. This is it, because this is the one thing that I can see so many shots. This is the one thing that I can see, like there's no real denying at this point that something really, really bad is happening. Now, I still don't know how you get to what he was supposed to do or how he was supposed to do it differently. But that's really the strongest thing they have. Yeah, there were a lot of shots fired before anybody did anything. Maybe that's just a different emotional ploy. You know, how do you not lose your reason and just run mindlessly towards the threat when you hear that many shots? I mean, maybe it's just a play on that. I don't know. But it really seems like the best fact that they have. And even when the defense went back and did their own timeline about the, roughly 48 seconds between him getting the information from Melody Flores and radioing, shots fired. It's like 48 seconds, 45 seconds, something like that. And there's a lot of gunfire. The time to act, just arguing, videos show, but this is the hindsight bias. This was where the animation was in many ways very powerful, because it puts all these things together. It, highlights when the shooting was happening, what was going on the radio, how people were moving. I mean, it just put all of those things together, but they didn't know any of that at the time. At the time, it is fog of war. It's easy to sit back after the fact and take your 3 years or whatever he took to just listen to this stuff over and over and over and watch it and break it down and try to piece it together and compare it to this other thing to be able to create this big picture view of how, like, you reconciled all of these different things. But that's not how they experienced it at the time. Yeah, if Adrian Gonzales was God with this omniscient view of everything happening as it was happening in concert, we'd be in a different, he probably wouldn't be sitting in that chair. But that's the whole point, isn't it? Because we don't know what he heard on the radio. He's trying to talk to Melody. He's trying to communicate. All of these other things are going on. Time to act. We know that there was time. It's just, doesn't the time to act depend on what action he was supposed to take in the first place? And we still haven't got there. We never got there. Other than just blindly run. They won't say it. They won't come out and say that that's what they're saying he should do, because that would be insane. And the jury would hear that and think, that's ridiculous. I don't think that's his duty. So they won't come out and say it. But they sure don't deny it. They sure don't give you any reason to think that they mean anything more specific than that. Time to act. Kind of depends on what he needs to do, doesn't it? His own statement is also, in many respects, relatively strong evidence against him, because he is talking with the benefit of hindsight. I think the defense handled that very well in their closing. He is saying all of this after he has had the chance to think about it and put it all together, and they're not asking him to describe it as he lived it, moment by moment, what was happening. He's given them the summary of what he did that he's kind of figured out in context. But he did. The statements that he made, Melody told him he's over there, he's wearing black. I hear shots going off. I hear sounds behind the building. He radios shots fired, and then he tried to get from the front to behind his vehicle because there's only a tree. There's nothing there but a tree. Yeah, there's no cover but his car. And that statement about get coverage over there, and then they would try to enter, get coverage over here first. Doesn't sound great, does it? It doesn't sound great, because it's very easy to say, well, those kids didn't have cover. And it's true, the kids didn't have cover. The locked doors were supposed to be the cover for the kids, and they couldn't rely on that. So they didn't have any cover. Why should he have cover? Would today be better? Would today be a better day if, in addition to 29 dead and injured kids and teachers, we also had a dead cop? Would today be better because of that? I don't think that would be better. I don't think that would be better. And so then when the defense showed, like, here's the training, here's how they go in with 2 of them with rifles. Here's where they point out in the specific training, go towards the shooting, but maybe go by yourself, but don't engage by yourself. Here's all the reasons why you shouldn't engage by yourself. It's better with 2 people. Why? Because you can cover each other. The shooter pops around the corner and there's 2 of you. A lot better chance one of you is going to get a shot off. Is he going to kill you both before anyone can fire back? That's the advantage of having the 2. The children were in danger. Yeah, it's an important part of the case. Horrible to see. I don't know that they needed to see it. This was just one of the real strong issues I had with this case, was the necessity of showing the jury all of that. You don't have to. You didn't have to put them through that. You didn't have to expose them to that. Seeing stuff like that can be enormously traumatizing. And it was not a disputed issue. Nobody disputed. Kids died horribly. Seeing how horrible it was for yourself says nothing about what Adrian Gonzales was supposed to do before that happened. Really struggled with that part of this case, is the consequences to the people on the jury that had to be exposed to that, the witnesses that had to come in and relive it. I just, Ms. Maureen, the after-school coordinator, she talked about how she's haunted by what happened. I am haunted by Ms. Maureen's testimony and how she was shaking on the stand. Just experiencing her trauma, that haunts me. Making her go through that. Bill, being somewhat more reasonable than Christina, in my view, at least acknowledges there's a whole lot of blame. There's a whole lot of blame for a lot of officers. You haven't really given me a good reason why we're singling this one out. But at least he's acknowledging there's a lot of blame for a lot of officers. But the teachers put the kids first and followed their training. We can't overlook the doors. The doors locking is there for the kids, for their safety, because you never know. Any given day, a monster might come onto campus. And I feel terrible for these teachers and what they went through and the experience they had. But it's simply a fact. They put their convenience before the kids' safety. It's too difficult to open and close the door when you don't have a key fob. So just leave it unlocked. So then he goes through the defense's case. This is a bit of a risky thing to do because you have to be fair. If you're going to point to the other side's case and say, here's what their case is, you really need to be fair. If you just trivialize it and present a caricature of what they're arguing, you don't look reasonable, and then you're not prepared to deal with the arguments that they actually bring and the possibility that might sway the jury in some way. They might actually see it the defense's way. So if you're going to take this approach, you really need to steelman it. And I will give Bill some credit that he didn't handle it like Christina did. Okay, he didn't trivialize it, but he also never really dealt with it head on. And it just it seems to me to be a tell. It's like basically a concession. You can't deal with their argument as it is because you don't have an answer. If you had an answer, then you would address it. You would just go ahead and point out, here's the strongest thing they said, and here's how we respond to it. So he didn't completely trivialize it, but really kind of missed the point in so many ways. So first part was that it was too far. So they brought evidence that distance between Adrian and the door, Adrian in the corner, Adrian in the west entry, whatever. If you jogged it, you could cover it in 11 to 18 seconds at a jog. Okay. What's happening while he's jogging? What risks are there while he's jogging? That there were no shots fired over towards Flores, over towards Melody, because Melody said there was shots fired at her. And this was all a bit confusing to me. I was never really quite able to sort this out. It sounded like they were saying that either Adrian was there when those shots were fired and so he would have known about it, or he was like on his way and would have seen it or something. Like just somehow it was supposed to put him on notice that the gunman was firing at Melody Flores because she said so. We had other witnesses talk about him firing towards the pavilion. We heard that from a couple of different people. I think even Gilbert Limones talked about, if I remember right, that he was firing the gun over towards the pavilion where the kids were on the playground. But that was before Adrian got there. At least as best as I could tell. So Bill points to the 8 casings on the side of the parking lot. Those don't tell you the direction he was firing that gun. They have the one defect on the outside of the building that's down at the far southeast corner of the campus. And prosecution's argument, it couldn't have been when he was shooting out the east windows from room 111 and room 112 because the conduit pipe was in the way. It would have had to go through the conduit pipe. But the defense has argued this could be a ricochet. I don't know. They never found a bullet. We don't know the trajectory. To me, like, none of this got to the timing anyway. When was that happening? And what does it have to do with what Adrian Gonzales knew and when he knew it? I never saw that circle got closed. I didn't see that any of this precludes. He was shooting over at the pavilion, hit that building at some point, and this was all before Adrian got there. Bill talks about slicing the pie. Slicing the pie and how it takes time. You got to do it slowly when you're in training so you don't put yourself in harm's way. That's that concept of how to get around the corner safely. And he says the building is the cover from the northwest side where the shots were fired. He didn't know it was from the northwest side. At best, he knew it was from somewhere over by the teacher's parking lot, but the teacher's parking lot goes all the way down to the south. So he doesn't know if that guy is right around the corner, just standing right there, ready to step back onto that south sidewalk and blast him out there in the open as he's jogging forward for 11 seconds. He doesn't know that. The echo is part of why Adrian didn't know what exactly was going on, needed to get oriented to it. But Coronado knew within 2 seconds from the other side of the building, having looped all the way around and having had a line of sight on the shooter going in the building. Coronado knew. He doesn't address any of that. Just the fact that Coronado knew, and they didn't have any question about which building to go into. They knew which building. I don't think there's really a dispute. And this is maybe just where the issue is, even in the indictment, that Adrian was on notice of his general location. He was somewhere over that way. He was somewhere over there. And so there's no school buildings over there. This right here is the school building, he's gonna be closest to. Seems pretty probable it's this one. It's, not one of those ones over there. If he's by the West Side teacher's parking lot, like Adrian, calls out on the radio. It doesn't seem that extraordinary to me that, you know what building he's in once you figure out he's in the building. The doors. I thought this was the weakest argument that they brought. The doors would have slowed him up. But the rifle penetrates glass, right? And there was glass on the side of the door. So it might have just saved him a couple of seconds. Here's the issue as I see it. It's friction. It's friction. It's making it that much harder for him to get in the building. And where is he while he's not in the building? Every second that it takes him to try to get into that building, he is outside. He is exposed. He is still in the line of sight of those people there over on the west side and all the other people that are starting to converge on the scene. That's the difference it makes. It keeps him in an exposed position. And so it's going to be much easier to intercept him, to surround him. If they had another 30 seconds on the radio for Mendoza to be like, I see him and here he is, and now Adrian knows where he is, and the hill, the guy on the other side, I guess he's not there yet, but they got people coming from all directions. You had another 30 seconds maybe to be able to coordinate. how we're gonna approach this? Could they have maybe taken him out before he got in the building? Just all of this, it seems so much more probable to me that the way this incident gets stopped is if the doors are locked than if a lone police officer with no shield, no rifle, not even a vest that's going to stand up to a high-powered rifle, just runs over willy-nilly and hope he's not seen, I guess. Hope he sees the shooter before the shooter sees him. I really thought the door argument was the weakest one. And that the teachers that he has the gall to say, oh, well, the teachers don't have the statutory duty to act. And it wasn't the doors being unlocked that created an imminent danger. We're not stupid. We're not stupid. Okay. The teachers don't have a statutory duty to act. Who buys that? When you leave your kids in the custody of the school, they don't have a duty to interact. How many times have we heard about things like a kid being bullied, a kid being ganged up on at school, a kid being harassed at school, and they do nothing? It's because they have a duty. They have just as much of a duty as the police do, because the kids are left in their care and control. So we're not stupid, but then the door didn't create the imminent harm. It sure allowed him to walk right the hell in that building, didn't it? And then walk right in the classroom. You notice which classrooms he didn't walk into? The locked ones. Walked right into room 111. And you're seriously going to tell us that wasn't part of why the children were in imminent harm, because he was able to walk right in? Gonna have a hard time buying that. The defense case looks at the radio dispatch, how it was confused. There was limited information, but he says they knew there was a wreck. There was a man with a gun. There was shots fired. That should have been enough. And the police administration is at fault because nobody was assigned to the school. Nobody being assigned to the school is definitely something that could have been done differently. Some other things that could have been done differently. You could have had equipment for your cops. They could have been prepared for something like this, instead of having to wait an hour for someone to show up with a shield. You could give your cops the equipment they need to be on tactically sound ground. I don't know if the Alyssa's law would have helped in this situation. I saw somebody mention that. in the chat. I think I started it. Yeah, this one right here. Every state should pass Alyssa's law. I'm so very glad my state has. My daughter is in 4th grade now, and this case hits hard. I bet it does. I don't know that Alyssa's law would have changed the situation here, because they knew this thing happened. It unfolded so quickly. Ms. Maureen called 911. One of the police, or one of the teachers, I don't remember if it was room 102 or 104, called 911. The issue wasn't that they weren't able to notify the authorities that there was an ongoing danger. They knew that. It was the problem with the information being communicated, the chaos, the lack of equipment, and the speed with which the shooter was able to act because of the lack of resistance from the safety features of the building itself. Part of the defense case, Page, Hill, and Coronado. He didn't mention Mendoza. Couldn't help but notice that. He left Mendoza and Saucedo. He did bring them up, but they weren't on his list. You know, if I'm just like looking at his list, he's not mentioning Mendoza and Saucedo. And that is a problem because they asked to take the shot. Asked to take the shot with the rifle. Pointed at the west door where the guy is. This to me is a very weak part of their case because it's one of the strongest things in my mind is that I don't know how you're going to say this guy has the duty when these people didn't do what you're saying he should have done and they're not sitting in the chair. They're not being charged, but they didn't do it either. Somehow them driving by is acting. But Adrian putting the information out on the radio and calling for cover is not. So they just focused on, he focused on, well, they acted, they got there, they assessed the new information, and then they acted because they drove away. But Adrian, according to them, heard the shots fired, 16 shots fired, then 14 shots fired, then 60 shots fired inside the classroom. There's a teacher saying he's over there. And he didn't act. Did the guys on the corner not hear those same gunshots? Did they not hear them, or were they too busy driving away? They would have heard. They would have heard him going up the side, shooting out the windows. They would have heard over the radio the shots fired. Told specifically, take cover, shots fired. They know. He asked for permission to fire because they're being careful. They get to be careful, you see. They get to be careful. I heard him say that. I'm like, you got to be kidding me. You got to be kidding me. Adrian doesn't get to be careful. They get to be careful. He doesn't get to be careful. They're acting by going to the other side because they're just thinking this is road rage, this is a bailout, and so they're going to cut him off. So they were doing something to address it. But he doesn't get the benefit of that same confusion. Adrian thinking maybe this is a bailout, maybe this is a road rage. We know shots fired. We know there's an accident. Who's he shooting at and why is still kind of up in the air. That's what they're trying to assess. So they get the benefit of that, which then, by the way, then in the rebuttal, Christina comes back and like discounts that. You know, he doesn't get the benefit of thinking that there's maybe a bailout. That's just an excuse the defense has. Not my responsibility, not my day. Point that at these guys. Because your own prosecutor is saying it's okay because that's what they thought. But now you're going to get up and say it's not okay that Adrian thought that. And you haven't given me a really good explanation for why I should be holding them to a different standard. And then the last part of the defense case, the challenges he faced, the tunnel vision, the auditory exclusion. He says these things don't count, either because he admitted he heard the shots when he gave his statement, or because even if he did, he was on notice, as things unfolded. Complicated. It's not complicated. The training is to go to the gunfire, and yet nobody did that. Nobody did it. And when they finally did, he was the second one in the door. The perimeter. Hill gets to set up a perimeter. Hill's literally the one dispatched to the call. Assigned to him. Go deal with it. And he sets up a perimeter. Adrian, on one of the body cams, we see he's there at the corner, the southeast corner of the building. He's checking the east side. He's watching to make sure he doesn't shoot out or he doesn't come out of the building or something like that. What if the shooter had gone out that side? Because nobody is watching. Nobody's guarding the perimeter. Whole bunch of other school buildings right over there across the walkway. The stress. It was a dark day, but there were some bright spots. Teachers put their kids first. The kids defended each other. The kids defended the teachers. The teachers put their kids first. And in many respects they did. And again, I don't want to be hard on these teachers because of what they went through. And I don't want to poke my finger in their wound of what they did and didn't do. But the teacher in, was it 104? Didn't have time to lock the door. Didn't have time to lock. Is that putting the kids first? The teacher in 111 or 112, the teacher in 112, the gentleman that survived, he got shot, but he survived. The shooter got in because they had the adjoining door with room 111. Again, supposed to be locked, but it's not, for convenience sake, because they have a shared printer. He hears shooting on the other side. What did he say? He said, "I'm not going towards that. I'm not going towards that." He didn't go lock the door so that the shooter couldn't get in room 112 from room 111. He said, I'm not going near there. I don't want to give this guy a hard time. I really don't. But these are just the facts. And so trying to rosy color them or pretend that they're something other than what they are to make your case, it's a problem. It's a problem when you can't deal with the facts the way that they are. I agree. A lot of the teachers did a lot of good things that day, and a lot of the kids did a lot of good things that day. But to act like all of the teachers did everything right, it's such a disservice to this. If the goal is we need to make sure that children don't continue to die in vain, then we have to be honest about the circumstances that allowed it to happen. And we're not being honest about that if we don't take into account what the teachers did and didn't do that made this situation so much more difficult to deal with. Adrian, by contrast, he sought cover. And that's ultimately the case. The case is that by seeking cover, by trying not to get shot so that he would be alive to go in when they finally, were able to get in. His fault. Could have prevented it if he didn't seek cover, but never told me. How was he supposed to engage this shooter? You know so much. Show me. Show me on your map. Show me, demonstrate for me here in the courtroom how you're going to hold your gun, how you're going to cover the distance, how you're going to navigate that corner. I'll be the shooter over on the other side. I'll be the variable that you don't see. And just play that out. Play that out a few times, a few different ways. What if this? What if that? How many times do you end up neutralizing the shooter, and how many times does the shooter end up neutralizing you? Because that's your causation problem. Got to the defense closing, and I am going to reverse myself. Jason Goss, he did great. He did great. I thought this was a very compellingly delivered closing. The prosecution got a bit monotonous and a bit just quiet. It was one note. Mr. Goss can modulate. He can get loud when it makes sense to get loud, get quiet when it makes sense to get quiet. And it seems like a very little thing, but it keeps your attention. It keeps you focused on him. Because it's not just kind of like lulling you into all of this is the same. And there's not really anything new here, and just runs the risk of losing your attention. I honestly, I never really loved his theme. He started his opening with it. He started his closing with it. The monster that hurt those kids is dead. I know. But our theme is about Adrian and what Adrian did or didn't do, and is Adrian guilty or not guilty? And I understand what he's doing. He's pointing out, and I think once he got into it, makes a real good point. I can understand, I can imagine the pain of those parents, and I can understand the anger and wanting to be able to put somebody in that chair, because the person who belongs in that chair will never sit there because he's dead. We can't put him in that chair. And so the desire, the hunger for accountability, or some kind of punishment, some kind of retribution, some kind of sense of we have been so grievously injured that we are able to strike back, makes us feel vindicated. It is part of what the justice system is for. It's part of why we charge people criminally in the first place. Is it makes us feel scales, makes us feel like we're evening the playing field just a little bit. You can never get the kids back, but you can strike a blow against the person who committed the wrong. And the defendant needs our help, because the government has decided he has to pay for the failures, all of the failures, the mistakes, and the pain of that day. This was the point. This was the point. Not that the monster who killed the kids is dead. The monster that killed the kids is dead is important only because that's why he's sitting in the chair. They need somebody. Somebody has to pay. They've decided it's him, but they need to make the case why. And have they done that? Beyond a reasonable doubt, have they shown he's legally responsible? It's not right. It's not right. It's not just, because he was acting. And they're going to massage facts. Got to massage the facts to justify that every one of the officers is fine, but not him. This reminded me, the way that they are so eager to make the excuses for the other police officers and not apply the same standard to Adrian Gonzales. This reminded me so much of over in Delphi. And the first time we ever heard First time I ever heard forensic witnesses for the state testifying about how all of this DNA, abundant DNA, like everywhere, all over these kids, it means nothing. It means nothing. Because they live with men and they do laundry, you know, is shared and things like that. It's the first time I've ever heard state witnesses explain away DNA as insignificant. That's kind of what this reminded me of. It was just it's just like a say what? Say what? You're making excuses for all of them that you are not extending that grace to him. How do you not see that? But he's the one that stayed in the hall after he got shot at. Of course, he knows he has a duty. He was trying to fulfill his duty. He was trying to carry out his duty, given the limitations of what he was facing. The message is the message that the next time the officers are going to be perfect. They're not going to be perfect, because you're still going to deal with the stress of the situation. You're still going to deal with making mistakes. You're still going to deal with tunnel vision and auditory exclusion and fog of war and all of the things that make these difficult situations, particularly when you've never encountered them before. The SWAT guy who came in is like, yeah, I deal with this every day. And so you become accustomed, you become acclimated to functioning in a super high stress environment like that. But these guys had never been through anything like this before. And the next time it happens in a small community where they've never gone through anything like this before, they're going to have these same experiences. And you don't fix that by putting somebody in jail. This is where his modulation got really good, because he started getting loud when he said, if you convict him, the cops will all be Randy Hill next time. They will all be out there. Well, I'm just going to go ahead and set the perimeter, because now I'm not in danger and I'm not going to get charged. I'm not going to get prosecuted, because I guess I got a little bit too close and didn't do anything. So I'm just going to stay. I'm just going to stay back over there. It doesn't honor the kids to do injustice in their name. Very important point. So he broke down a little bit from the jury instructions, the duty to protect against the threat of injury that's occurring in his presence. And so, is this really in his presence? He didn't see the guy. He knew generally where he was, meaning he's over there somewhere, but he doesn't know specifically. He never had eyes on him, never saw. And when he first arrived, he knows there's a gunman going towards a school. And so he drove directly at the person he thought was the gunman. He specifically tried to engage with who he thought was the gunman. The hallway, everybody knew. They said they know that this hallway is death, the fatal funnel. They have no equipment, no shield, nothing. Went in anyway, which a lot of people didn't. So he risked certain death. Nobody had a rifle. Just going in with their handguns, their little, tactical vests. They risked certain death. So decent case to me that he's trying to do the best that he can. But they couldn't get to the door because the gunman shot at them through the wall. And the prosecution is saying your job is to die at the door. This kind of cuts both ways, right? If you're going to talk about the other's case, you gotta be fair. You can't caricature. You can't make it a caricature of what their argument is. It just makes you look bad. This to me comes off as a lot stronger, even though obviously the prosecutor is not saying your job is to die at the door, but because the prosecutor never said what exactly is his job supposed to be. Just go to the gunfire, and they've told you over and over and over again, here's the tactical problems that make that difficult, and you don't hear them and respond to them and explain why they should have been overcome, and here's how. You just keep denying that they exist at all. It's not complicated, it's simple. Just go to the gunfire. So yeah, the prosecution didn't say that, but is that kind of a reasonable inference from what they presented? Your job is to die at the door. They never said, tactically, here's a good way to do this. Here's what the alternative was. They never said that. They've just kind of left you to have to conclude tactics are out the window because the tactical objections have never been answered. And they just keep saying, go towards the gunfire, go towards the gunfire. If all you're going to do is go towards the gunfire, regardless of tactics, regardless of equipment, then it really does sound like your job is to die. And if that's the job, nobody there did it. If that's the job, not a single person there did the job. So it kind of makes it hard to believe that that's the job. If that is the job and nobody did the job, then you probably need to reconsider a whole bunch of how you're getting this job done. This reminds me of, okay, I'm going to go on a little bit of a tangent here because Jeff and I have a little bit of a dispute. We have a little bit of a dispute when it comes to our Phillies quarterback, Jalen Hurts. And how much is Jalen Hurts responsible for the sad ending to the Phillies season versus the coaching? How much is the coaching and the play calling responsible? And one of us, I'm not going to throw anybody under the bus, right? I'm going to keep this general. You might be able to tell anyway, because of course I'm not going to be able to help the temptation to caricaturize the opposing argument, right? One of us is of the position that the quarterback has the ball. At the end of the day, it's his job to get the ball into the end zone. It is his job to find the run. It is his job to find the receiver. It is his job to manage the pocket, take the time that he needs. One of us says it's the responsibility of the person who designs the offense to account for the characteristics of your quarterback, the weapon that you have. If you know that your quarterback is short and has a hard time seeing through the pocket, if you know that your quarterback doesn't maybe want to run so much anymore, because running will very much shorten a quarterback's career, take a lot of damage. If you know that your quarterback gets nervous when the pocket starts to collapse and wants to get out of there, you need to design your offense with those characteristics in mind. It does you no good to design your offense around an ideal, a platonic form of a quarterback. That's kind of what this reminds me of. If nobody here is doing their job, it's because you're not designing the job for human beings to do it. You're not equipping them. You're not taking into account just what the normal reactions are going to be in the situation. If the job is you need to be able to go to the door, then you need to prepare them and equip them to be able to go to the door. You need to have them the shields. You need to have them the means of communication that are going to work. You need to have the weaponry that they need to be on an even footing with the threat that they're encountering. These are things that are not in their control. If you're going to say you have to go to the gunfire no matter what, then you need to take human nature into account. That nobody is really going to be eager to just run to their own death. And if you're expecting otherwise, you're expecting some platonic form of a cop to show up and just throw down his life. And ultimately it may not do any good anyway. Nobody did the job of dying at the door. So it's got to call into question, is that even the job? If it was the job, you did a terrible job of selecting people and preparing them and so forth to be able to do it. But that's the point, isn't it? It's not the job. The job is to be tactically smart when you engage with the threat so that we don't have 29 dead and injured students and teachers and a whole bunch of dead and injured cops. They waited 50 minutes for a shield to get there. That was a fact that came out at trial that just blew my mind. SWAT shows up and SWAT doesn't have their shield. You are literally the special weapons and tactics group. Where are your special weapons? That's exactly why they called you to come, and you left the special weapon at home. I couldn't believe it when I heard that. So they had to wait forever to get a shield. The training is to use the best tactics to get the best outcome. It's a very simple way of putting it. And it's logical. Makes sense. If the job is to just go die at the door, we're not paying them enough. I mean, bottom line, everybody wants to go home alive at the end of the day. So the training is to tell them how to do that, teach them the best way to do that, to give them the best chance of everybody goes home alive. And it doesn't mean their life matters more or even as much as the innocent people in the room. But it does mean you need to put them in a position to be able to prevent what happened. And you dying in and of itself isn't doing that. There's just no evidence that any cop that died here trying to approach the shooter would have made a difference one way or another. The law doesn't mean he has to put himself in the presence. If he's not in the presence, doesn't mean he has to put himself in the presence. I didn't love this argument personally, because I mean, yeah, you need to be approaching the threat. But I buy that you need to do that in a tactically sound way. You're not under any obligation to charge the machine gun nest, to make yourself cannon fodder. You're not under an obligation to do that. But yeah, you do. You have an obligation to go and find the threat. But within your ability. That's where I think the second duty issue was, it's a stronger, if you're going to make a purely legal argument like this, if it's within his power, that's the whole issue. And that goes to the causation again. What's feasible here and what isn't? What should he have done differently, and what would it have accomplished as an outcome? How do we know that would have stopped the shooter? This whole problem with the tactics comes down to what's in his power and what's feasible and what's not. Everybody Everybody can imagine the scenario. Everybody's watched enough movies, that we can picture the movie scene where, the stormtroopers can't hit anything that's coming at us and stuff. And so you can just like sort of run straight at them with no protection and take out 20 of them at the same time. Everybody can imagine that movie. That's not real life. So they waited because it was in none of their power to get in and stop it until they got the right equipment. Wasn't in any of their power. Could they have done something different? Could they have gone in without the shield and maybe just overpowered them? Taken enough damage. If you go in with 10 people, it's like coming up with the cover. If there's 2 of you, there's a lot less chance that he's going to be able to shoot all of you before you shoot him. If they had just like at the very beginning gone in and said, we know people are going to take fire, but we'll trade that to be able to take him out because somebody's going to be able to get the shot on him. Just overwhelm him with numbers. Maybe. It's asking a lot of people. But the damage was already done is the problem. By the time there were enough people coordinated to be able to pull off that kind of swarm, the damage is already done because this unfolded so quickly because the doors were open and he could just walk in and wreak the havoc that he wreaked. The doors had been locked. If nothing else, you got that friction, you got that time it takes where he's exposed. And maybe that minute of 48 seconds, 3 minutes before they went in the room, whatever. It's like so many numbers thrown out. It's kind of start to lose track of what's referring to what. The shooter has to mess around with that entry door to figure out how to get in the first place. Shooter has to mess around with the doors in the hallway to make it into the classroom. Would it have given him enough time by the time there were enough people there to swarm him, take the losses, take him out before anybody got hurt? Maybe. I mean, we'll never know. It's the problem with counterfactuals. You'll never know. But does it seem possible? Yeah, it seems possible to me. It really does. I put a little star in my notes next to this thing that he said, because to me, this is the bottom line. If they haven't proved he could have done something to prevent it, he's not guilty. That's the whole bottom line. What was he supposed to do differently? And how would it have stopped what happened? Given the circumstances that he was facing, given the conditions on the ground, what he was equipped with, what he was dealing with information-wise, what was he supposed to do differently? And how can you show it would have prevented it? That is their burden. And so if they haven't met that burden, he should be acquitted. And there is a reason why they never did that. There's a reason why they never said, oh, here's the tactically sound way that we can be reasonably confident he would have lived and the shooter wouldn't. There's a reason why they didn't do that, because insistence aside, this was in fact a more complicated situation than just go to the gunfire. Just go to the gunfire. Go to the gunfire and die. Might make you feel better. Won't make me feel better, but it might make the prosecutors feel better. But How would that have prevented anything? It's not going to take him 1/10 of the time to turn and shoot one cop running willy-nilly at him and continue about his business as it would take for him to have to deal with a locked door and getting past a locked door. Now it's 1 minute and 48 seconds, not 3 minutes. Works through the time frame. Okay. I mean, again, the numbers, it's just, I don't know that the actual number is going to matter. This is where I think it's just a gut on the part of the jury. Like, they've already either bought in that it's too much time or it's not enough time. And the details between 1 minute and 48 seconds and 3 minutes, I don't think that's really going to matter. This theme of how the prosecution is twisting the facts. Continue to revisit that. Gets a little problematic during Nico's, right? It was the one objection that gets sustained when they object to it. They did like to personalize, and I understand this. Sometimes you get in trial and you take it personally a little bit what the prosecutor is doing, and so you want to just kind of call that out and put it back on them. Really not supposed to do that. Goss kept it pretty clean by keeping it to criticizing their theory and their case and how they were trying to make the case. But still, having to twist the facts. So Melody advised him of the general location of the shooter, but she's frantic by her own account. She's probably not real clear. They're relying on his statements from the interview, but he is compressing time in the interview. It doesn't account for, the process of him trying to get information from it. He's looking at it in hindsight, so he's able to say, by the time he knew where there was to go to, and we know because that's when he radioed it out, the guy already wasn't there anymore. So did he even have time to respond? Did he have time to respond? The approximation in the timeline and in the animation, calling out the way that the animation suggested he just drove right by the shooter and didn't look at him. It's possible that happened, but definitely not an undisputed fact, not like a certain thing that happened. Because as bad as that defense video is, the potato that filmed it, as Ian put it. Yeah, I mean, it does kind of look like he's just there crouching in between the cars when the car went by. And that's what Gilbert Limones described in his testimony. He said the guy was between the cars when the white car went by. He was between the cars in the parking lot. And so that was a really good way of highlighting so many of the assumptions that would have to go into that type of a recreation. You got to assume the direction of travel, the pace of travel, the continuity of travel, and so forth. But those are all variables. And it can mess up your entire approximation by just not accounting for the fact that, yeah, the guy might have paused on the walk. The guy might have ducked behind the car. And so I thought this was a pretty effective way of dealing with the animation, that it's very powerful evidence. I don't think there's really any way around that. Putting it together the way they did is very powerful, and that's exactly why they did it. Because all you just hear the pow, 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 the shots going off while the cops are yelling back and forth at each other on the radio and so forth. And you're watching them on the screen, and the whole time the pow, 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 and you're seeing Adrian's little X. It's very powerful, and that's why they did it. And so It's critical for the defense to point out this is misleading. And that visualization that they gave, showing the jury is extremely effective way to do that. Because we can tell you all day, oh, he would have had to make this assumption. And he, even by his own account, it was a couple seconds here and there. And so if you shift seconds, it could change the whole picture. You can rationalize it all day, but seeing it with your own eyes, always going to be more powerful. So seeing that comparison between his animation and then what it should have looked like. They did the alternative. I love that. Visually show them what it should have looked like if they were being honest and not twisting the facts. If they were being honest about the facts, here's what it would have looked like. They played the part of the state's opening where he said, guys, Melody had said that Adrian Gonzales said, guys, I think he's in the building, but Coronado is the one who said that, according to the defense. And he would know that because he's the one that had the line of sight from the corner that he was at. He's the one that's looking at the west entry door where the shooter went in. This is where the state objected. There's no evidence of that. Oh man. No evidence. Rarely is there no evidence. There's just inferences that you don't like. Again, just with the standards, they want to draw all kinds of inferences about what Adrian Gonzales was doing and what he was thinking and what he saw and what he perceived and what he knew. There's no facts, there's no evidence where we can peer into Adrian Gonzales's mind and identify the exact point where he figured out, okay, here's an active shooter and here's where he is. In the process of trying to get that information from Ms. Flores, we are inferring that. But the prosecution doesn't like it when you do it back. Hey, gee, these guys up there, 130 yards away, looking straight at the west door. They knew he went inside. We know they saw him. Why? Because he asked to take a shot. That seems like a pretty reasonable inference. You're not going to shoot at nothing. Nobody's going to ask for permission to take a shot at nothing, at no target. He saw the target. And he even testified, Coronado. He thought he was going through the building, right? He gets this benefit of the doubt. He thought that it was a bailout or maybe road rage or something. And so maybe he's running through the building. So that's why they went around to the other side. He gets the benefit of that. Adrian doesn't. And so the state's trying to say that they went to the gunfire when they went away. The defense is arguing they went away. They saw what happened. They knew shots were fired. They had the shot on him that they didn't take. He goes inside the building. They didn't go inside the building. They went away. They went over to the other side. I noticed as well, I'm glad he called this out because I actually noticed it too when the state called the guy who did the training, the active shooter training that Adrian Gonzales participated in, didn't know anything about the case, wasn't asked to give an opinion about the case, and was it consistent with the training that he received or not? That really surprised me. And again, you just, you can kind of draw inferences why. Why would they not ask him to testify to that? Maybe it wouldn't be helpful. I mean, as it was, so many of these witnesses, you could just tell. I mean, this is the advantage of having a cop as a client. If he's not like crystal clear guilty of something really horrendous that everybody's going to condemn him for. This is the advantage of having a cop as the client. over a question about how he behaved as a cop. Cops don't really want to take him down. They're very aware that could be them sitting in that chair. So maybe the reason we didn't hear the opinion is because the opinion wouldn't be very favorable, because he himself was testifying. This is just my opinion. There's other opinions. This is just the way that I say, but I'm not the gospel. He gets a pass because of the backdrop. He gets a pass because of the backdrop. That's crazy, says Mr. Goss. Anytime you're not in the shooting range, there's going to be a backdrop. I mean, this is like, this is to me just kind of a wild excuse, because anytime you're going to fire a gun, sometime, someplace out in the open, in a populated kind of area, yeah, there's always going to be a backdrop, and cops do it all the time, routinely. There's always going to be a backdrop. It came up during the they had the map up, and they're like, Adrian's backdrop would have been over here. And he's pointing at like the parking lot and the funeral home. Like, yes, exactly. Adrian also could have shot somebody in the background had he fired his gun in this direction that you're indicating. He had a backdrop. The backdrop is the building and the door. Could have hit the window. Do you take the risk that you might hurt or kill a child in the hallway if it's going to save 28 others? This is a trolley problem I don't really want to have to ever answer. But I just don't think it's clear. It's hard in this particular case. Because you look at not just what's the magnitude of the risk, but how likely is it? Are you going to be able to hit your target 130 yards with an AR if you've trained with it? This is not difficult. So the likelihood that there's going to be some kind of lethal pass through, that a bullet goes through a body, goes through a building, and hits somebody else with sufficient force still left to be able to seriously hurt or kill them, seems real low. Probably a bigger chance that you just miss the target, and then maybe it goes through the building, and then maybe it hits somebody. It's a risk. It's not zero. But the risk of him getting in the building, maybe that's hindsight too. Maybe it's just hindsight now. We know that risk was real high. So they interpreted every fact against him, against Adrian, but they made excuses for the people who were better situated. So many of these points were like good, just summaries. I mean, that really does sum it up. They make excuse after excuse after excuse for the guys who didn't take the shot, the guys who saw the door and didn't go in, the guy who is called to the scene and never actually even goes to the scene, just hangs out in the street. The guys who drive around the building. They make excuses for all of these people, and they are not showing that grace to Adrian Gonzales. It reminds me of, too much reminds me of Delphi. Investigators just happy to take what Elvis Fields and Brad Holder and Ron Logan, less Ron, they did actually search Ron's house, but Patrick Westphal, Just take what they have to say at face value. No, we won't bother to look at the camera that shows when he actually left. No, we won't bother to check the hospital to see if this guy's explanation that the hospital jams cell phone signals of everybody that's there so he wouldn't have location data. We're not going to ask Patrick Westfall's kid about the alibi. We're just going to take their word. We're not going to look at anybody's phone. We're just going to take their word for it. But then when it comes to Richard Allen, we're not only not going to take his word for it, we're going to twist his words. And in some cases, literally change them to make the case against him. You're not being even-handed. This shows that your prosecution is targeted. This is not where is the evidence leading us kind of stuff. This is show me the man and I'll show you the crime kind of stuff. Because if this was driven by the standard, you would apply the standard equally to everybody. And they never explained that. They never explained. Why does he get a different standard? Why does Mendoza, who didn't take the shot from the west side at the door, why does he get a different standard than Adrian Gonzales? All they do is object. That's not evidence. Well, it's an inference. It's an inference from what we saw. Their own training sends mixed messages. It says, we don't endorse or encourage going it alone. And greater numbers significantly improve the odds for success, meaning actually being able to save kids. And that was important because when they finally go in and they have that shield and he's pop, pop, pop right on it, shows they needed it, shows why you needed those numbers and you needed that equipment. Because had you, Adrian Gonzales, gone it alone, we have no reason to think he wouldn't have just gone pop, pop, pop right on you. And now what help are you? Now you're just one more person that somebody's family is grieving for having died senselessly. A dead police officer is protecting no one. The training they did, it was the two people with the rifles. It was fine that Mendoza and Saucedo and Coronado, I'm going to keep trying. Coronado, Saucedo, Mendoza. I will never be able to say it as well as as Nico does. It's fine for them to think it's a bailout, but for him to have that on his mind and to have to sort out, he doesn't get the grace of the confusion. They use the confusion against him, but they use it to excuse the other officers. That's not a consistent standard. And then the hindsight bias. He now knows it's a female that he saw, that he went towards, but at the time he didn't know that. So he's telling the story based on what he knows with hindsight. Because they weren't asking him to tell it, to walk them through how he experienced it at the time. There were a lot of horrible things you, the jurors, didn't have to see. And they're playing on your emotions. They're just trying to make you mad at him. They're trying to get you emotional so that you'll turn that anger onto him. Just calling it like it is. But they have to ignore what he did do. They have to ignore what he did do. I like how Nico kind of converted that into the coward sandwich. I didn't like the coward cream. We'll get to that. But they have to ignore what he did do. And not acknowledge that, not incorporate that into their theory, not give him any credit. it just would be a lot more credible if you're able to do that, because he's not a monster. He's clearly not a monster. And so it doesn't do anything to paint him as, just a guy who did acknowledge what he did right. And then account for what he did wrong. It would be so much more credible of a case. So we had the recess at this point. Jason Goss, I thought he did much better than I thought he was going to do. In many respects, I think he might have done better than Nico, although I do like Nico. But I also kind of understand a little bit of the criticism of him. He does talk a lot about himself, personalizes and tells stories. It might be part of what helps him in this particular case, because he has the story of his own family experiencing, obviously not on this level, but something serious. And so he can relate to the emotion. It is a tool that he has to kind of help give him some credibility, as long as he can deliver it in a way that is authentic and doesn't look like he's being opportunistic or kind of tailoring things to his own advantage. Then that has the potential to be very powerful. But I didn't necessarily like, it took him a while to get going. I thought I didn't necessarily love how he got started. I didn't necessarily love how Jason Goss got started either, I guess. But it took him kind of a long meandering through, how could one evil person, do these things, and it's emotional, and I have my own experience, but that isn't like the family, and it's not us against the family. It's just the pursuit for truth. And then we go through the philosophical part of the Lady Justice and the Thomas Jefferson quote. And the cross-examination is the greatest tool in the pursuit of truth. I think cross-examination is your turn to testify, personally, but but that is the philosophy behind it. And that they're trying to hijack your emotions. So then we talked about Lady Justice. Most people don't want innocent people to be convicted. I think that's fair. And here is what Lady Justice is supposed to do, and here's the symbolism behind it. This was, I mean, I know some people will like it and some people won't. To me, it's I don't mind a little bit of it. This was just a lot. This was a lot of philosophy and short on analyzing the problems with the state's case. Like, if you got nothing but philosophy, when you're in the case where they got your guy dead to rights, okay, he's caught on camera, he's confessed to people, he has no defense, but he won't, do what's in his interest and take the plea because he's in massive denial and always will be, but won't get on the stand, to try to explain it, because on some level he already knows you're gonna look real bad. Those cases happen to every public defender. In that case, yeah, you're justified in going really heavy on philosophy and stuff, because that's all you got. Throw out all of the Thomas Jefferson and Montesquieu and John Locke, like everything. Throw it all out on the table, because that's all you have. But they have a lot more than that here. So I personally found it a little bit much. It's just a risk that, okay, you're not getting to the point. So there's just a risk that maybe you tune out. He's got the charisma to keep your attention. And so maybe it's fine. Maybe it works, but it is just a risk. I personally didn't love it. Then he came back to the personal part of his argument. I'm a passionate person. Don't hold it against Adrian. I'm going to worry, Do I look like I haven't slept? I haven't slept. No, sir, you don't look like you haven't slept. That was quite clever, actually. That little bit of a fishing for the compliment, maybe. No, sir, you don't look like you haven't slept. But I can't apologize for it. I can't be fake. I can't tell you something I don't believe. This is one of those things where it's maybe better to just do it and not say it. You run the risk. Again, if you've connected with these jurors, you don't need to tell them this. They already know. They already believe you're authentic. They already think you're not going to tell them anything fake. But if you haven't connected with them, this might sound a little bit like the lady doth protest too much. Why would you have to tell me? You know, why are you worried that I would think that you're inauthentic? It's not a problem for me because I like Nico. I don't hold it against him, but I can't guarantee that every juror is going to see it that way. So it is a little bit of a risk. And so finally, after this sort of long segue in, he gets to the argument about it's the totality of the circumstances. So he breaks down the 1 minute and 48 seconds. He's saying the time frame based on their own charging document between the time when Adrian showed up and the time that the shooter entered the classrooms. At 11:31:55, he parked. At 11:32:09, shots are fired. So this is 14 seconds after he gets there. Yeah, we got to assume you have not gotten all of your information from Melody Flores in 14 seconds. You are still maybe even just at the very beginning of dealing with Melody Flores. 11:32:58, the shooter enters. 11:32:59. Now, just over a minute after he arrives, he's radioing. He's on the west. The shots are fired. And then it's 11:33:43 that the shooter enters room 11. He left, the problem with the timeline and being the specific with the timeline is that if you aren't sympathetic, there's 44 seconds there. 44 seconds between him radioing, he's on the west side, shots have been fired. If you're not sympathetic, you might be thinking, could have done something in 44 seconds before anybody got shot. Prosecutor never told you what, though, but it's not going to preclude the jury from sitting back there in the jury room and deciding for themselves, thinking it through for themselves. They got all these maps. They got the radio. They can potentially sit back there and brainstorm an entire approach, an entire plan that they think you should have followed. So there's just a little bit of a risk there. But then we got to compare the defendant's actions to the other people's actions. I thought this was also an effective visual. He had these columns, defendant on one side, Mendoza, Salcedo, Coronado, Hill. Here's the circumstances he was facing. Here's the circumstances they were facing. Every single one of them kind of in a better position than him. State has another objection to the these aren't the facts. I want that in the record. You're not going to get that objection sustained ever. These aren't the facts. You get to argue inferences from the facts, and it's all he's going to do. The judge is going to do is what he did in this case. Jury, it's up to you to remember what the facts are. So then then we watch the dash cam. Watching the dash cam, again, the visualizing is very helpful. Where we see the officer shouting, consistent with what Claudia, I can't say it like him, Claudia, testified about, telling them shooter went in the building. Looks like they're having that conversation. See Saucedo, pointing the gun, getting lined up to take the shot and then not taking the shot. They don't believe what they're prosecuting. he starts to personalize it a little bit. He got called out for this at the end of the trial too, right? It's fairly clear they had a sidebar where they talked about don't personalize this with the prosecutor. Don't be focusing on what they said or what they did. Like, that's not the evidence. They had the conversation about don't make your objections to the other side, make them to me. Because Nico was like turning and talking to the prosecution. He's like arguing with the prosecutor when the prosecutor objects. And I understand it can be very frustrating, but that's not correct. So then he did it again. And the judge is, what did I tell you? He's like, I'm sorry, Judge. I'm sorry, Judge. Yeah, it got personal for him. And, this might be a little trick he has. It might just be, how he is. It comes off as authentic. But the way that he has kind of excused himself is, well, I'm just really passionate. Don't hold it against me. If you're charmed by him, that's going to work. But there is a risk that the jury is not going to be charmed by him. So same thing with, they don't even believe what they're prosecuting. If you don't hate the prosecutor, it might not land. It's really hard for me to sit here and imagine, how do you not hate that lady? Honestly, like hate's strong. You don't have to hate her, but she's just so insufferable. She's so off-putting. Some people are going to be drawn to that. I mean, geez, Jennifer Coffindaffer has fans, for heaven's sake. So just never know. Never know what people are going to think. So where's Randy Hill? Why didn't they call him to testify? Why didn't they call Mendoza? Why didn't they call Saucedo? They called one of them. They called Coronado, and only because they wanted his video in evidence. Hill was dispatched 3 minutes before the shooter ever entered the building. So why didn't we hear anything from him? Calling attention to the explanations they didn't ask for. It's easier for them to make excuses for these officers than it probably is for the officers to make excuses for themselves. What was 911 told? They were told that someone was shooting a gun, that they were shooting a gun at the school, that he was going into the schoolyard, that he was jumping over the fence, that he was running to the school, he was wearing black, and nobody relayed that to the officers. And then Trooper Hill didn't put in his critical timeline when Randy Hill showed up, because he didn't check in on the radio. He didn't let them know. He didn't radio in to say, I've arrived at the scene and here's where I am and here's what I'm doing and so forth. So all they have is just a video of him standing there. Nobody asked to set up a perimeter. They say that it was dispatch, but there is no evidence other than that they said it. They said it. State objects, he's misleading the jury. That's overruled. It's going to be overruled, arguing the facts. So then Joe Vasquez, the true hero. He was the guy. It's not even his county. Not even his county. He hears it on the radio. He's like, all right, I'm there. And he goes straight there. He was there at 11:56, half an hour, just about after everything has already kind of started to go down, but they haven't breached yet. So he gets briefed. When he moves in, he's got 27 other officers around. He's following the instructions that he's given, asked if the commander wanted him to make entry, and they said no. They've been fired at. They're trying to negotiate. So does that make him a coward? It's a good question. Does it make them all cowards? That one might be a little harder. That might not be, that's probably an easier to get to yes than focusing it on Joe Vasquez. So they finally entered at 12:50:01. And the reason why they had to wait is because they had to plan the entry because of the tactics. They had to navigate this outward swinging door that makes it complicated. Everybody agreed, at least Joe did, that taking cover is reasonable if you don't know where the shots are coming from. You don't just expose yourself. It's not going to do you any good to get hit by a shot that you didn't see coming. And if the first 5 of them in the hall hadn't contained him to that room 111 and 112, he could have done it to the whole school. That made me think back to room 104 and how that teacher testified. She didn't have time to lock the door. Her door was unlocked. She didn't have time to lock it. They had to, lock it with the key from the outside. And so somebody would have to be inside and then let you in. Didn't have time to do it. So 104 was unlocked. If he hadn't been contained to that room, do you think 104 would have just would have made it through? We'll never know. Good thing we'll never know. But that's what I sure thought about. He was familiar with 111 because he went to school there, the shooter. That was his homeroom. He already knew the room, and so he was able to wait in the closet. He had these advantages because of that, and they didn't know that. They didn't know who he was. They didn't know that he was going to have these advantages, that he could hide, just wait for them to come in. Pop, 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 pick them off. Melody Flores addressing her. I remember she's the special ed teacher. He's got the special ed kid. So he's not attacking her at all. It takes a special person to do that kind of work. But she just wasn't accurate. Took her 7 days to give her statement. In the meantime, she had watched everything, heard everything about the case. There's just no way that that's not going to influence her. The actual information that she gave wasn't correct. She thought he had a handgun. She ID'd the wrong vehicle. She described the wrong police officer as far as who she's talking to. She admits that she's frantic. Respectfully, it's probably more like the demeanor of Claudia on the 911 call. The 911 call was awful. And very, very frantic. I mean, maybe. We saw a lot of different demeanors from a lot of different witnesses. So it's definitely possible, but we just don't know. Her sense of time, obviously way off, 2 to 7 minutes that she was talking to him. He radioed the information about where the shooter was within, 30 seconds. So, wasn't going to be 2 to 7 minutes, but you can't cherry pick what you believe and what you don't. It's a good point. You can't just, you can, it's just, is it reasonable to do that? If you've decided somebody isn't believable because of their lack of accuracy, it's how do you rationalize then we're going to pick out the things that we want to believe? And so then I didn't catch exactly the comment that he made where he was talking about how, basically like according to the prosecution, it's okay for those 3, Mendoza, Saucedo, and Coronado, to run for cover, but not Adrian. This is the one time the prosecution got objected, and it got sustained because she wasn't objecting to the fact. She was objecting to the sidebar conversation that they clearly had at some point about personalizing the argument. Because he did it. It got sustained. So the one time he got corrected, don't do that. Don't hold it against me. Don't hold it against Adrian. Hold it against me. Go ahead and hate me all you want, knowing the whole time they're not going to hate you. It's a clever trick. So then the shots are fired while he's with Melody. So now he has to account for her and her safety. She's also an innocent person that needs to protect. Do you just ditch her and go run willy-nilly looking for gunfire? Makes sense. He's got a duty to her as well. She said the shooter went into the south door, but she pointed to the west door. She thought he went into the south door. He wasn't even sure what building. Had to ask her to clarify, what building are we talking about? And just basically emphasizing there's a lot to assess here. You know, it's not the nice, clean version that the prosecution gave of he talked to Melody Flores. She provided him instantly with all the information that he needed to be able to react. It's just not how it went down. By her own account, that's really not how it went down. And then based on what you can see about what she said and how she said it and so forth, what she remembers, what's accurate, what's not accurate, you can infer. You can infer this was not just a crisp, clean delivery of accurate information. He needed to orient. He needed to reconcile, clarify what she's telling him, reconcile it with his own observations, and be able to make sense out of it before you can decide how you're going to address it. And so it's plausible that took the time, leaves him with that whatever it was, 40, 44, 48 seconds between him radioing on sending out on the radio that he's on the west side, even though he's no longer on the west side, but communicating that information, and then the shooter entering room 111. Still have that time gap to deal with. But is it credible that he's dealing with Melody? Is it plausible? Potentially. Because we didn't hear from Adrian. We didn't hear his story. We just got his interview. You know, sometimes that can really cut both ways when the prosecutor has an interview like that, because it does take a lot of pressure off of him to testify. The jury already got to hear his version of events. And there may be things about it that you don't like, maybe things about it that you would change. But you can handle a lot of that the way they did, by just comparing it to the other evidence and the context, and just asking the jurors to be reasonable. And look, is this a plausible interpretation of why he said what he said? If it's a plausible interpretation, you got to consider if that's reasonable doubt. If it's plausible, it's reasonable. If they hadn't played that, then the jury hears nothing. The jury hears nothing except what the prosecutor has painted with their animation and so forth. And the witnesses, that's all the jury would have known if they hadn't played his statement. And so it puts a lot more pressure on him to have to get up and give his version. So I always kind of consider that from a tactical standpoint when they play the defense interview. You know, it's just case by case. Sometimes it makes a lot of sense because the defendant said things that are very damning, or the defendant said things that are ultimately going to be able to be clearly contradicted by subsequent evidence, or the defendant is going to say multiple things to different people or something like that. I mean, there's reasons why you do it, certainly. Not sure that was the right call in this case. There wasn't a lot there for them to capitalize on that can't be explained away by, we're talking about hindsight right now. Gotta wonder if they hadn't done it. So he then apologized to Christina. He doesn't mean to be disrespectful. But then he goes back to the Thomas Jefferson quote. Respectfully believe he was talking about Ranger Hill, the issue of the government holding itself to account. And then repeats, what we heard from Jason Goss already about the shooter, where the shooter was placed in the animation. That's not facts. And so then what's she going to say? What's Christina going to say when she gets up to do her rebuttal? I think he gave her more credit than maybe she deserved, because this would imply an actual rebuttal, which I don't think she gave. She's going to say it was the 3 or the 3.5 minutes. She's going to say he didn't follow his training. But we showed you the training. It said don't go in alone. He said this is just suggestions, just my opinion. Other people will think differently. She's going to say he had the best opportunity because Ranger Hill looked you guys in the eye and said, those people with the line of sight who asked to take a shot, they didn't have a better opportunity to engage, delay, distract the shooter than the guy who never saw them. But you're the judges of the credibility jury. You get to decide. You get to decide what you think of that. Then he got into the coward sandwich. Now, obviously, this is not something she's going to say, but it was his way of describing that they're going to have to ignore the bravery, where he drove into danger, where he was one of the first into the hall, where they take the incoming fire. 2 officers get hit and he doesn't move. And so you have to kind of disregard that and just focus on the coward filling. I thought it was a very clever way to put it. He had a lot of just little things like that, simple ways of putting things. The fatal field, he's like, I made that up. We know, but it does make sense. I mean, it makes sense. A wide open field is going to be a problem. There's probably a military term for that, but the fatal field, the coward sandwich. The coward sandwich. It's a clever way of putting it. They're going to go back to Adrian remained. And so you'd think by the way they presented it, that all he did was just stand there, but all he did was remain in danger. That was a good turning of it. The only place he remained was in danger. He drove straight to the danger. He didn't run away. He didn't retreat like some of the other folks did. He stayed where he was. Ultimately, got oriented and got in the hallway. Going to tell you to send a message. But, the problem with that is that the message that's sent is going to be Officer Hill, stand back, don't engage, don't put yourself in trouble, because you might end up in that chair. They want you to pick the lowest man on the totem pole, so they're going to have to ask you to ignore a lot. You're going to have to ignore the inaccurate dispatch. You're going to have to ignore that he drove to danger. This is when they brought up the coward cream. Nobody wants to think about that, okay? Nobody wants the coward cream. Nobody's mom, definitely. You could have said coward burger. There's plenty of things that go. It's part of the reason why this is so to me is who puts cream in a sandwich anyway? No, that sounds very British. That sounds like something the Brits would do, is put cream in a sandwich. I'm very sorry, all of my British friends. Just giving you a hard time. Doesn't it sound like a British sandwich, a coward cream sandwich? Ugh, yeah, no. Not for me. Thank you. I'll go across the channel for my cuisine. Thank you very much. Nothing personal. He remained in danger. You have to ignore the 1 minute 48 seconds. You have to ignore Mendoza having the line of sight with the weapon before the shooter ever made it inside. You have to ignore Saucedo, Coronado, and Hill, the opportunities that they have, what they knew and didn't do. You have to ignore the building doors being unlocked and how it would have made a difference because you had 3 officers on that one side. That's the point he's making. Even if it would have delaying him right at that point in time could have been the difference, because he's exposed. It wasn't just, can I take the shot? And now he's in the building and you've lost it. If you need time to reflect and think, you have it. And you can verify and you can see what's going on and what he's doing. And if he's going to have to shoot open the door to get inside the school, that's going to be pretty good corroboration for this guy watching that, oh yeah, that guy is a threat. Just in case you had any doubt about who this is or what he's doing, prosecution's trying to suggest, oh, Adrian was in dark clothing. Maybe they were worried about that. Yeah, maybe they were, but I bet if he was having to shoot up that door to get inside, they wouldn't be thinking, but maybe this is the cop and I shouldn't shoot him. The door being locked is just not being locked is just is such a critical fact for me. If you're going to change one thing for this to be different, it's got to be that. What else is it going to be? If there's just one thing it seems so easy to see how it would have disrupted and provided opportunities that they didn't otherwise have, it's that. It's having the doors locked. And that's a hard lesson to swallow because it sure does sound like victim blaming. Nobody wants to blame the teachers after what they experienced. The bottom line is the convenience of getting in and out came above the safety design for the school. They want you to speculate, how things could have or would have been different for everybody but Adrian. They want you to give everybody the benefit of the doubt, but not him. That's not how you are a good steward of justice. And so based on that, the evidence has shown he's not guilty. So Nico's closing. A little disorganized from my perspective, a little repetitive of what Goss had to say. That was my complaint in the opening. I'm like, why are we hearing from two people when we're just kind of hearing two variations of the same thing? A little bit of that going on in the closing as well. Might give the advantage to Jason Goss on the closing over Nico, but it's going to be a question of taste, I think. And at the end of the day, so much of jury decisions are just gut. They already know where they're leaning. And so the arguments are just kind of giving them tools to move the other people on the jury their direction. If they need it. If there's resistance, it's giving them the tools they need to be able to convince the holdouts to go the direction that they are already inclined to go. So I think he delivers in that respect. It's just, is it maybe a little bit too much? A lot of details. Just depends on what you take away, I think. And for me, like I've said, big takeaway was these other guys, man. These other guys. I don't know how you're holding this guy to the standard when you had the other three there at the corner, ready to take the shot, didn't take it, and don't go into the building. I just don't know how you get there. I really don't. To me, that is the biggest flaw in the prosecution's case, is trying to justify that when you're not giving that same grace to him. That there are other ways besides just running willy-nilly towards gunfire. There are other ways to be responding. And if the issue is that nobody ran to the gunfire, then everybody needs to be held equally to account. You can't just be making excuses for these ones so that you can put this other guy in the defendant's chair. For me, that's the big problem. We got the rebuttal from Christina that was it wasn't a rebuttal because it didn't respond to the defense. She had her script clearly already written out. She just had more things to say. This was like this was a closing part 2. This was not a rebuttal. This was not, the defense said this, here's our response to it. And it's because of that, it just continues to emphasize that they don't have an answer. That's been the problem from day one. The defense is pointing out tactics, circumstances, not feasible, can't show this would have made a difference, and they have no answer for that. So they just can't let kids die in vain. Training says approach the gunfire, period, but only him, not the other ones. That's the problem with the case. That's why the case is kind of incoherent. Starts off terribly. Just want to make a quick note that the judge will decide the punishment in the case. Just want to make a quick note. No. This is not grabbing their attention. This is not compelling. You're starting off with an actually. Then she took the bait. Nico's been personalizing it. She took the bait. There's no evidence I bowed to political pressure. Again, with the no evidence. There are inferences. People can draw inferences. People can look at what you did and how you did it, and they can draw inferences about that. And I'm just not sure this was a great thing to draw attention to get them thinking about. Just overlook that. Rise above. If you think the defense is being petty, don't get in the ring with them. I don't know that this was a smart thing to do because it's got me thinking about the political pressure and why you would be doing this. Why would you make all these excuses for these people and not this one? Why are we prosecuting this guy at all? While we're thinking about sending a message, and what message? I might be thinking about what message my verdict would send to you. And I'm just not sure that was the smartest thing to do. And the easiest thing would be to say, because everybody made mistakes, that nobody was responsible. Honestly, this is kind of a fair argument. It really is. In and of itself, it's a fair argument. That was the issue I had with the Rust trial, the Rust prosecution, was that because it always kept coming back to, but the standards, the SAG standards are to do this, and this person is in charge, and it's not his responsibility to check the gun and stuff like that. And the problem is that the way those standards were written was that responsibility is so diffused that everybody gets to point the finger at somebody else and say, if he had done his part, my failure wouldn't have mattered. And so when everybody failed, nobody's responsible. And so I'm sympathetic to that because I just that it resonates with me. It's like a way to excuse your mistake. Well, everybody made mistakes. That's a terrible excuse. Talk about the message that you send. So I'm sympathetic to this. I really am. But they've never taken the position that everybody was responsible. Everybody made mistakes. That's the problem, is your whole case is built around excusing some people and not others. Not a single time did any of these, either prosecutor, acknowledge the doors, the importance of the doors, and what a mistake that was. So you're just not being honest about who's responsible and what they are responsible for. What is the scope of everybody's responsibility? Because you're asking us to single this guy out. You need to have a reason for that. You need to sell it. Why should I hold this guy uniquely responsible if everybody made mistakes? And so they've never been able to come up with a good explanation for why. And it's a big problem. Because you don't now get to hide behind everybody made mistakes. Doesn't mean nobody's responsible. To shield yourself from this accusation of political pressure when you've refused to acknowledge everybody else's mistakes throughout the course of your case. If you had made that explanation, this would land a lot better. They focused on the things that the defendant did, but it's not about doing good things. It's not about handing out participation trophies. She can't even, this is the having to villainize him. She can't even acknowledge the things that he did right. She's got to have him all bad. Sometimes I get the impression that this is like there are prosecutors that do this. They have to turn everybody at the other table into a bad guy. And I feel like there's maybe some kind of like, psychological justification going on with that. Like maybe you have a little bit of internal doubt about the justice of what you're doing. And so you have to turn everybody into a monster to justify it. I remember this prosecutor I dealt with once. This is back when I did all kinds of different things. I was doing like CPS, child dependency cases. And so this was a case where years and years and years before, a woman had lost custody of her child. She had ended up giving the child up for guardianship. So somebody else gets appointed to be the guardian of the child. So once that happens, it's like, okay, the child is safe now. CPS doesn't have to be involved anymore. Well, years go by. She has rebuilt her life. She has, worked with the guardian, rebuilt the relationship with the kid, and so forth. And they've reached a point where she thinks, they think, the counselors think, everybody thinks it's going to be in everybody's best interest to put her back in the parental role. Go ahead and terminate the guardianship. She's ready to be mom again. The kid is ready for her to be mom again. That is going to be the most healing thing for everybody. One person who's not on board with this, the prosecutor. The prosecutor isn't on board with this. And I remember, I just remember like going into court before the first hearing, and I remember the prosecutor saying, yeah, I remember this client. I remember this, this case and this mom, she's a real piece of shit. And that it stuck with me so hard because of how much she was refusing to look at. I mean, first, just the essentializing, right? To anybody to be a piece of shit. Like, yeah, there's some people out there that are like that. But if that's your attitude about everybody that's sitting at the defense table, I mean, then what a sad view on life. What a sad view of humanity. It's just distorted. I mean, the problem is that a lot of times even the victims don't have that stark and black and white a perspective. People who are most commonly victimized are the friends and family of the defendant. And they often have a much more complex and nuanced view of the situation than, what a piece of shit. So this need to villainize him and not even be able to acknowledge, this is what it makes me think of. It makes me wonder, are you overcompensating here because deep down you don't think you're doing the right thing? You have to turn him into somebody who did everything wrong to justify to yourself why we're even here, why you put these jurors through this, why you put these witnesses, you put poor Ms. Marine on the stand to shake and relive the horror that haunts her to this day. Do you feel a little bad about that? Is that why you can't look at the situation fully and acknowledge he did some good things? recognize the nuance here. The fact that he did good things doesn't take away from what he didn't do. That's all you got to do. It's not hard. But just couldn't do that. And I'm not sure the jury is going to see him as a monster. They may not agree with what he did and didn't do. But I don't think they're going to just write him off as, dismiss the good things he did. I think they're going to take that into account. But it's about holding cops to the duty that's imposed by law. It's about holding cops to the duty that's imposed by law. Spell out how he didn't comply with his duty. That's the problem. That's the problem. What are you saying his specific duty was in this situation? We will be happy to hold him accountable. If you can show me what his specific duty was here, how it would have prevented the shooting. You never did that. And so now the prosecution is relying on the kind of philosophy and the big ideas and stuff like that to substitute for the fact that they can't say specifically what he did wrong, what he should have done differently. All of the personal attacks are just an attempt to justify the unjustifiable. All of the personal attacks. Calling attention to that, but then she's not going to stay above the fray. So she says she's not here to send mixed messages. When you take an oath as a police officer, that oath means you'll be held responsible for following it. Nobody disputes any of this is the problem. This is missing the point. Nobody says he doesn't have a duty. Nobody says he shouldn't be held responsible. The question is, what should he be responsible for? Because we can't hold him responsible for the doors not being locked. We can't hold him responsible for that weird air conditioning corner that has to be navigated. We can't hold him responsible for dispatch not immediately conveying the information that they're getting from Mr. Limones. That's the whole point, is not, is he responsible or not? It's what is he responsible for and why? We've had 23 years of mass shootings since Columbine. It's crazy to think about, isn't it? And so they've had a lot of time to study and figure out how to respond. And so the school district has created its own police force. Because of that, these buildings are their homes, the halls are their roads, the students are their people to protect. Nobody disputes any of this. Defendant even said in his interview, the car wreck, when he thought it was a car wreck, it wasn't his responsibility. He wasn't worried about that call. But when he heard there was a gunman near the school and he was going in, that's when I went, because that's his beat. That's his job. Nobody disputes any of this. Their own expert talked about the hot situations he'd been in San Antonio, but there's nothing hotter than this active shooter situation at this school. And if you have the training, you rely on the training, or you figure it out. He had the training. He had put on the training. Defense has made some very good points here about the inconsistency of the training and the way that it teaches them tactically to approach the situation that wasn't going to work, with Adrian Gonzales being alone by himself, without any cover besides his car, with a handgun, with no body armor. Missing the point, not addressing any of that, just head in the sand, pretending those things don't exist. They weren't said. It's not persuasive, not at all to me. If there are jurors in that room that have the gut reaction that I did, and I feel like there's likely to be at least some, because there's an awful lot of you in the poll. I haven't checked the poll. Where's the poll at? 84%, 2199 votes, 84% not guilty, 16% guilty. That's where our poll is at. I am not the only one in the jury room who's got this impression going in. And so she's done nothing to address the reason why this impression landed in the first place. She's just ignoring. It's like it's this part of why she's so aggravating as a prosecutor, because it's like it's disrespectful. You know, you're not showing me the respect of treating me like a thinking and caring human being who wants to get this right, who's concerned about being fair. You're not addressing the reasons why I might be struggling with reaching your outcome. You're just insisting. You're just insisting that things are other than they are. You're just ignoring. I know this is a hot situation. I'm very well aware of that. It's not in dispute. The issue has always been, how are we supposed to deal with it? And the training was kind of a problem. And you didn't address that, because all you've got is the training says run at the shooting, but it clearly doesn't. Nobody needs to be taught. Go towards the threat. They know that. You don't need a week-long training to just be told. If that's the training, you can do that in an email. You can do it in an hour. You can call in and do that over Zoom. You don't need to go through a week-long training, because that's not what the training is. The training is about how. And she's treating us like we're idiots and like our concerns don't matter by refusing to address them. So we're supposed to ignore. Defense wants us to ignore her position, I guess. Say that he's the low man on the totem pole, but he's not. He's the school officer who showed up first. And I think that right there is the bottom line. That's the best justification they've ever come up with for why is Adrian Gonzales sitting in that chair and the others aren't? Well, just because he was the first one there. It's the best explanation that we've heard. If we have to pick somebody, not that there's political pressure here, but we're going to pick somebody. Might as well pick the guy that was the first one there. I mean, what does being the first one there have to do with anything if he's not in the best position to be able to deal with it? And I don't know how you, I don't know how you could say with a straight face and look the jury in the eye that the guy who had the shot on the shooter at the door before he went in was not in a superior position to do something about that threat. I don't know how you do that with a straight face. On any given day, you can have a monster show up at your school. Yeah, we know. We know that. That's why those safety precautions are so important. And why you can't get lackadaisical and think that, well, just because it would be inconvenient to have to open and close the door every time a kid wants to go to the restroom, therefore we need to defeat these safety purposes, these safety designs, because on any day a monster can show up. They'd have you believe that there was confusion. He was confused because there was a wreck and because bailouts happen, and that means don't hold me responsible. You're the one saying that these other three are not responsible because they were justified in driving away because they thought it was a bailout. Your other prosecutor, Bill, just said that in his closing. He just said that's why it's okay for them. They're not responsible. Like how do you not see? How do you not see? Were you not listening to what he said? It baffles me. How can you be so unself-reflective to not see that this is you doing this? This is not the defense saying, don't hold me responsible. The defense is saying, hold me responsible for what is in my power. Don't hold me responsible for what I am helpless to prevent or helpless to do. Because he wasn't assigned, he's not responsible. This is doing that thing that I said. If you're going to caricaturize the defense argument, you need to be fair. This is not fair. This is not what they're saying. That because he wasn't assigned to the school, he's not responsible. Never said that. Because the doors weren't locked, it's not his responsible. Definitely didn't say that. Nobody said he's not responsible because the doors weren't locked. What they're saying is that the doors not being locked made it a whole hell of a lot harder to do his duty. Because it made it a lot harder to know where that shooter was. It made it a lot harder to intercept him. It gave them a lot fewer options to address him before he ever got in the school. Doesn't mean he's not responsible, but he's still over at the far end of the building where the guy is not in his line of sight and he doesn't know where he is. He only had a pistol, so he's not responsible because the other three showed up. Don't hold me responsible. It's just like deliberately missing the point. It's like deliberately missing the point. And it's insulting. It's insulting. Like you're talking at us like we're too stupid to know any better. I heard what the defense said. None of it was about he's not responsible for all of these reasons. It was he's not responsible because his duty is limited to what's in his power. And you've never showed me that it was in his power to do something different that would have changed the outcome. And that's on you. So all of the, kind of throwing the personalizing back at them, they're saying he's not responsible. Don't hold me responsible. Maybe you're mad because you didn't do that. Maybe just on some level. I don't know. Then the whole part about the kids and the teachers, they lock the door, lights are out, be quiet. And that's just teaching the kids to practice for impending death. I mean, just really going all in on this, trying to get people upset and to focus that on him. Teaching the kids to practice for impending death. So unfair. It would be fine. It would be fine to be arguing about Adrian Gonzales's responsibility if we had some clear picture of what was in his power that he should have been responsible for that he didn't do. But by making him responsible, you've made him responsible for everything. Okay, because if I take all these things that you said, well, he's saying he's not responsible for that. Oh, are you saying that he is? He's responsible because bailouts happen. He's responsible because the doors weren't locked. He's responsible because he was only issued a pistol. Because he was responsible for all this stuff that's not in his control. The kids are just practicing for death. I mean, she just had nothing left at this point but outrage is really the only way that I can take this, because it's just so unfair. It's so head in the sand. It's so ignoring the issues, the problems with your own case, and why people might be inclined to think that in the first place. You got to give the jurors a little bit of credit for having their own minds. Going back to the quarterback, you gotta, somebody said, you gotta build your offense around the limitations of your quarterback. You can't just expect him to play like a quarterback who is 6'5" and super nimble and comfortable in the pocket. If he's not, if you design your plays for a 6'5" quarterback who's really nimble and comfortable in the pocket, your actual quarterback isn't going to perform well. You already know that. You really need to build your case and your argument to the concerns the jurors may actually have. If you can't be honest about that, you're not gonna capture them. She's making this argument as though they're all already on her side. And maybe it's just an easy habit for prosecutors to get into, you know, because they're used to winning. They're used to trying cases that you know, they have so many advantages. A lot of cases where the reason we're going to trial is not because of the strength of the evidence, but because of the personality characteristics of the defendant. So maybe you just get so used to getting that benefit of the doubt that you take it for granted. I don't know how else to explain this. I really don't. She's saying they want you to ignore the active shooter training that goes to the shooter. How? How are they supposed to go to the shooter? I'm sending a message. I am sending a message because those days are over. The days of the kids dying in vain. Those days are over. Well, if we don't address the doors being locked, if we don't address the people not showing up with the right equipment, if we don't address the dispatch not timely communicating the information, if we don't address the radios not working, if we don't address all of the other failures that went into this, you're not fixing anything. And unfortunately, those days are not going to be over. Because next time the officers do everything perfectly and they show up and they still have no shield and no rifle and no way to stop this guy from going in the building, I don't think we're going to get a different situation. We're going to end up in the fatal funnel. Okay, we do it differently this time. He goes in the door by himself and the shooter shoots him. Those days are over because now a cop is dead along with all the kids. Ugh. His statement is telling because 3 times he said he walked. He walked here, he walked there. Whereas Flores is saying, I ran. She told him, I ran and we need to get in there. Compare those two. This is not persuasive. Where is he supposed to run? Why is he running? Is he just, if he had run somewhere, would he be getting the benefit of the doubt that Mendoza, Saucedo, and Coronado are getting just because they went somewhere? Because they went somewhere, they acted. If he had just run somewhere and done nothing, is he, I just, because he didn't run, because he walked? Really? This is where we're at? Are we holding teachers to a higher level than cops? No, ma'am, we're not, because no teacher has been placed in that defendant chair. I don't think you have to worry about that. That somehow if we don't convict him, we're holding teachers to a higher standard. Nobody ever said the teachers need to go into the hall. Nobody ever said the teachers need to go confront the shooter, distract, delay, and engage him. They are marginally less equipped than Mr. Gonzales is to do that. But sure, if all of the teachers had run out to the hallway, swarmed him, could enough of them, you know, if they do a flight 93, you know, just overpower him with your numbers. Yeah, a lot of teachers are going to get killed, but could you have stopped it? Maybe. Nobody is freaking saying they have a duty to do that, for heaven's sake. Be real. Be real. All anyone has said is, would have been great if the shooters had locked the door, or the teachers. If the teachers had locked the door, might have changed. Might have changed some of what happened. Is that holding them to a higher level than the cops? No, it's holding them to the same level of safety, putting safety first, being tactically smart. The parents, got to bring up the parents because we got to tug at the heartstrings. Salinas and Torres left their kids. Next time they saw them was at the hospital. Garcia left her daughter for the pizza party, told her you have to stay because she'd already paid, and then never saw her again. Yeah, we know the family suffered. We know. That's not what this trial is about. What happened in Uvalde can happen anywhere. The fact that they're trying this in Nueces County and not in Uvalde County, it could happen here too, guys. So think about that message. Adrian, he had his car, he had cover. The kids didn't. They had chairs, they had desks. The defendant had a pistol. They were unarmed. They had teachers without weapons. He had a vest. They had curtains. They should have had locked doors. They should have had locked doors. They should have had 2 layers of locked doors that the shooter had to get through. You know, if we want to go real crazy, maybe they should have had police officers, first responders, equipped to deal with this. Maybe one of them should have had a shield. Maybe the school should have paid to go ahead and put in those electronic key fobs so that we aren't using the magnets to defeat the security system. But the school district doesn't want to pay for that, and so now Adrian is responsible for that too, I guess. Because he had a pistol and he had a vest that's not going to stop a rifle round, but he had it. So he should run to certain death because the children are exposed based on circumstances that were not in his control. He didn't unlock the doors. He didn't not take the shot at the northwest corner. The prosecution by facial expression, I don't know what she saw. I feel like if you're going to make a point like this, okay, Ranger Hill asked him in the, or the Ranger, not Hill, but the one doing the interview asked him, why didn't you engage? And he gave a look that was like, not me? Really? You need to put that face on the stand because this is just kind of ridiculous. If you think this is so persuasive that I should convict a guy based on your interpretation of his facial expression, do you not trust me to make that judgment for myself? Am I to just take your word for it? You should probably show something like that. Show, don't tell. Basic rule, right? Basic rule of trial practice. Didn't show it, just went through this this expression. So they'll have the radio traffic, points out they'll have the radio traffic to decide if it's 1 minute or 3 minutes, but it's a long time either way. And he had the backdrop. This is where she went to. He had the backdrop over here at the parking lot and the funeral home. Everywhere outside of the shooting range is a backdrop. It all has a backdrop. Okay. Everybody had a backdrop. I don't even know. I don't even know how you use that excuse. If you're going to need to fire your weapon in a populated area, which police officers are sometimes going to need to do, there's going to be a backdrop and a risk of overshoot or missing or whatever. It doesn't mean you don't take the shot. It means you assess the relative risks. And gee, this guy who's been shooting things up on his way into the school seems like a pretty big risk. That's the whole point you've been saying in this whole case. This was an obvious risk, right? There's no reason to be confused about the bailouts and the road rage and just what, and maybe he was passing through the school. No, that's only for other people. You're saying he was an obvious risk. So you take the shot. I know the case has been really difficult. And she paused a long time. Yeah, the case has been really difficult. And who's responsible for that? Is Adrian responsible for that too? I bet actually don't even ask that, because I would bet anything this is the kind of prosecutor who would say, yeah, it's his fault. He could have just pleaded guilty and made all this go away. He could have just pleaded. He's the one that made us go through all this. I sincerely believe this is probably that kind of prosecutor with that mindset, based on just how I've seen her so far over the course of this trial. The way that she like blame shifted for their own failure to disclose the new information. You know, it's their fault somehow. They should have known. They should have been on notice. How? Never explained that. Because in fact, they didn't know and wouldn't have had any reason to know that she's going to claim out of the blue that she saw the shooter down on the south side of the building when she had never, ever claimed to see that until she talked to you in her interview before trial. But somehow that was all the defense's fault, and it doesn't really matter anyway. She is the kind of prosecutor who will blame Adrian Gonzales for the fact that we're having a trial because he could have just pleaded guilty. So the difficulty of the case and where that responsibility lies, I don't suspect is something she is being very introspective about. But we can't continue to let children die in vain, so that's why we need to return a verdict of guilty. That's all it's going to take, guys. Verdict of guilty, all these other issues wiped away. Doesn't matter. It means it won't ever happen again, even if the doors stay unlocked, even if the shields continue to not arrive, et cetera, et cetera. I feel like in many ways the rebuttal kind of made things worse. If you weren't already on the state side, I feel like the rebuttal made things worse. It did for me. I mean, it did for me. I think it was a bad call to end with her in the first place. Primacy and recency, right? First thing you remember, last thing you remember. Last thing I remember before I go into the jury room is this insufferable woman with no insight, no ability to pause and see things from another perspective, like somebody who disagrees with her might see things. No ability to put herself in those shoes and address it honestly, directly, and straightforward. The last thing I've gotten is just this super obnoxious lady who deliberately misses the point and mischaracterizes everything the defense has to say. So if I'm already on the state side, it's probably great, probably enjoying it. Ooh, she like really dunked on him or whatever. But I don't think the odds are probably pretty good that all or even most of the jurors are already on her side. Not if our poll here is anything to go by anyway. So now we wait. Now we wait. We've got quite a few comments and questions to be able to go through here. I also I starred a whole bunch of things just kind of as they came up in the chat when I saw them. So we'll just take through some of these. Pantoufle D. I'm going to assume it's un nom français. Watched all of Peterson trial and the jury got it right. Eiglarsh A+. Many will only ever read headlines and still blame him. Hurts too much to watch this one, but thank you for covering. They blamed him immediately. I plead guilty to this. I really do. I didn't watch any of the trial. And that's the thing. Like, I can take your word for it. I watched the interview on Peter's channel on Lawyer You Know, and I completely believe like everything that they're saying. I still have the gut feeling, you know, and but I recognize like it's totally on me and it's probably completely unfair. It's just there. Maybe I do need to go watch that at some point, or at least do something to kind of get more familiarity with the facts. But this one has really changed my perspective. It really has. I did not come in with a lot of sympathy for him. I really didn't. I'm open to this either way, but like my kind of gut inclination is, yeah, you know, you're the cops. You are the ones. You are the ones with the responsibility to keep us safe. It's literally what we pay you for. It's what we give you, all this power, the gun, the badge, all of it. All of the cost that we have in society, because the cost of having good cops is some bad cops, and bad cops cause a lot of damage. And we tolerate all of that because this is their job. Their job is to keep us safe from the monsters in the dark. And so when they can't do that, I understand it's the gut instinct to blame them and to feel that they're responsible. And I have such a hard time getting past that in myself. I mean, I'm aware of it now with this guy, Scott Peterson, the guy at Parkland. But I just, this one definitely changed my perspective. And I know too, like the facts here are way worse than they were in that case. That case, it was like 90 seconds before they went in the school. 73 minutes. Just unbelievable. But it is just more complicated than the gut reaction. I definitely realize that now. Homestead on Potosi, 6929. Texas allows certain school officials to be armed. They have signs at my kid's school. I brought this up just because this was interesting to me. I didn't know this. I know this is one of the things that kind of comes up repeatedly when there's school shootings. How do you deal with it? What are the ways to handle it? And often you have these kind of polar sides of take away everybody's gun, give everybody a gun. And like neither of these are really feasible, right? And just, I understand this is a political question about how to deal with it. So Texas has chosen this approach. They're going to allow some school officials to be armed. I mean, even just having an armed police officer on campus at the school potentially made a difference. It might have. I don't know, if only being, one other person there who's able to get information, able to get in position and stuff like that. Even if it's just the shooter went to the school, he's familiar with the school. If he knows there's somebody armed there, it might discourage him a little bit. I don't know. But I am curious about this. Like, when did this start? Which school officials? Is it working? How's it working? Has it been tested? I don't know. But I found that interesting. Carrie Cherry 75. Did Adrian get fired from the police department as a result of these charges, or had he been fired or resigned, retired beforehand? I don't believe he's been fired. I was trying to look this up, and if anybody has a more definitive answer, definitely let me know. But no, I don't think he has. I think he's been on leave this whole time. Because I wasn't able to find any kind of like formal confirmation that he got fired, that he lost his job. I think he's on leave, like waiting for the outcome of the decision. Now, the chief, who's the other guy who's going to be on trial, Arredondo, he lost his job. And that's why, like, I kind of don't think he did, because we heard about it with Arredondo. We didn't hear anything about it with Adrian. So I don't believe he did, but if anybody knows otherwise, definitely correct me. Tammy Glassenap Simon, 4941, you'd think all schools would learn from Columbine High in Ohio. 23 years we've had to learn, right? Here's the problem. They have learned, but you got to implement what you learned. They talked about in this trial the Columbine doors. Columbine doors, like with how they're designed and how they open and how they lock and all this stuff. But if you just bypass that, it's not going to do you any good. It's not going to do you any good. So it's just a shame. But I think part of the problem too is every situation is a little bit different, and it's not just the schools that are learning from this. The attackers are learning as well. They're finding the vulnerabilities. You know, the guys that are like the copycats, looking for glory, looking to, you know, get their name out there. It's because they've studied these. And so they're learning too. And you end up in this kind of process of it's like an arms race a little bit. It's very sad. Pantuffelton, I live near Brown University. To think it's not going to happen here is foolish. Schools don't learn from other schools' tragedies. They only seem to learn from their own. That's tragic. I'm afraid in this situation, they may not even learn from their own. If this is the takeaway, I'm not sure what they're learning. I really don't. Because there's no accountability for the basic, gotta lock the doors, man. Can't leave those doors unsecured. Donnie Not Wahlberg, thank you for your time in covering this case. Free Runkle. Hashtag free Runkle. I agree. Hashtag free Runkle. If anybody, I haven't checked in, but if anybody is so inclined to send your request to Team YouTube, please take a look at this and get it fixed, because Ian is not a community guidelines violator. We need him streaming about this case. So my pleasure to be here. I mean, such as it is, but I didn't want to miss the closing. This was going to be important, even though I'm a little bit behind in getting my updates out. Cracked Pot Christian, I have only started watching this trial yesterday. Did AG take the witness stand? He looks to have integrity. He did not, but he didn't have to, really, because they played his interview that he gave when they were, you know, in the aftermath of the shooting, doing the investigation of what happened and how they responded and so forth. He gave an interview. And so they played that, and it really took the pressure off of him because the jury got to hear his story. So he didn't really have a need to get on the stand and just kind of repeat it. I did, you know, develop some sympathy watching him over the course of the trial myself. This is one of the things I saw, was just how he reacted to the emotion of what was happening on the stand. You can just see he's an empathetic person. He reacted to it. He's not just like cold and unaffected by other people's feelings. And so it did give me some sympathy. He's not a monster. If he's feeling other people's suffering, then he is carrying the weight of what he wasn't able to do, because he's carrying the weight of the horror that everybody experienced in that school, the loss of the families, the grief. He's going to carry all of that if he's an empathetic person. And so it is one of those situations where, for me, I kind of You know, I do. I kind of question, like, what's the point of this? Is this gonna punish him worse than he's already punishing himself? And to what end? What's the reason? You know, we're not gonna like rehabilitate him by sending him to jail. So what's really the point of this? That's me. People may disagree, but that's kind of where I'm at with it. I watched a 2-hour documentary I found on YouTube last night from 2 months ago. They had more body cam and inside school video as well. Yeah, no word salad. I haven't watched a lot of what's out there, but I know that there's been a lot of public records requests early on, and so like a lot of the body cam got released. They didn't release the graphic stuff, which is appropriate, I think. But yeah, there's images out there of them in the hallways and stuff like that, and you can kind of see from their perspective what that was like. Carly F 7460, Andrea, if they find him guilty, how many years is he looking at? So what I was able to find out is that it's a 2-year sentence is the penalty, the max penalty for child endangerment. So the big question is that 2 years, like 2 years total for all 29 counts, or if they convicted him on all 29 counts, is it 2 years for each one? And that's the consecutive sentencing versus concurrent sentencing question. It looks to me like it would be concurrent. Texas has some rules for when consecutive sentencing is allowed, but it doesn't look like it's going to apply in Adrian's case. So it looks to me like we are talking about a maximum of 2 years for all counts is what he is potentially exposed to. Good old mod, CH, just CH. Would a crying clerk be grounds for an appeal? Definitely not if you don't call it out. You know, they never made an issue of it. It would probably depend on the circumstances, but it's not good. It's not good. What's particularly not good is if you're getting like differential responses, and that's maybe a little bit more of a close question to me. Like when she's not super expressive, but there did seem to be like some kind of micro expressions there. She when the prosecutor's talking, she looked like her eyes are kind of watering, and when I see her while the defense is talking, she seems more eyebrows pinched. It's just more of a skeptical look. But I'm also getting a very limited view. You know, we just see her when the camera goes in that direction. I don't have the view from the whole courtroom. I don't know if there's an issue or not. Defense didn't call it out, so that's kind of the bottom line. It won't be in this case because nobody made an issue about it. Chronicles of JB, he said, I'm not going in there. Done. That might be enough for some people. It might. I understand. But the reality is he did go in there. The reality is he did go in there. He didn't go in there alone and unprepared and unarmed and uninformed about what the situation was. And so if that's what his duty was to do, then, then he's going to be found guilty if that's the way that the jury sees it. I just don't think it's that simple. I don't think I'm alone in that respect, but I understand this. I really do. I really do. It's exactly why I felt the way that I felt about Scott Peterson over there in Parkland. Like, how do you not go in? You hear kids being killed and you don't go in. And it's a problem in this case too. Because by the time they got in, the damage was already done. They had already heard it happen. How do you not go in before that? It's hard to imagine. It's tough, but trying to separate the emotional reaction I have to that to the dispassionate assessment of what the options were. And I don't like it, but I'm not real sure that I see he had another option that was going to do anything other than potentially get him killed. Maybe you take that risk anyway. This is not an easy case. I saw this one, wanted to call it out. Kim C7980. Does anyone know if Andrea will be covering the Aaron Spencer trial next week? I don't have plans on it. It's another one where it might be difficult to get information. If you're interested, definitely follow Defense Diaries. I mean, Bob and Ali Mata, they've been like super into this case for a long time. I think they're planning to be there. So my take on it is likely just going to depend on the quality of the information that we're able to get. And at this point, because there's not going to be cameras, there's going to be limited seating. I'm not expecting there to necessarily be very good information. So not really planning on following it for that reason. Kelly JG76. Why is the only person on trial AG who didn't run into a sword fight armed with a nail file? What about the men with equal size swords? AG is NG. The comparison is to me the biggest problem. If you're saying this is the duty, then this is the principle of law enforcement response. It applies to all of them. So you have to hold them all to that same standard. And the fact of the matter is, Salcedo, Coronado, Mendoza, they're in at least the same position that he was in that they are on the scene before the shooter gets in the school. They are aware that he is shooting. They are aware that there is a risk. And he didn't do what the prosecution is saying Adrian Gonzales should have done. Run towards the gunfire. They didn't do that. So I just, if this is supposed to be a simple, uncomplicated, easy to apply standard, then I don't have a good explanation for why these other guys aren't also on trial. And why we're making excuses for them that we're not going to make for Adrian. Tracy talks a lot, 1513. Was he supposed to just intuit there was not more than one shooter? See, this is an excellent point. I wish the defense had made this point because it's a pretty important part of the orientation, isn't it? You're hearing that something is happening, but if you don't have eyes on it, you don't have the information. Yeah, how are you going to know? You're hearing a lot of gunshots and you're just to assume these are all from the same gun. It's all just one person. This is such an excellent point. I would have loved to have seen the defense pick this one up and run with it. Because, yeah, okay, he's supposed to run towards the gunfire. Just, what if there's more than one? What if there's more than one and he's by himself? Okay, maybe he takes out one. There's still somebody else there. Can shoot him dead. It's the whole problem. What did he know and when did he know it? At what point? At what point was he confident? It's just one guy we got to worry about. Excellent point there, Tracy. Polly Pocket's power trip. I feel like this is the dress rehearsal for the Chiefs case. I mean, if it is, it doesn't, I don't think it bodes well for the Chiefs case. There's just too many things they haven't answered. Maybe that's what their feedback is going to be. If Adrian Gonzales gets acquitted, then maybe that's going to be the takeaway. Is just, okay, we'll talk to the jury. We'll find out why, what didn't land. Oh, you mean we should have provided some kind of alternative explanation of what he should have done? Something specific about what his duty was that he didn't do? Some reason why we're holding him accountable and not these other people? Well, we have that for Arredondo, right? Because he was in charge. We got at least some reason to hold him to a different standard than we hold the people that were not in charge. They're not the chief. They're not just responsible for the scene and what they're doing in that moment, but the preparation for it, the organization of it. He's the leader, then there's a lot more of a buck stops here kind of argument. Now, does it make him criminally responsible? I feel like if they don't learn this lesson about you really need to account for the things outside their control, and how fast this was able to unfold. And you need to provide a clear description of what the alternative course of action was that he didn't do that could have prevented it. I mean, it's just going to be the same thing over again. So, I mean, I guess whatever outcome we get here seems likely to predict what's going to happen with Arredondo, because those are big hurdles to overcome, and there's a reason for that. Because this was a difficult situation. And if it was easy to just come up with here's the, the different tactics, here's the action he should have taken, they could have very easily had somebody testify to that. Mark Blaine, 8438. Where did the kid get the gun? Where are the parents? The kid turned 18. The kid turned 18 and then went and got the gun for himself like the same week, like within days, if I remember right. Where are the parents? I mean, I don't think there's a lot of dispute about these were not ideal parents for a kid like this. But in terms of like their ability to prevent this in a real proximate way, right, and not in just a long-term be better parents kind of way, we always like to think that. Problem is, if this guy's a monster, monsters are always a complex combination of nature and nurture, right? Some of it's beyond your control, some of it is, and it's just very hard to know, where things would land. So, I don't know. I don't have the kid's whole bio. I don't have his whole life story. I don't know the whole life story of his parents. Is there room for better parenting? Like almost certainly, yes. Usually with criminals, there's environmental factors involved. But as far as where he got the gun, he got it himself because he became of age, and seems like he already kind of had some idea of wanting to do something like this. So did it very quickly. Stephanie B, I feel like he should have went with the bench trial. I don't know. Bench trial is a big gamble. Bench trial is a big gamble. You got a judge who might have political accountability to the same people that the prosecutor has political accountability to. So if they're subject to political pressure, judge is in a real similar position. You got one person to convince instead of 12 beyond a reasonable doubt. Almost never am I going to favor a bench trial. This is me personally. My approach was always the bench trial. It's a slow guilty plea. It's a slow guilty plea. The judge does not want your client off. They don't want to acquit defendants. You might get a special judge from time to time, one that you can count on, one that one that is going to give them the benefit of the doubt, one that has a record of being able to make hard decisions that aren't politically popular. But you need to know that going in, before you make this type of decision. It's a slow guilty plea. The reason why you do a bench trial is because you're not going to plead guilty because you have some issue. You're trying to preserve your right to appeal. That's my view on it. It's not absolute, but it's pretty much my starting point. So you're going to have some pretty special facts for me to feel like a bench trial is going to be preferable. Alyssa Ramirez, what are the chances Gonzales is being prosecuted to reduce the city's civil liability? Is it comparative fault? This is a great question. It may have started out that way, but it is not that way at this point anyway, because the families did sue the city, but they've settled. That case is already settled. So there's not going to be any impact one way or the other on that outcome, based on whether Adrian Gonzales gets convicted or not. Now, I do believe there are some other lawsuits that are still outstanding. I don't know a whole lot of details about them. I do remember there's like a class action, or there was. There's a lawsuit that was filed against like all the officers, a whole bunch of them anyway. So there's other lawsuits that are outstanding. Would this affect it? Maybe. But I'm not sure that not sure that liability in those situations is going to be a whole lot stronger than it would have been for the city. There's just going to be all kinds of issues with qualified immunity and, yada, yada. Process of being able to sue the state and who's responsible and so forth. A lot of complications with that. So this is possible that there's a kind of some liability strategy that's behind it. I can just say, at least as far as the city goes, it's not for that because they've already settled. Farm Mouse 3011, I'm all for cops being held accountable for their actions or lack thereof, but the Supreme Court has already decided cops have no duty to protect. I talked about this in the video that I did where I looked at the law that's going to apply here, or at least some of it, because this is the Castle Rock Doctrine. The issue, though, is that that's the constitutional floor. That is the Supreme Court saying, as a matter of due process, the police don't owe you this duty. But that doesn't mean that states can't voluntarily decide to impose a higher duty. And so that's the point that the prosecutor was making. That's the point of the statutes that deal with that duty that we looked at early on that were cited in the charge. Texas legislature gave these law enforcement officers specific duties to how to respond to crimes committed in their presence and threatened injury to the extent that it's in their power. And so states get to do that. You get to do things above the constitutional floor. So that's why it's going to matter in this particular case. Rebecca D 2919, while watching these cases, do you ever get a sense of whether any of the lawyers feel like the jury is generally on their side or not? Yeah, you pick it up. You can tell. You can tell pretty well if you've connected with a jury or not. Sometimes it's not so much that you can tell you've connected as much as like you can tell when you didn't. If somebody's really not on your side, sometimes you can pick that up. I remember this closing I gave once, and it went into a long deliberation. The jury deliberated for like a week, and it was agonizing. And so they're clearly split and had a lot of things to work through. But I remember giving my closing, and there was one point where I paused, like just to kind of gather my thoughts. And there's a juror that's sitting in the front row, and I see her look at me like. So I kind of knew right off the bat, I don't have that juror. It's pretty obvious. Pretty obvious I don't have that one. So yeah, I mean, I think that they do get a sense. Now, jurors are really good and most of the time are trying really hard to have their poker face on, to not reveal it, not give away what they're thinking. Because they're trying to be fair. They're trying to do their duty. And they're trying not to prejudge, and they're trying to follow the instructions to wait until they get into deliberations and so forth. But you can always tell if you've connected with somebody. You can see how they react to what they do. You can see if they laugh at your joke. You can see if they, glare at you. You can see if they're looking at you. You can compare how they're responding to you versus how they're responding to the other lawyer. You typically get a decent idea, at least for some of them. Our writer, thank you for your coverage and insights. Thank you for being here with me. It's made getting through the closing a lot more fun, entertaining. It was a bit of an early morning, but hey, we're only going on 8 hours now. What's a good long trial day on stream? We haven't had one for a while. Shan Pickle. Andrea, oh, yes, I had to highlight this. When speaking with a Spanish accent, the words are spoken more towards the top in front of the mouth. In front of the mouth. Yo entiendo. Yo entiendo. I get it. It's just hard to do. Like I know in my mind, and I can even do it like sometimes. I think part of the challenge with the names is for me, and it's what impresses me so much about Nico. It's the switching back and forth between I'm speaking in English, which is much more. It's rounder. It's much more in the middle of my mouth, and then being able to like flip into the Spanish. You kind of bring it forward more on the tip of your tongue. Yeah, I totally understand what you're saying. I can imagine in my mind. It's making yourself do it, making the body do the way I envision it. Doesn't always work, but it's just a question of practice, right? I got to keep practicing. I got to get down there to gotta get back down there to Chile so I can keep working on it. Melissa Garcia, when I was in the 5th grade, I was lucky enough to be a school safety patrol officer. Even at that age, I knew my duty to my classmates to lock the giant metal doors we had. Those doors make me sick. Yeah. The doors, I mean, and that's, I feel like in so many ways, that's maybe at the heart of all of this because it does. The doors are such a deep regret. And they're going to be for everybody that survived, and nobody wants to make it worse for the people that had to endure this and are having to deal with the aftermath. Nobody wants to make it worse for them, but we can't look past. Nobody made this choice maliciously. Nobody did this thinking this was going to happen. That's the whole point. They let the doors stay open because they never thought this would happen. They got complacent. And it can happen to anybody and it can happen anywhere. And if we don't learn that lesson, I don't feel like this trial is going to teach them that lesson. If we send the message that it's Adrian Gonzales' fault, this is clearly not something he was responsible for. It seems so obvious that it would have made such a difference. It does. It makes me really wonder about the point of all this and why we put everybody through this. If we can't even acknowledge this basic that a 5th grader would know how important it is to keep the doors locked. But it's easy to just think it's not going to happen. We're a small town. We'll have time to do it. I mean, whatever. It's so easy to talk yourself into prioritizing the comfort over the security. And I think part of the risk too is, we live in this time. There's so much security theater. I think about the flights, and we still got to take off our shoes. I guess not so much anymore. They've finally gotten away from that now. 25 years after 9/11, we get to wear our shoes on planes again. Get to bring at least like some small bottles of liquidish things on the plane. I mean, has any of that ever stopped anybody? Really not sure that it did. But it's this theater that we have to go through. And I think the risk of that is it makes you discount a lot more of the security, the things that really are legitimately needed for protection, even though the likelihood of something happening might be low. But if it did, you're going to want this in place. The likelihood of somebody, hijacking a plane with a, shampoo bottle, not impossible, but it doesn't really seem that high, to justify, okay, we'll take away everybody's shampoo bottles. Just so many other ways that things can go wrong. But this one, locking the doors, like there's no question. But I think it's easy to think, all this stuff is bullshit. We don't really need it. You get fatigue, you get security fatigue in that kind of environment. So I do wonder about that a little bit. If that's just part of what contributes to complacency about something like this. Tara Rayner, Adrian was in dark clothes in their line of sight, and they didn't take that shot either. They lost me when he was the only one charged. Yeah, I mean, the asking to take the shot, that was kind of a weird thing. It would be one thing if, I suppose, if you've got specific policy that says you have to, get clearance to take the shot before you do it, but that really wouldn't be feasible, would it? Because how on earth would you deal with that in a emergent situation? You're at the traffic stop, the guy pulls the gun, you got to stop and radio for permission to deal with it. It's not practical. And I'm somebody that's more than willing to blame the lawyers for a lot of these problems, right? Because people are worried about, am I going to get in trouble if I do this? People are going to hesitate because they don't want to get sued. They don't want to lose their job. They don't want some lawyer coming at them being like, you took the shot when you shouldn't have. But in this situation, I have a hard time kind of reconciling the asking for permission to shoot and not taking the shot. I would have liked to have heard from that officer. I really would have, because it's not that I can't imagine any possible explanation. I mean, the best explanation I can think of off the top of my head is because he wasn't sure. He had doubt. He was trying to get confirmation that this is the risk, this is the target. It is, in fact, a serious risk. It warrants my use of deadly force here. Because that's what he's worried about. If I use deadly force here and it's not justified, my ass is on the line. Why? Because lawyers are going to come at me. So I do understand that. It just would have been nice to hear that and then be able to explore that. It would have helped put all this in context. But just because the prosecution wasn't willing to acknowledge that this was even a problem, this was even something that might cause people to question, why is Adrian Gonzales sitting in that chair? They chose not to call him and give us that. Maybe it would have made a difference. I don't know. Carazola YT, why didn't the prosecution just play Die Hard from start to finish for the jury and say, why didn't he do that? Easy conviction, obviously. Yeah, just play a movie. Just play a movie. Just show that scene from Game of Thrones where Jon Snow, standing there with the sword while the thousands of, warriors are charging at them on the horseback. And that's all we're asking Adrian Gonzales to do is just that, right? Because it's a movie and we know he's going to get saved somehow. He's going to, not get trampled or whatever. Even if he dies, he's going to come back. I'm not going to apologize for spoiler alerts on the Game of Thrones because it's been out for quite a while now. If you missed it, that's on you. But that's the whole problem, isn't it? I mean, they know, it's like they know. I appreciate how Nico kind of put it like that they can't seriously believe what they're saying. Like, they got to know what they're saying is bullshit on some level, because they have to know that the best case scenario is that they're just imagining something. They're just imagining a scenario, and you can imagine anything. There's no limit on what you can imagine. But they know on some level that that's too far, because they would have presented something. If they could have imagined something that seemed credible, well, then you would have presented that as, here's the thing that he should have done. But it's like they know on some level that there's There's nothing you can do but fantasy. You can't rewrite what already happened. Debark 09DB, ex-PD dispatcher here and baffled by the police response. Resigned partially because I didn't want to end up in the blame game circle if something went wrong. This case solidifies my choice. Yeah, that's hot potato, isn't it? Who's gonna grab the accountability? Who's gonna grab the accountability? Nobody's gonna step up and say, it's me, I'll take the fall. It would be the honorable thing to do. But it's not consistent with people's self-interest, people who want to keep their job, people who want to keep their standing, people who want to keep their self-respect. Well, maybe you would. Maybe self-respect would come with accountability, but especially if you're the only person. I mean, that's the thing that I have a hard time with. It's the taking responsibility for all of the other failings that I'm not responsible for. That's the part that's going to be a problem for me. I'm happy to acknowledge my own mistake. I've had to do it before. It's not fun. Nobody likes it. But knowing that that's what's going to happen, it's just going to be a hot potato game. Yeah, I think you're perfectly justified in worrying about is somebody going to be trying to toss that thing at me? And then what do I have to do? I don't want to take the responsibility for everybody else's failing. But the only way for me to get out of that is to toss the potato right back at other people. And it just becomes this circular game of finger pointing, because when everybody is responsible, nobody's responsible. But it's not. It's everybody is responsible. It's just that responsibility doesn't have to mean people get charged with crimes and go to jail. Sometimes that's just not what responsibility looks like. Sometimes responsibility looks like you live with guilt. You live with remorse. You live with the knowledge of what you could have done differently. You live with the fact that other people know that there's something you could have done differently. Yeah, this is a tough one. And can't say that I blame you for having that response. Bunny Love 21, help me settle a debate. I have no law experience. I'm just a bartender, but I love justice and I love due process, and I want to go to Arkansas to watch the Aaron Spencer case. My husband thinks that's very strange. Is it? It's unique. Not everybody is so interested in cases that they want to go actually watch them in court. I tell people all the time, go watch court in your own community. Like just go to some trial. You don't even have to wait for a trial. Just go check out the docket and see what happens, because almost nobody does it. It's a very unique thing to do, to take an interest in court to the point of going and being there in person. So in that sense, it's unique. It's different. Not everybody does it. Is it strange? I mean, is it any stranger than reading the news, paying attention to what's happening in the Supreme Court, paying attention to what's happening in the legislature? Why would it be any stranger than that? This is one of the branches of our government at work, and at work in one of the most direct ways that the government affects our lives. Literally one specific person whose liberty is at stake. The government is trying to put them in a box, lock them away in a cage, put the scarlet C, the criminal, the scarlet C on them, take away their rights to vote, their rights to own a gun, their rights to have certain jobs, all of those types of things. I mean, this is the government at work. Is it a strange thing to be interested in? I mean, not to me. Not to me. I see a lot of people interested in the power dynamics of our government. And so this is no different than that. It's just a particular manifestation of it that maybe doesn't get quite the attention that other forms of government do, but it doesn't make it any less important. In many ways, it's critically important because the legislature doesn't put people in cages. The legislature sets rules, and then it happens here in the courtroom. This is where it gets carried out. So strange is a bridge too far for me. I wouldn't say it's strange, but it is unique. It is unique. But hey, I'm not going to tell you not to do it. I did it in Delphi. You know, it's sometimes there's just no substitute. Just got done saying, I mean, I'm probably not going to follow this case real closely because it's going to be too difficult to get good information. I'm going to probably follow Bob and Allie. You know, if I pay much attention to it, that's more than likely going to be where I get my information because I expect that to be the best information that comes out. So I don't take any issue with if it's a case that you care about and an issue that you care about, and we already know the media is not going to report it fully. They're likely to not report it fairly. They're not likely to not report it accurately. It's just is the way it is. And you have media with limited sound bites and limited page space and so forth. And they're not lawyers. They're not trained in it. Many of them are not like courtroom experts at all. They're just reporters. This is what they happen to be reporting this time. They don't know what they're seeing. They don't know what matters. They don't know what doesn't. So it's kind of normal that run-of-the-mill legal journalism is just, it's not particularly reliable or helpful. And so knowing that, wanting to go see it for yourself, I completely understand. It's the only way you are going to get good information a lot of the times. Well, guys, we didn't get a verdict in the first, hour and a half or so. Didn't expect we would. I'm not expecting one today. We'll see. We'll see. Oh, out of my tea. Sorry for slurping into the mic there. So now we wait. We wait. I doubt that I'll go live for the verdict because I'm probably not going to sit around on pins and needles and wait to see what happens. If I'm around when the verdict comes in, I'll watch it, but otherwise I'll probably just get the news and then catch it after the fact, like a lot of other people. I'm not going to say like everybody because many people may be sitting and watching and waiting for the verdict, but I had to lock the cats out of the room and they're probably going to need my attention now. This poor dog here is waiting for a little mommy to notice her. So I will not probably be sitting and watching and waiting for the verdict and going live when it happens. But I do still have a recap to put out week 2. Lot to look at for that. Suppose I've probably shown my hands as far as my read on the case and how things have gone so far already, but we'll break it down in a little bit more detail. Kind of take it a little bit more piecemeal in terms of what the state actually did in the second week and how the defense responded to it. And then I'll, depending on what the outcome is, may or may not do some kind of reaction to it. We'll just kind of have to see how that plays out. But I do appreciate all of you joining in to share your thoughts, take the poll, weigh in on what you think. It is kind of, it's less lonely to watch a trial with company, see how other people are feeling and thinking. And even if it isn't, in line with exactly what I think or anything like that, it's what the jury is going to be experiencing, so to be able to put myself in that position of having to kind of think things through a little bit more and appreciate other perspectives is something that I do value. So thank you all for being here. Thank you, mods. As always, you really do make this a fantastic chat. Really do appreciate it. everything that you do. It's been a bit of a long one today. So everyone who hung in there, really very grateful. Thank you so much, as always, for everything that you do. So with that, I'm going to go ahead and sign off. Fingers crossed. Hope we get justice, whatever that means to you. At the end of the day, might be too late for that. You know, I tend to have the view that with crimes like this, as soon as he walked in the door, the chance for justice was over. You know, there's never going to be real justice after something like that happens. So at least not on this planet, not in this world. Depending on what you believe, may or may not be an opportunity for that in some other time and place. But best we get is just this verdict, and we'll hope for justice, whatever that means. Love to hear from the jury if we get a chance, but just gonna have to see what we get, see how long it takes them, and so forth. In the meantime, I am going to keep an eye on Ian, our good friend Ian, because I want to know what Ian thinks about all this. Like, I'm dying, dying. I need to know, how is Ian taking this? So let's continue to keep that pressure on YouTube if we can. Try to get him reinstated so we can get his perspective on it. But I will stay in touch with him for sure, and hopefully they'll be able to get that sorted. So guys, checking out. Thank you all again. Appreciate you so much. Hey, always another trial to watch. So we'll do it again soon. Thank you so much, guys. I will see you next time.